besides this is obviously going to be this. If you want to know what really happened, you need to watch this. This is the only place you're going to get this type of interview or
I don't really know what this is, but I didn't do it. I'm innocent, Judge. I'm not guilty. I'm innocent.
We, the jury, being duly impaneled and sworn, find the defendant Matthew L. Moore not guilty of murder as he stands charged in count 1 of the indictment.
Good morning, everyone. How are we? Hope you're all well out there. It's been a long time. It's been a long time since I've seen most of you. How are we, beautiful people? I hope you're all well. I tell you what, it's been a nightmare this afternoon. I tried to go live just now and it wouldn't let me go live. I was like, wow, don't do this, you mofo, don't do this to me. It took like 30 seconds to go live. Then I got no notification. I don't even know. Am I even live? I don't even know if I'm live. Hello, everybody. Hello. There we are. And I forgot to do this, so I got tangles everywhere. Oh, do you know what? I'll get into it. Do you know what I did this morning? Oh, you'll never believe it. I'll get into it in a second. But hello to you all. Sassy, good morning to you, my darling. Hope you're well. Susie, hello to you as well. How are we doing? Larry's in the house. How are we doing, Lar? Have you tried that Scotch egg yet? The Scotch egg. I hope you tried it. How is it? Film it. Ruka from Chicago. How are we doing, Shrew? Hope you're well, my darling. Rhode Island lady. Hello to you, my darling. How are you? Oh, Susanna. It's Susanna. Oh, Susanna, day and night. How are you doing, my darling? Hope you're well. Hey, do you like my new t-shirt? El Chatty, do you like it? Everybody. Mary, quite contrary. How are we doing, my darling? Hope you're well. Good morning, everyone. Mary, there we go. Morning to lunch chat. Hope everyone's doing well. Very well, thank you. Hello, Vicky. How are you doing, my darling? Hope you're well as well. Julie, how are we doing? Hope you're well. Another LC. 2 LCs in the chat. Good morning, Dylan from Michigan. There we go, from Michigan, Jim Harbour country. How are we doing? Hope you're well. Beautifully appropriate. Hello, my darling. How are you? Hope you're well as well. Emma, how are you? Hope the haircut went well. Or the hairdressers, whichever one it was. This is intense intro, I know. Shout out to Mexi Taxi. I know. I don't remember what intro I did, but it's my normal intro. I need to change it up. I'll get Mexi to do another one. She's awesome. Shout out to Mexi. Hey, good morning to you, David from Merthyr. How are we doing? Had a nice recharge time ready. Hope you all had a nice recharge time ready for the next case. Yes. So I got some news for you today. And I'm not sure what people think about it. So let me go through chat quickly, then we'll go into it. Hello to you, Carol. Disney Queen, how are we doing, my darling? Rolling Stone, hello. How are you? Jerry, how are you? From Florida. Hey, Jerry, nice to see you, bud. Hope everything's well with you. Lane, good morning to you. Hope you're well, my darling. Or, sir, I always get these wrong. I don't know if it's male, female. I always go female because most of my viewers are females. Hello, Darcy. How are we doing? Lightning Leaf, hello to you. Still playing with your leads. Do you know what? I wasn't planning on it. Actually, I don't need headphones now, so I don't know why I'm playing with it. I forgot to fix them. But anyway, it doesn't matter. It's all good. Ruka, Lisa, hello to you. Another one from Michigan. 2 Michigan people today. There you go. Jody's in the house. Jody. Always confused with the other Jody. Lisa Reed, hello. Quizzical Girl. Good day, mate. Good day, Sheila. How are we, Quizzical Girl? Hope you're well. You are live. Fuck, that means I'm way behind then already. Right. No, I'm not too bad behind, actually. Good morning to you, Nikki. See, life is hell. Christine, hello, my darling. How are you? Joyce, good morning. Rhode Island. Love the shirt. Thank you. I got them in different colours, and I got the cheese and rice t-shirt came through as well. Cheese and rice. and I got a couple of hoodies that came through. So yeah, I'm happy. Hippie chick from Indiana, how we doing, my darling? I'm wearing the same shirt. I got mine over the weekend. Let's fucking go. Hippie chick, let's go. I hope they've all been delivered. Hope you're all happy with them. I'm happy with it. I am happy with it. I'll be honest. I think they're good. So it's good. Hey, Cousin Jill. Good morning to you, Cousin Jill. How are we doing, my darling? Always nice to see you. Very hot in Florida. Let me tell you, it's fucking hot in Wales. Nice shirt. Thank you, Elsie. I'm okay being for like a 2.5 hour walk down town. Not used to it. Do you know what? That's my story. Going for a walk. No worries at all, Elsie. Larry, will you get it? It's all good. Right, let's go. Karen, hello to you, my darling. Oh no, is that injection's not working? Fuck, I'm sorry to hear that, but inappropriate. Oh, Lou Barber, hello to you, you beautiful baby Archie as well. Hope he's well. Hope you're all well. How are we? So happy to be back here. I'm happy for everyone to be back here. I've got some changes for this week, so I hope everyone likes it. I'll get into it. Hello, darling. How you doing? Big D dog. Love it. Here you go. I love the fact that you all say good morning to each other. Got my t-shirt as well. It's great quality. Yeah, so it's better quality on the other side, I think. I think they're great quality. So, you know, I think they are. It's worth me paying the premium, I think. So, and they're cheaper. Do you know what I mean? For you guys. So, let's go, Carol. And I need to try the hoodies as well. But I got loads. Hang on, let me grab them. 2 seconds. Let me grab them. So I went for variety. So I got my white one, which is 3XL. So I'm a 2XL, but I always buy 3XL because normally they don't fit. Another one, my red one, my army cargo one, my this one. I got another one in that one there. This is the hoodie. I got 2 hoodies. Where the fuck's the other one? Oh, here it is. And blue as well. You might guess red and blue are my favorite colors. So, but anyway, dump it on the floor. Easy. And then same for my cheese and rice. I got one in blue and one in red. Yeah, 2XLs. So they're probably shrinking me, so I can't really, you know. But anyway, it doesn't matter. But anyway, they all come. I'm glad they're all being delivered. I think most of them have been delivered now. So shout out to all of you. Thank you so much. Right, hang on. Boo Boo, hello to you. How are you doing? Hope you're well. Great to catch you live. Happy days. Crafty Cow, good afternoon, Dylan. Hope you have recharged and ready to hit the ground running. So I'm like a Tesla. I'm not, but I'm like a Tesla. I'm not 100%, but I'm like 60. Do you know what I mean? Where I was at 0. So I'm on the way up. Moving on up, moving on down. Much better, very soft. Yes, I like it. I don't like Teespring though. I use because it's free for me. This one I have to pay £50. So it's a compromise on quality and stuff like that. And what's best for you guys, really. So as long as people buy it, I might keep it open. Toots, hello to you. Can't hang around, just swung by to say hello to you, Boo Boo. That's all good. It's all good. Come on, drop the link for the t-shirt so I can get one thing. No, I'll do it now, Rodi. I'll do it now. I'll do it. Hang on. Oh, do you know what? It's pinned at the top as well, by the way. The thing is pinned at the top for it, but I will find it now so I can put it in there. But again, if you do buy, make sure you buy from your own country. So I've done it so that you can buy either American, UK, Europe, Australia, Canada. You would think I know where I'm going. View store. Here we go. I got it. So yeah, hopefully that makes sense. You need to go to the actual, for you, America. So America store, USA store, go to that one. All the price you see is a price you pretty much pay. I think you have to pay bank transfer fees 1% or something, but the delivery tax, everything's in there. I've taken care of everything. I just try to make it as cheap as possible and as efficient as possible for everybody. And don't worry, if you do click on something wrong and you're from the UK, but you decide to buy something from America, I can decline it. It's all good and refund you, so it's all good. Chrissy, how are you doing, my darling? Hope you're well. Just moved lawn because it's going to be 1,000,000 degrees here. Right, I need to get into my story. Archie's having a snooze on me. Happy days, baby Archie. Love Archie. Quizzical red hoodie's nice. Thank you, my darling. Jill, hi, Dylan. Good to see you. Got my cuppa ready. Been weird not tuning in. Hello to you, Jill, over there in Newcastle upon Tyne. Hope you're well. Thank you very much. People tell me that, so that's why I do it. My favorite color is actually blue. Oh, right, hang on. Someone bought something from the store. Let me just authorize it. Thank you, Deborah. Let me just check that you did the right one. You did. Thank you so much, my darling. I appreciate you so much for this. Request. There you go. Done. It's been sent to print. Thank you, darling. Red's definitely, everyone says that. Red's my color. Blue is my favorite color, but everyone says red suits me better. So, yeah, people say that. I don't know why. Ban VAIA, love you much. Thank you very much, sir. Madam. Fuck, again, I don't know. Thank you. Hello. Raoul, hello. What does everyone think of the Paul O'Keefe public? I'm not even bothered with it, to be quite honest with you, Raoul. But yeah, I'm not. I'm trying to get into the whole thing. But yeah, there's some stuff I want to talk about with Karen, but another day, I think. There you go, done. Jodie, hello, my darling. How are you? Hope you're well as well. Good afternoon, Dawn. Not got my hoodie yet. It's on the way. It's definitely on the way because I know everything's on the way, Dawn. 100%. But yeah, it's definitely on the way. I can check it up though for you. Good morning, Sandy. Grick, Jem, how are you doing, Jem? Hope you're well, my darling. As well. There you go. Everyone's in here. Oh shit. Okay, I think I got. Oh, we missed you all as well. Honestly, I missed you all. So I'll get into what the plan is moving forward. I've got the cheese and rice in grey. Love it. It's soft and pink hoodie. My hubby said it looks great. There you go. Happy days. Florida Tim, hey you fella. How are you doing? It's nice to see. Do you know what? I can't watch it either. I can't. Yeah. Ex Animo. Good morning, everyone. Morning, Dylan. Hello to you, Ex Animo. How are we doing? Hope you're well. So I've had loads of messages over the weekend. I've had loads of stuff going on. Before getting to that, so yeah, I went out for a walk today. It's fucking boiling in Wales. Obviously not boiling comparing to US and stuff, but it's really hot. Do you know what I did? I went out for a walk about 3 miles. I forgot my water. And it was scorching. So obviously by the time I come back, a massive headache. I was like sweating. So this is my second full one now. I downed a pint, down another one of these, and now I'm on my second big one of these. So yeah, I'm trying to get rehydrated at the minute. So you have to bear with me. I might be pissing like a racehorse today to go to the toilet. But yeah, if you go out for a walk, people remember your water because that was a lesson today. By golly, was that tough. Luckily, I didn't walk so I'm trying to go back to do 5 miles a day. I failed today because obviously I forgot the water. Always take your water, people. It's dangerous if you don't. And as I say, I semi got a headache right now. So yeah, hippie chick. Julie says, hydrate. Absolutely. This is why, as I say, second one, I'm pissing like a racehorse though. So I mean, every time I drink, I'm rushing to the toilet. Water's good, yes. Absolutely. Chuck and everyone says about sizing. My daughter wears a medium. Other shirts pretty true to size. Love the cheese. So Eric, yeah, actually, so for me, Oh, fucking hell, I don't know. This is so I'm a comfortable 2x, and I would say this is it fits me. Do you know what I mean? 2x. So you know, and I'm usually 2x. So just it's not tight or anything. But I do think once you wash it, it might shrink a little bit. I don't know. 3x is way too big for me, and I want it to shrink, put it that way. Where normally 3x would fit me from stores. I'm not sure if that's helped you at all, Jodie, but hot year 2 walk with the dog, Charlie. There you go. I got a late. It's big, but I got a large, but it's big. But I figure it will shrink. This is my worry. I've not washed any yet, but I figure they're going to shrink as well on your walk. So we could go with it. It's the Wi-Fi. It's the 3G stuff, 4G, 5G, wherever. I probably drop signal. That's the only problem, Karen. But I've done a few before previously. I got a walking machine treadmill in my bedroom, so sometimes I go live on that one. Sometimes. But yeah, I live in a beautiful part of the country, so I should go live here, right? Yeah. Hi, Luby. How are we? Now you're back to your normal name. I know who you are now. YouTube got me hydrating all the time. I was watching T-Boy with his giant Stanley Cup. Made me get one. I ended up drinking every time he did. Great plan. Happy days. Would be fine for her. Good morning to Danielle. When you're in a dog or on a trail through the woods, you feel something is watching you. It's just a deer wondering if he's going to be chased by my pup. There you go, Florida Tim. There you go. I would, because they're probably going to shrink, aren't they? Good morning, Susan. How are you? All right, okay. Good morning, Helena. Oh, another order come through. Bear with me 2 seconds. Thank you, Christine. Hey, Chrissy. Thank you, my darling. I've just requested fulfillment and it's gone. You should get an email now. It's gone. Thank you, Chrissy. Right, hang on. Let's go. I got some news here. Let's go into some news. Hey, James, how are we doing? Sings a song about staying alive, like Sean. I've not watched this. I've not watched the stream yet. I've tried to keep away from YouTube. If I'm being honest. Staying alive. I don't know if he sang that or not, but staying alive. Quizzy girl, please go live in the country. In the country, it's the problem I got is signal. That's my biggest problem. Wash it in cold water, hand dry it. There you go. I normally do actually. Yes, afternoon for most of us. Hello to you. Yeah, most of them are out for delivery. Either out for delivery or they've been delivered. That's why I thought everyone had it. So mine came today, Lou. Literally all came. Some came. Oh, this is the other one that came last week. My El Chatty mug. I've got my El Chatty mug with cheese and rice at the back. So that's my other thing. I left to buy shit. No, he didn't. I just authorized it. So done. Okay. I could do photos of the country. Yes, definitely. I know. I want Boston first. I do need to do Florida as well. Yeah, I mean, the Paul stuff, I'm not really getting into it. I'll get into camera. So, my plans this week has changed. So we're going to be doing this today in a little bit. I'll get into it. So the plan today is we're going to be covering the ballerina murder trial, which is Ashley Benefield. You've done enough, Carol. You got enough stock. But yeah, cheese and rice. I saw you had 3 orders for whatever reason from different stores because I try to make everything US based, so like limiting the delivery charges. I love the cheese and rice. So this one is, I initially thought this was going to start on the 11th, okay? The Ashley Benefield trial. So, but it's actually starting on the 22nd, 2020, or around the 20th. So we commence on the 22nd. It might be jury selection on the 22nd. So we got 2 weeks before it starts. So I'm going to be playing today the stand your ground hearing that she put together. So this happened a year ago. She put in, there was a hearing about stand your ground. So she put in the defense that of stand your ground defense, which will become clear. I just want to explain it because obviously what's going on, what are we playing now? So for those that don't know, Ashley Benefield is a former ballet dancer. She's accused of murdering her husband, whose name is Douglas Benefield, who was a little bit older than she is. Detectives say Ashley went to the neighbour's house in September 2020, claiming Douglas attacked her, so she shot him. However, during the investigation, it was discovered Douglas most likely had his back to Ashley when he was shot. The couple reportedly got married 13 days after they met. So they're still new together. A lot of the details have come out in this. I think it's important to play this stand your ground hearing, which is an all-day hearing, by the way. It's going to be all day, so you might not be able to watch it all today. It's like an 8-hour video today. And then tomorrow morning, there's another hearing I want to play as well. It's probably about an hour and a half tomorrow. Florida. This is Florida, people, by the way. This is Florida, not Wisconsin. So it'll give you a good basis of why they're going the angle they're going with in the trial. Normally, I don't play stuff like this for hearings, but I think this is a super important part of it, which I watched this. Actually, this was live streamed exactly a year ago, 6th of July last year. So it'll be a good refresher for those that have seen it, and then obviously a refresher for people going into the trial. So that's what we're going to be doing here today. Hang on, there's a few more here. I'm just hearing about this case is new to me. There you go, Elsie. So bear with me. We'll probably start in the next 10-15 minutes. Okay, I just want to get some of the stuff out first, then we'll get into this. As I say, it's going to be about 8 hours today, and then I'll finish off tomorrow morning. So you'll have a good basis going into the trial on the 22nd, basically. So it's a little bit messed up, this trial is, because as I say, it was supposed to be done on the 11th, but now it's moved, I believe, to the 22nd, or we commence on the 22nd. They've not said when the trial actually starts, which is a pain in the ass. It's because of different depots they are. As long as as long as they're in America, I don't care, type of thing, you know. Different providers, I should say. Show me where I find the Australian order site. Luby, is it so? Right, Luby, it's in there. It's in there, my darling. Unless you got it. Victim's daughter on TT. Yeah, 13 days. This is what we're going to get into. You're going to get all the background today. You can make your minds up then. Thanks, Karen. Oops. Yes. James. Ooh, James is already on it. He's already on it, James. You know with this case, do you? Susie, thank you for the gifted membership, my darling. Thank you. I'm so excited about it. So am I. So am I. Hey, Sally, how are you and family? Hope you're well. And Susie, thank you so much for the gifted membership. If I didn't say it. I'm listening. I need a new case. So, yeah, this is one we're definitely diving into. There you go, Christine. There you go, Luby. Well, I'm trying to go into it with quite fresh eyes, but yeah. Hey, Murph, how you doing, my darling? Good morning, Denise. Getting my sweatshirt today. Happy days, Denise. Thank you so much. Oh my God, her name's so close. Do you know what? First of all, I get mixed up with them. Gilf, the Gilf is on fire. Lady Law, how are you doing, my darling? How are you doing? Hope you're well, my darling. Some call it Florida. Right. Hit the like button, people. Yes. Hello to you. When Proctor's hearing is through, I'm not sure they're going to be streaming that. There's something on today, isn't it? But I don't think they're streaming it. I'll keep an eye out on Twitter though. Live stream this week. Do you know what, Danielle? Probably it's hit and miss, Danielle. Hit and miss with Turtle Boy stuff. You just never know with it, if I'm being completely honest with you. And sometimes they play it after the fact. So I know the last one they played, they weren't allowed to record, even though a couple of people did record it. They weren't supposed to or something. I don't know. There was some drama about it. I don't know. But they're so iffy about whether they do it or not. So until the day happens, I don't think they know, Danielle. Top of the morning to you. Karen, how are you doing, my darling? Hope you're well. Right. The other part of this, right, is obviously now that this is moved to the 22nd, he's been demoted, yes, but he's got a hearing today. He's not attending the hearing. He's doing it through Zoom, is what I heard. Hello to you, Josie, my darling. Hope everyone's had a great weekend. There you go, Josie. Oops. One morning, one afternoon, yes. It's whether it's going to be televised or not. That's the question now. But right, get back to this for a second. So my plan is for this week now is we're covering this today. Tomorrow we're finishing them off, right? The hearings and stuff like that. Then I know I said I wasn't going to do it. I know I said I wasn't going to do it. Is it today? I don't know. I don't know if it's today at 2:00. To be quite honest, I'll keep an eye on Twitter though. And if it is live, we'll stream it. You know, I'll jump on and stream it. You know, as in I'll stop this and watch it. But I don't think it will be. Good morning, Mofo. Missing our mornings together. Hello, Margaret. How we doing, my darling? Hope you're well. Free can read. So my plan is to show this again tomorrow morning. I know I wasn't going to do it, but a lot of people asked me the Alec Baldwin trial. So the Alec Baldwin trial is starting today, hearing-wise, but it's officially started on Wednesday, and it's going to be finishing on next Friday, which fits in to this. So I'm confusing stuff now. So I'm thinking of streaming Alec Baldwin's trial because it starts at 11 o'clock Eastern. So there's time. And it means I can cover stuff in the mornings. I still do morning streams because I do want to talk a little bit more about Karen and the jury and stuff. I still want to talk a little bit more about some other cases and stuff for like an hour and a half, which I can do. And then, but I'll probably stream the Alec Baldwin one, but more of a not knowing much about it. As in, if this makes sense, if there's no interest in it, it doesn't bother me. I won't stream it. But if people want to watch it, as in, I'll probably do it I'll probably just join chat and do it. I don't know. Hang on. And all after pobydd Ceredigion Cymreig. Hey, Shwmai, ti'n iawn? Yeah. I love it. Yeah, no, exactly. There's peaceful protest today. 4 to 6. There you go. 4 to 6 then today. Okay, Eastern. There you go. No, he's going to do it online. Current ball, we keep us busy. Yeah. So if there's interest, you can watch it. If there's not many people interested, I'll probably still play it, but I probably won't be on screen for it. Did you know what I mean? If there's enough people here, I'll, do the usual, but I'll still play it and stuff. I know nothing about Baldwin trial. I know fuck all. I know nothing. I just know someone died, and someone, I think is Baldwin, that shot him. I know nothing about this case. And I wasn't going to cover it because it wasn't fitted into my schedule by the ballerina one, but now it does fit in, so it makes sense. But also, either this week or next week, I'm going on another channel. You might have heard of it. It's called Going Through the Motions, by a host called Sean McDonough. So we're going to be doing a morning crew on his channel, because Howie Carr has requested it. So we'll be doing, I believe, I don't think I'm spoiling it, but we're doing a show with him either this week or next week, just for a couple of hours, 8 till 10 Eastern. But the Alec Baldwin trial doesn't start at 11 o'clock Eastern. So I can fit stuff in between, if that makes sense. And then the Karen Reid stuff, I am covering all of that. And Sean's coming back on this channel on the 22nd for her hearing, or the whatever you call it. There's a lot going on. There's a lot of moving parts here. There's a lot of stuff going on. So I don't want to start another trial. That means I can't do the show with Sean, because he's asked. Sean never asked me to do anything. He's asked me if I can come on his channel to do the show for Howie. I'm like, absolutely. So by not doing another trial in the next 2 weeks, that conflicts with that. We're happy. And then doing the Alec Baldwin one, that should please people as well, because it keeps them busy and keeps me out of trouble as well. Well, hang on. No, it's not. Howie Carr won't be there, Jackie. Just to be clear, Howie Carr has requested, I believe, allegedly through Sean, Howie Carr wants another morning show, just me and Sean again, because he used to watch them. But we're going to do one on his channel. So Howie Carr will be watching, but he's not actually going to be there. I don't believe, anyway, unless he's ringing in or something. I have no idea. Okay. Hey, Keith, how we doing, fella? So, yeah, there's a... Hey, Potty Mouth. How we doing, Potty Mouth? Lovely to see you. Do you know what? The chat is a lot slower now, which is even better for me. You got too bonkers, but lovely to see you people. Hey, Kim, how we doing? It's gearing up, yes. So June next year, I believe, Elsie. We'll be covering it. Just like the Armour Girl did. Again, I don't know anything about it, so I couldn't tell you. So I'm going to go into it with the whole presumption of innocence. Do you know what I mean? I know nothing. Always drama. Hugo started something already, don't I? Yeah, I don't want to let him down. So I'll say it might be this week or it might be next week. I don't know when it's going to be. So yeah. Okay. I was listening to the UI guy Saturday night, and he said someone close to Can Reid camp said that there was going to be major breaking news today regarding the trial. Okay, we'll see. Not a Baldwin fan, neither am I. Do you know what? One of the reasons I want to play it is because the lawyers involved are excellent. They're excellent. So, hello, Emma. How are we doing? Hope you're well. I think it's the... Hang on, let me tell you. I think it's the 31st of July. I think. I don't know about that. But yeah, he loves Sean. He loves Sean in the mornings. When do you think KR 2.0 will take place? Late this year? I think it'll be early next year, I think. Early next year. Because if Jackson's going to be on there, Jackson needs to be ready, and he's got other clients and other trials all lined up. So a lot of it will depend on when he can do it as well. There you go. You see, I know her now. She's Luby. So, okay. Okay. So, does that make sense, though? So, tomorrow we're back in the morning show doing that, and then we'll start the Baldwin stuff tomorrow. I think there's jury selection tomorrow. There's a motion trial today or something, which we're missing, but who cares? It's fine. but the proper trial starts on Wednesday. But I will do something tomorrow. So we'll do Benefield, finish this off, and then do that afterwards. So if that makes sense. So yeah, I hope that makes sense. I don't know if it doesn't even make sense to me. I didn't even know any of this stuff until pretty much half an hour before it came online. But I hope it makes sense to everybody. And I hope if you want to join me, if there's enough people here watching, I'll do as I always do, give commentary in the breaks and stuff. But if there's not many people here, what I'll do is just leave it on. I'll join you in chat. Do you know what I mean? Wherever. So we'll figure out. Hey, she got it. El Chatty shirt, love it. My membership expired and I didn't renew it. Where's the link? I don't actually know. I just think you press it. I don't actually know, hippie chick, because my setup is totally different to all of yours. So I have no idea how. Actually, I don't actually know how to join. I think it's something. There's a $sign or something. You join through that. And I just see next year spring or maybe Morrissey's forced to drop charge. Foolish man. There you go. Where did yours go? Memberships, I think, if you gifted one, it lasts like 4 weeks, I think. Hey, happy days. What's Lisa Reed say? Did I miss what Lisa said? Oh, here we go. Sean done together made me laugh so much. Just a laugh makes me laugh. Fuck. My laugh is horrific. Horrific. I know. I cringe. The whole day I was floating down the river last week, I kept making sure there was no one causing a ruckus. Fucking hell, Heather. Makes sense to me. I'm watching with you. Happy days. Hoodie just come. Hey, the hoodie just came to. Happy days. Okay, so Josie says memberships need to be renewed from a YouTube browser. Can't do it on the app. There you go. I hope that makes sense to everybody. Oh, right, yeah, you can only do it on your PC. I think, or if you're on your phone, you have to go into Safari or Google or whatever and do it that way. Do it through the chat, but Apple, you have to do it on desktop from what I understand, yes. Country Girl UK, hello, afternoon, how are you? Hope you're well, my darling. There you go. I'm glad that, look at how everyone's helping each other out. You best laugh. Oh, I don't know about that. I can't watch myself. I can't watch myself. It's too much sometimes. Crumbs. Thank you, Lady Law. Try clicking the draw. There you go. Thank you, everybody. Love your laugh. Happy days. Lucy, hello to you, my darling. There you go. I hope you heard the plans. We're doing this today, Ashley Benefield today and tomorrow, and then start tomorrow afternoon or tomorrow whenever. Baldwin. And just a shout out as well, because I did shout him out. If you do want to know more about the pew and laws and stuff, Potentially Criminal is also streaming it. So he'll do more the legal analysis. I'm just going to be a juror because I know nothing about this case. So can't do it on your phone. Thank you, Carol. I don't know how either. Sadly, don't worry. I'm not even a member of my own channel. I don't know if I can be. I don't even have that option on my one. There you go. That's why. It's all good, though. Right. Are we ready? Should we just start? Yeah? Should we just start? Let's start. Let me put a timestamp in because Murph's turf's here, so I've got to put timestamps in now. If Murph's around, she gives me rows if I don't put timestamps in. So, 41. There we are. I'll just do it that way. It's close enough. Airfield. Stand your ground hearing from July. So this hearing, again, as a reminder, was done in 6th of July, 2023. So this isn't like, something new, but I wanted to play it because it's important before we get into trial. So, right. Okay. Boy, here's a ton of. There you go. And so you go. There's plenty of people to watch it, but you know what to do, people. Yeah, you know how I stream it. I don't stop and start and stuff like that. So go to Uncle, go to Sean, go whoever during breaks and stuff like that. But yeah, come here and watch it. Thanks, Lady Law. Let's get ready. Let's get ready. Let's get ready to rumble. Psych! Let's go. Right, let's get it on. Let's get it on. Let's get it on. Right, here we go. There. Need to find where I'm supposed to be. There you go. There I am. Murph loves his timestamps. Just love y'all. This is what I wanted, Carol. Do you know what? Also, it's important. I said this the other day. When we got the verdict watch, there was way too many people here, and I felt I missed out on a lot of you people. I didn't see you. Like Gary's not here today, but Miss Gary, Florida Tim, Potty Mouth was here. There's lots of people I didn't get to see. Now we're back. Oh, you all caught up with Zachariah. What do you think, Luby? What do you think with it? Hey Terry, how we doing? I know. Mini Golden Hood. Ah, there you go. Thank you, Hippie Chick, for becoming a member. Thank you, my darling. Appreciate you. Good morning, Miss Jessica. Jessica, let's get it on. Wes could do the trail together on this one. Well, Hippie Chick, yeah, you figured it out. Welcome back to the crew. Good morning. Hey, Saray, whatever will be, will be. Saray. Hello, Saray. How are you? Right, we started. Do you know what? I'm going to have to change a fucking timestamp now, aren't I? But has been in prison for 4 years. Yes. There you go. Thank you, Sally. Yeah, I will. I just needed to. I only found out this morning what I was going to be doing. I will do one. Right. If everyone's ready, are you ready? Let's get ready. Let's get ready to rumble. Right. Let me go out of that one then. Sure, I'm going to have to start looking into this new case because I know. So basically, Ashley Benefield is up for murder for shooting her husband. Her husband, Joni, there's no doubt she shot her husband. It's whether it's self-defense or not. That's the question. So, Joni, I promise you, a lot of your questions about this case will be covered in this hearing today. So the hearing is about standing ground hearing. A lot of your questions are going to be answered. You're going to get the basis of what happened in this hearing today. Lou, happy days. I'm glad it fits perfectly. Good. He's not 4. Thanks for clarifying. He said the judge right before he sentenced him. I don't know. Just found it so genuine. I did not do this, judge. I agree. Right. Everyone, let's get ready. Let me get timestamp. Oh, the timestamp's coming up to 45. We're going to go 3, 2, 1. Now, why are you going to play? There you go, there.
Field, the force used was reasonable. So to that end, as the court is aware, we established a prima facie case that the force used was justified. The state stipulated to that, and Your Honor signed an order so designating it. At that point, the burden shifts to the state to establish that the force used was not justified. That's what the statute says, and that's what the case law holds. The standard that state has to meet to do that is clear and convincing evidence. So that leads us to what I think is a very appropriate consideration, Judge White, which is what are the parameters of a motion such as a stand your ground motion? I would suggest to the court that was pretty well defined in the second DCA case of Bowie versus State. I'll give the court the site at 292 Southern 3rd, 471, and specifically page 483, second DCA case 2020. The court there pretty much stated that the inquiry for the court is to entertain any evidence which establishes that the force that was used was not justified, which means, Judge White, that any other inquiries are irrelevant, specifically motive. Motive, a lot of times at a trial, is not required. It's never an essential element, but when it is available, it's a very powerful tool for the state to present to a jury. Abuse allegations, also irrelevant, as is Ms. Benefield's psychological state. Why are they irrelevant? They're still, of course, subject to the rules of evidence, even if the court entertained them. But the question then is, why would they be irrelevant? And it's our position, Judge White, that they're irrelevant simply because they are not material to the stand your ground statute's requirements. As the court knows, the issue is, was Ms. Benefield in a place where she had a right to be? Was she involved in any criminal wrongdoing? And did she have an objectively reasonable fear of great bodily harm or death? So the case law supports exactly that. One of the benefits, Your Honor, of being in the Second Circuit is we have very well-defined case law on stand your ground. And I'll cite to the court two things in particular that should apply across the board to this hearing, respectfully. The first is in Riggins versus State, which is in our brief. It's at 344 Southern 3rd, 625, page 626. Also a second DCA case in 2022. Therein, the court held that the trial court, this is a quote, the trial court is to assume all facts as true. Secondly, I would cite to the court, also in our motion, the case of Jefferson versus State, 264 Southern 3rd, 1019, again, a second DCA case, 2018. Here's what the Jefferson court had to say in upholding the stand your ground motion and immunity filed by the defense. Quote, "We are mindful that there will be situations where the accused is the only available witness to the events leading to an act that is claimed to be justifiable use of force. This may result in great difficulty for the state to overcome the accused's prima facie claim by clear and convincing evidence. But our result here is mandated by the text of section 776.032, subsection 4, stand your ground." In closing, Judge White, I think that the state will be unable to demonstrate in any capacity, much less by clear and convincing evidence, that Ms. Benefield, knowing what she knew on the day of this incident about DB, which is the objective standard, Douglas Benefield, was not justified in using deadly force to prevent great bodily harm to herself or death. Thank you.
Thank you, sir. All right, State.
State calls Tommy Benefield.
Judge, I suppose now we're into our,
Okay, just to explain to those that are new coming in. So this is a hearing from last year. So the actual trial is going to be happening on the 22nd of July. So in a couple of weeks. This is a hearing that happened last year called Stand Your Ground hearing. Because this was the defense she was going with. She's accused of killing her husband. She doesn't deny that, but she's saying it's in self-defense. And this is a big part. A lot of your questions are going to be played in this standing ground hearing. It's an all-day hearing. You'll get a lot of it, and the other bits I'll play tomorrow morning before we get into Alec Baldwin. So just again, I'm covering Alec Baldwin as well after this one. So yes, this is from last year, just to give you all the questions you have about the case. I can guarantee you will answer in here. It'll tell you what happened, how they met, what she's accused of, everything. So should be good.
This motion
And you're talking about your omnibus motion?
Yes, sir.
Under, hold on one second.
I'm going to play it at 1.25 unless people say it's too fast, okay? Because I think 1.25 is fine. I can't play 1.5, Danielle. I can, but a lot of people, it's too fast for a lot of people. So, yeah. So let's try a 1.25. See what people think.
I'm looking through. Go ahead and put whatever it is on the record related to
Yes,
Tommy
sir.
Benefield.
Number two, yeah.
Number 2. All right.
I had lodged an objection to any Benefield family member testifying without personal knowledge of or participation in the events immediately preceding the alleged homicide. I then followed that up with a discussion about testimony by non-expert witnesses who lacked personal knowledge and cited the Florida Evidence Code. And I also included in the memorandum for Your Honor the following. As the court knows, in a homicide case, the accused has the absolute right to open the door or keep it closed as it relates to character evidence. Only the accused can inject character evidence, after which the state is permitted to rebut it. It is the same thing with a witness's testimony under 90-404, Your Honor. Mr. Benefield is limited. The state can establish that Douglas Benefield had a reputation for peacefulness once it's attacked. The rule is very clear. So it has yet to be attacked. Mr. Benefield can only testify as it relates to the rehabilitation of character by the state for peacefulness to his reputation in the community. Mr. Benefield did not live here in this community. He can only testify to his personal perception of his cousin's reputation for peacefulness, which the Florida Evidence Code does not allow. That's our objection, Your Honor, respectfully.
Thank you very much. State.
And Judge, the state does not intend to elicit testimony about reputation.
Okay. This is a great example of what I was saying when we were talking about the hearing is I heard your objection. I'm going to reserve on it because I don't know what these witnesses are going to say. I don't know quite where we're going. You guys know the case so much better than I do. So for now, I'm going to allow it and I'll reserve. At the end so keep making your objections. I'm going to reserve on those, at least this one.
Understood.
Some of them might be a more clear call, but we'll pour it all in the pot and see what we get.
Understood, Your Honor, and I might say I'm quite comfortable with the court proceeding that way. I have no doubt.
Thank you. But let me say this. Having sat on at both tables, you make every single objection as we go that you feel you need to make. But I understand completely you have just a general objection to all of that character evidence, the background. You want to focus on that particular day.
Yes.
Got it. Yes, ma'am. Okay, thank you.
Tommy Benefield.
Will stand right here, sir. Face the clerk. Raise your right hand.
Do you solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth?
I do. Swear.
Chair, stay about 12 inches from the microphone, please.
Hello, sir. Morning, Judge. My name is Judge White. I'm presiding over this hearing. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. You adjust up, down, left, right, wherever you're comfortable. If you just speak in a loud, clear voice, it'll pick everything up.
Yes, sir.
Good morning.
Good morning.
Let me just ask, can you see?
Again, Your Honor, it's being blocked a little bit by the photo.
If you need to readjust yourself or reposition, please feel free to do so. Yes, ma'am. I'm sorry.
Please state your name.
Tommy Douglas Benefield Jr.,
How do you spell your names?
TOMMIEDOUGLAS BENEFIELD Jr.
And what was your relationship to the
Motherfucker.
deceased Doug Benefield?
First cousins.
And how close were you?
We were close our entire lives, and I was instrumental in him going into the Navy when I was in the Navy. Both naval officers, both flying off aircraft carriers, both did other work for the government, and then all the way through his business career and his dual career in the government and in private, probably talked weekly to monthly, depending upon the times of our lives.
Okay.
I visited his family multiple times in Charleston.
And let me just ask,
yes, ma'am.
before he died, where did he live?
Well, he was in an apartment down here at the very end.
But before he moved to Florida, where did he live?
Charleston, South Carolina, 701 Preservation Place.
And where do you live now?
I split time between Jacksonville, Florida, and Atlanta, Georgia. My wife and I have a spa business in Atlanta, Georgia, and I work 2 weeks a month in Honolulu, Hawaii.
And what is your job?
I'm a flight instructor for Hawaiian Airlines, teaching pilots in a particular airplane.
So let me ask you a little bit about Doug. At the time that he was murdered, how old was he?
He was just 1 week short of 59. He's born October 5th, 1961.
And how tall was Doug?
5'9", 5'10".
How much did he weigh?
I'd say 160 to 170.
And you already said before he moved to Florida, he lived near Charleston, South Carolina?
In Mount Pleasant, a suburb on the north side of the river.
Okay. And just before he moved down here to Florida, who did he live with in the house?
Just Eva and himself, except for the time that Ashley was living there previously.
So you said Eva. Who's Eva?
Eva is his biological daughter, first daughter, with his longtime wife, Renee.
And how old was Eva at around this time?
15, I believe.
So a teenager.
Yes, ma'am.
When did you first meet Ashley?
I had an overnight. I was flying for Southwest Airlines, had a change in a schedule. They sent me to Charleston, just me, not the rest of the crew, to take a plane into Charleston. And I texted Doug and said, hey, I'm going to be in Charleston tonight. Let's go to dinner. He texted back, great. April 14th, 2017 was the date.
You seem to remember dates well.
I have a very good memory, ma'am.
Okay. So you remember the exact date was April 14th?
Yes, ma'am. And I keep a diary and a flight log, so I know exactly when it was.
Okay. So did you in fact meet up with Doug?
Yes. When I got into Charleston, ahead of the hotel, I texted Doug again, and he said, Ashley's not feeling well. Could you take Uber up to Mount Pleasant to the house?
Overruled.
Did you know who Ashley was?
I had never heard of Ashley at that time.
Okay. So he spoke it like you knew who she was?
Yes, ma'am.
Did you take an Uber to their house?
Yes, ma'am.
Once you got to the house, did you meet Doug
I met Doug and Ashley together.
and Ashley? Was that the first time you'd ever met the defendant?
Yes, ma'am.
Did you speak with both of them together about their relationship and how they met? I'm assuming you were basically like, who are you?
We spent 4 hours together.
Okay.
We started at the house. I got her short life story, their life story together at that time.
So their life story together at that time, did they say how long they had known each other before they got married?
Yes, ma'am. It was almost a sense of pride for both of them that they had only known each other 13 days.
And how old was Ashley at the time?
At that time, Doug was 54 and she was 24, I believe.
So a 30-year difference
Yes, ma'am.
between them. And I think you already answered this earlier, but did Eva live in the house with the two of them?
Yes, she did.
Did the defendant ever mention that she had a job?
No, ma'am. It was only past history stuff and what she was doing temporarily in the 2016 timeframe.
Was she interested in the ballet?
Yes, ma'am. She was a former ballet dancer. And by this time, they talked about the American National Ballet they had founded in February.
So let me stop you
Yes,
there.
ma'am.
So was Doug interested in the ballet?
The way a husband is, proud of his wife, supportive, knew nothing about the ballet except its existence, I think, prior to that.
And prior to this meeting with Ashley and all this, had he ever expressed any interest in the ballet?
No, ma'am.
Okay. So you mentioned February. So they started a ballet in February?
So there's an old ballet that was defunct called the American National Ballet. When Ashley wanted to start a ballet and make this a special ballet, a diverse, non-judgmental, non-stereotyping ballet, Doug found a name and found an old ballet, and that's, I believe, February 27th of 2017 is when they founded it on paper.
So a couple of months
I'm
before
sorry,
you met.
Suzanne. Continuing relevancy objection. I don't want to keep.
Understood.
So you mentioned that was February of 17. So that was roughly 2 months
Yes, ma'am.
before you met Ashley. And how was the ballet being paid for? Did they discuss that with you?
Doug did. They both did.
Okay.
Uh,
Ashley did as well.
she talked about it.
Yes.
She understood what Doug was having to do to raise money and to put money personally into it. Doug was very, very good in all his businesses about doing the founding paperwork and establishing an LLC. And he had done the same with the ballet. He had built the website, just typical of Doug to build it all himself from scratch.
And you said he put his money into it.
I know he put his money all the way till he ran out.
And then did he also have other money?
There were investors, including his business partners and other donors through the process. Yes, ma'am.
Okay. So it was actually formed in February of 17, but was there a formal launch of the ballet?
So the night I spent with them, they talked about the upcoming events. There was an informal launch in May. There was a formal big donor party that I was a part of, brought all my business partners, a lot of veterans that I work with, to a McKee House event in August, I believe 12th of 2017. So that's the ballet that I learned when the event was coming out, and planned on being there and bringing all my people.
During this time, 2017, at some point, did Ashley and Doug decide that they were going to have a child or try to have a child?
That wasn't a part of that first meeting night.
Right.
We talked about everything else and caught up on everything that we hadn't known. But it wasn't a part of that night. We ended up leaving the house, going back to my hotel, having dinner together. I'm a master trainer in a medical device. It's a pain relief device. It's helped her, helped him. And then they headed back home that evening, but there wasn't any talk that evening about having a child.
Was there talk later on, specifically with the defendant, about the child?
Certainly. Vasectomy reversal is a very intrusive surgery for men. And when they made the decision they were going to do that, he and I talked about it at the time, in particular because of my medical device background, that could help him.
So they decided as a couple that they were going to have this vasectomy reversal to try and have a child?
Yes, ma'am.
Okay. And did the defendant, in fact, get pregnant that year?
He had the vasectomy reversal, and 3 months later, she got pregnant, I believe, because we talked about it later, that the conception date was July 10th of 2017.
And at some point, shortly after that, did she move away from their home in South Carolina?
Yeah, so August 12th is when we had the McKee House event, the big donor event, introducing the other members of the staff of the ballet and everyone involved. Ashley and her mother, Alicia, were there. I was there. And 2 weeks later, I believe on the 26th or 27th, they made the decision together that it would be better for her because of her morning sickness to go live with her mother, because Doug traveled for work and was busy. And that was what was presented to me by both of them.
And her mother lived in?
Lakewood Village here in the Sarasota Bradenton area.
In Florida. Okay.
Yes, ma'am.
And so shortly after that, did Ashley move?
I believe on the 27th of August, because Doug called me both on the way down and the way back.
Did he help her move?
Oh, yes, ma'am.
Did he move with her?
No, ma'am.
He stayed in South Carolina?
Yes, ma'am.
So that was August of 17.
Yes, ma'am.
Did the ballet eventually go under? And when?
So the ballet opening, the actual launch to the public, was September 18th of 2017. That's a landmark date in this case in my history, because it's the date Ashley and her mother went back in the house and got her stuff, and she filed against him.
Okay, we're not
I'm
going to talk
sorry.
about all of that.
I'm sorry.
So shortly after this whole time, we're going to skip ahead, did the ballet eventually collapse completely?
Yes, ma'am. I'll answer it more directly. I apologize. So they launched it publicly on September 18th. The biggest performing arts center in Charleston is called the Gaillard Center, Big Performing Arts Center. And they actually had an opening performance on December 7th of 2017. And the dancers had been paid through December 15th. And by the end of the month, everything was finished.
Okay. So by the end of December 2017,
Everything's done.
it was defunct.
Yes, ma'am.
During the time that you encountered Doug and Ashley together and talking to Doug, how did he act about Ashley?
He was completely in love, completely supportive, starstruck, visibly, physically. You could tell by the way he treated her, took care of her on the opening night that I met him, met her, and then it continued through the entire relationship until I never saw them together after the separation.
Okay. And when was that?
Well, physically, August 27th of 2017, when you drove her down.
So you never saw them together after that you can remember?
Well, I'll leave a caveat on that. I spent a weekend down here with Doug, Ashley, her mother, spent one night in the home where Doug was killed or murdered. And I don't remember that date. It could have been after the separation, probably was, but I just don't remember that date. But that would have been the only time that I saw them together after that August 27th period.
Thank you. I have no other questions. The defense will probably have some questions. Thank you.
Cross?
Thank you, Judge.
And let me just say, I completely understand that based on my evidentiary ruling so far, how do I say this? I know you probably wouldn't have asked a bunch of questions, but certainly for your cross-examination, any proffers of cross, I understand it's going to be broader than what it might have been.
Maybe not.
All right, maybe not. And please, sir, feel free you can question from either podium, wherever you feel more comfortable.
Thank you. Good morning, Mr. Benefield. I'm Neil Taylor. I'm appearing on behalf of Ashley Benefield. I regret that I meet you under these circumstances.
I understand, Mr. Taylor. Thank you.
You were a pilot.
Yes, sir, still am.
And consistent with being a pilot and listening to you and your detailing of events and dates and times, it's pretty stereotypical of the discipline that a pilot generally brings to their profession. Would you agree?
Yes, sir. You want the best people up front that work like I do.
All right. And you've told us that as a first cousin, you were very close with Doug Benefield.
Yes, sir. I was closer with Doug in our adult lives than my own brother, who was still alive at that time.
All right. Now, Doug was not a pilot.
Yes, sir, he was.
A commercial pilot?
No, sir, a Navy pilot.
Okay. Not a aviator, not like the second seat, but the actual pilot?
So in a multi-crew plane that he flew, the S-3 Viking.
Yes, sir.
He started out as a naval flight officer out of training, and then he became a second in command, which is like the first officer in the airline world, actually at the controls. And that's how he finished his flying career in that airplane. So he flew the plane, he flew in the front of the plane, and not always in that position.
Okay. Now, being as close as you were to him, you were aware, were you not, that he was an accomplished, among other things, martial artist?
I never saw that personally.
Were you aware of it?
I knew that he was a wrestler in high school.
Actually, he was on the judo team in high school, was he not?
Well, he was a state all-star wrestler, which is I'm very aware of, but I was not aware of the martial arts being a part of it.
So as close as you were, he never spoke to you about his accomplishments on the high school judo team?
No, sir, more about the wrestling.
Or his training in the military for martial arts?
He had the same training. The military doesn't train in martial arts.
Did he confide in you the training that he went through once he left the service through the private sector in conjunction with servicemen, both active and
Not,
retired?
not specifically, because we don't talk about that stuff if we're in really special programs.
Okay. Tell us about the physical condition Doug Benefield was in. He was built pretty well, was he not?
He was in terrible condition the night I met Ashley. He was in pain from his ejection from an airplane in the Navy that led to back surgery that year in 2017. He was not in good condition at that time. He became in good condition after he bought the device that I am a master trainer in, and it brought him back to health. He was in very good condition when he was regularly going to the CrossFit. I'm sorry, I don't mean CrossFit. Some fitness facility called Iron Tribe, which is a Christian-based workout facility. And I believe the last pictures of him on Facebook are in that gym. He was in very good shape at the end.
You saw the pictures?
Yes, sir, I've seen the pictures.
Okay. And they accurately depict the shape that he was in at the time of his demise?
Yes, sir.
Now, you've told us that he was, I think the words that you used, Mr. Benefield, was starstruck with my client, Miss Benefield.
Yes, sir, I would say that.
You're married?
Yes, sir.
Happily so?
Very happy.
How many years?
Just over 4.
All right. Do you own a weapon, a firearm?
Objection, relevance.
I'll overrule.
I own firearms, but I do not have a concealed carry permit like they did.
All right. And you're familiar with firearms from your time in the Navy, I trust?
Less from the Navy than after.
Okay. Have you ever fired a firearm inside your home? Intentionally?
Not intentionally or unintentionally.
Did your cousin Doug ever tell you that he admitted to firing?
Objection, Judge. This is part of what we were not going to get into.
So the objection is relevance?
The objection is relevance, and that there were certain complaints that this defendant made against the victim that were denied by Judge Morlan in a hearing, and this is one of those.
Okay. So is there a written agreement not to get into this, and that written agreement delineates everything?
No,
or
but
is this...
I thought we were not going to get into the specifics about it, other than it was shooting into the ceiling.
Well, I intend to stay within the 4 corners of my motion, but I think it's a fair cross-examination based on what he's testified to, his intimate knowledge of Douglas Benefield.
Okay. I don't know. I don't know what the agreement was to get into or not get into. I don't know what the relevance of this is going to be. It may be relevant. It may not. But again, I don't have to unring a bell with the jury here. So for now, I'll allow it. I may decide later it's completely irrelevant. I don't know.
Understood. May I?
Yes.
Have you ever fired a firearm inside your home intentionally?
No, sir.
Have you ever considered firing a firearm inside your home intentionally to intimidate your wife?
Objection, relevance of this question.
Hold on. Let the question finish. Go ahead. But, sir, hold on. There's going to be an objection.
Yes, sir.
Go ahead and finish your question.
To intimidate your wife into not speaking any further.
Go
And
ahead.
what is the relevance of whether he
I just need objection, relevance, sustained.
Did your cousin ever share that with you?
My
Objection,
cousin,
hearsay.
Overruled.
my cousin admitted both privately.
Is the answer yes?
I would like to answer your question and be very accurate, sir, like I've been all along.
I understand. However, Mr. Benefield, this is
Yes, sir.
cross-examination.
Yes, sir. He inadvertently fired a gun in his home.
No, he testified under oath that he intentionally fired.
Objection, is there a question?
Improper impeachment. Go ahead, sir.
Did
Sustained.
he ever acknowledge to you that he intentionally fired the
No, sir, he did not.
Did he ever tell you that he threw a loaded gun at Miss Benefield?
Perhaps we talked about that. I don't remember that specific event like I remember the inadvertent firing.
Did he ever acknowledge to you that he punched the dog in the face so hard that it rendered the dog unconscious?
That's not what happened in his story to me.
Were you there?
No, sir. You asked me if I talked to him.
Did he ever acknowledge to you that he punched the dog in the face so hard that it knocked the dog out?
He admitted hurting the dog, but that's not a detail I remember.
Is the answer to my question no or yes?
Would you restate the question, please?
Did he ever admit to you punching the dog in the face so hard that it knocked the dog unconscious?
No, sir.
Did he ever tell you that he regularly carried a loaded firearm?
Of course.
All right. And to be clear, it was a firearm that was also cocked. All that was necessary was to pull the trigger.
I don't remember that detail, but I'm sure that he carried it appropriately or he wouldn't have carried it.
Okay. You don't know whether he carried it wrapped or not?
No, sir.
Did he acknowledge to you that he placed a tracker on Miss Benefield's car?
No, sir.
Did he acknowledge to you that he was caught at night by a neighbor peering into
Objection,
Miss?
Judge. Counsel is testifying just to find out if this witness has the information.
Correct.
If he
So-
wants to call a witness, fine.
Your Honor, he's testified.
Hold on. The way cross-examination works.
Yes, sir.
Is that the attorney is allowed to ask his question.
Yes, sir.
Generally, it's going to be yes or no. If you can agree with it, you agree with it, and then you agree with it in total,
Or not.
or no.
Yes, sir.
And if it's a question about, do you know, you know or you don't.
Yes, sir.
And State, I understand what you're saying on the counsel's testifying. That's another issue. Obviously, if there was a jury here and so forth. With me, I'm not going to be influenced by the question. The witness can say, yes, that's true, or no, it's not. I know that. I don't know that. So go ahead.
Thank you, Judge. Did he admit to you and acknowledge that he was caught by a neighbor of Miss Benefield's at night, standing in the neighbor's yard, peering into Miss Benefield's window?
I don't remember that from him.
Is that something that you think you'd recall?
Yes, sir.
Is that something that you would expect of the Douglas Benefield that you knew as well as you did?
It's a possibility, not a regular habit of his.
Did he acknowledge to you, Mr. Benefield, punching holes in the drywall of their home out of anger?
I'm aware of one, not many.
And finally, did he acknowledge to you beating up his first wife, Renee, on their honeymoon?
I'm not aware of that.
When he lived here in Bradenton, Mr. Benefield, I want to be clear about something. At no time, to your knowledge, did he live in the same residence as Miss Benefield.
I know that they were on the lease together in the final apartment, but I don't know if they ever were in the apartment together, but they were on the lease together.
Okay, so my question to you is, did he reside in a separate apartment here in Bradenton?
He had an apartment in Bradenton. Yes, sir.
I don't believe I have anything further.
Yes, sir. Redirect.
Your Honor, give me one moment.
Yes, I was going to say, if you need a moment, go ahead and do that. Hold on.
AP 22nd of July, 22nd of this month, but I'm not sure if it's 22nd and for jury selection or if it starts on 22nd, but it's planned to start on the 22nd. Hello, Warriors, ma'am.
1 second.
I think he is good, Lil G. For what I've seen so far, I think he's good.
Your Honor, something for the court to consider at a later time. If the court would take a look at 90-806 of the Florida Evidence Code regarding hearsay, it states that once hearsay has been admitted and allowed by the court, the opposing party is entitled to move into evidence any testimony of the witness referred to, the non-testifying party, that exists. So in other words, during the state's examination of Mr. Benefield, wherein hearsay statements were allowed, the defense is entitled under 806 to move into evidence the entire statements of any prior statements made by Mr. Benefield, the deceased. If the court would take a look at that rule, I'll address it later on.
Okay, so the doctrine of completeness? The doctrine of completeness?
Yeah.
For that particular, each particular statement?
It's actually separate from the doctrine of completeness, but pretty much the same thing. It basically says when hearsay is allowed, the hearsay statement in any capacity or any statement of the non-testifying witness may be admitted into evidence by the adverse side.
I guess it'll just depend on what the statement is and when it was made and the relevance and sure.
Yes, I'll address it with the court at a later.
Okay. Yes, ma'am, redirect.
Just for the record, Judge, I completely disagree that that's what 9806 says. And in my direct examination of Mr. Benefield, I was very specific to only get Ashley's comments, not Doug Benefield's comments with reference to hearsay. So just that would be my response to that. So the defense asked you about this punching a dog issue.
Yes, sir.
And,
Yes, ma'am.
and you said that's not the story I got. What was the story you got?
The story I got was that Doug was sitting on one of his chairs with an ottoman. He always wore short shorts, bare-legged sandals, just like the night he was killed. And the dog jumped up in his lap because the dog was I picked up the dog after his killing, so I'm very familiar with Sully. Big dog, big nails, jumped up in his lap, and he was frustrated, and it hurt. Aggressively pushed is what he told me.
Okay.
He admitted that was more than he wanted to do to the dog, but it was due to his frustration at the time. He pushed the dog off of his lap because it was cutting into his legs.
So at no time did he say he punched a dog?
No, ma'am.
At no time did he say that the dog went unconscious?
No, ma'am.
And the defense asked you if you were aware if Doug told you that he put a tracker on the defendant's car. Were you aware of that?
No, ma'am.
Okay. The defense also asked if you knew about Doug punching a hole in the wall.
I knew about one punch.
And what was the reason for that punch?
Frustration.
The defense asked you if Doug regularly carried a firearm. Did Ashley regularly carry a firearm?
Even the first night she met him in front of Secret Service in the area. Yes, ma'am.
So did she have a concealed weapons permit?
I understand she does.
And did Doug have a concealed weapons?
Yes, ma'am.
No further questions.
All right. Did you have any further questions before we let this witness go?
Yes, one. Mr. Benefield, where did you obtain the explanation about what happened to Sully by your cousin?
Both from Ashley and Doug.
Your Honor, now, again, I would direct the court's attention to 806. And briefly, if I may, Your Honor, I'll read to the court why I believe it's appropriate. Attacking and supporting credibility of declarant. When a hearsay statement has been admitted in evidence, credibility of the declarant may be attacked, and if attacked, may be supported by any evidence that would be admissible for those purposes if the declarant had testified as a witness. Evidence of a statement or conduct by the declarant at any time inconsistent with the declarant's hearsay statement is admissible, regardless of whether or not the declarant has been afforded an opportunity to deny or explain. Okay, so I think any statement inconsistent with this witness's repetition of a hearsay statement by Douglas Benefield is admissible. And I would suggest that the exhibits to our stand your ground motion clearly apply to that.
I don't know which exhibits we're talking
I
about.
don't either. And Judge, I would argue that the only person that elicited hearsay was defense counsel. So defense counsel cannot elicit hearsay and then try to impeach the hearsay that he elicited. So I would object and disagree with that.
Yeah, I don't know what are we?
Judge, Your Honor may recall that during the direct examination by Ms. O'Donnell, Mr. Benefield related conversations that took place with the deceased, Douglas Benefield. And specifically, there was a hearsay objection. The court overruled it and allowed it. That opens the door to 806, Your Honor.
Right, I didn't hear argument on it. Which specific statement was it?
I believe, among other things, Mr. Benefield testified to everything relating to the ballet. I believe he testified to statements about how enamored Douglas Benefield, the deceased, was with Ashley Benefield. Those hearsay statements alone, Your Honor, open the door to 806 so that any statement by Douglas Benefield that is inconsistent with that testimony is admissible.
I don't remember any statements where, you know what, this would probably be better. So we're talking about your testimony.
It's okay.
I'm going to excuse you to the
Yes, sir.
hallway.
No worries.
The rule of sequestration has been invoked.
Yes, sir.
That's a rule here in the state of Florida, probably other places too. That says once you're called as a witness, your son is as a witness, you're not to discuss your testimony, the questions asked, the answers given with anyone at all until you're released from your subpoena or the hearing or the proceeding is concluded.
Yes, sir.
So that rule has been invoked. So when you're outside, you can't talk to anybody.
Yes, sir. I understand the rule and I'll follow it.
All right. Thank you, sir.
Yes, sir.
We'll call you back in as soon as we can.
Yes, sir.
All right, the witness has stepped out. On that particular point, I got some pretty decent notes and I was listening. My notes are not that he said that, just that he observed that Mr. Benefield was starstruck. I mean, nobody clarified, how do you know that? Did he say it? Was it your observations? So I don't think that's necessarily a statement. What other statement in particular? There was one I overruled. I didn't see it as being offered for the truth of the matter asserted, so I didn't see it as hearsay.
Sure.
I know there was one of those.
My objection was on the basis of hearsay. The court allowed it. And I think if you will, the danger of 806 and why it can be a two-edged sword is that it does not restrict the subsequent admission to anything relevant to the hearsay statement that is allowed. It rather sets up the credibility issue. And once a hearsay statement is allowed into evidence, then any other statement that the declarant made that is not available is admissible if the credibility of the declarant is being attacked. So, for example, on cross-examination, I question the witness about these violent acts by the deceased. Some he acknowledges were told to him, some he denies were told to him. If I have an admission, even though it's in a hearsay statement, if I have an admission by the declarant, it is at that point admissible according to 806 in evidence. It doesn't make a difference that the hearsay statement, Judge White, is related to the hearsay that the court admits.
So you're saying if one hearsay statement is let in, whether, and let me also say, somebody might object to hearsay. Overruled doesn't tell you if I overruled because I don't see it as hearsay. It was a statement, but it wasn't offered for the truth. Could be that I went through the catalog of exceptions and found as one of those. So I wouldn't read too much into overruling a hearsay objection.
Sure, and I understand.
And 806, familiar with it, and it's when a hearsay statement is put before the trier of fact or into evidence, that the hearsay declarant's credibility can be attacked or supported as allowed by the rules. I don't think it kicks open the door to any possible hearsay statement the declarant ever made on any topic at all.
Respectfully, if it goes to the declarant's credibility, I would say it does. And I think that the statute and the case law will support that because, again, it's not tied to the relevance.
I didn't say credibility. I said any hearsay statement. That's what I'm hearing, that we can bring in any hearsay statement.
To the extent it supports an attack on the credibility. Yes, sir. Yes, sir.
That I don't disagree with. A hearsay declarant's credibility can always be attacked or supported pursuant to the rules.
Right. So it's our position then that any hearsay statement that supports or attack on the credibility of the declarant is admissible. And specifically in our motion, we have several of them and we appended them as exhibits. So I think that they are now admissible by virtue of 806.
I'm still not sure exactly which ones you're talking about, but state.
And Judge, I'm confused because at the base of it, the defense elicited the hearsay, and then he's trying to bring in hearsay to impeach from the hearsay statement that he brought in. I don't understand this, but 806 says that once a hearsay statement comes in, the other evidence can come in, which would have been used had the person testified. So I think we're still bound by the rules of what can come in. Just because someone may be impeached on one statement doesn't mean every hearsay statement they've ever said comes in. That's different than credibility. So to be honest, Judge, I'm a little confused.
I am too. And let me make sure I understand. You had mentioned something, and I didn't want to get into it too much. The witness was here. And I think this was also mentioned, Mr. Taylor, I think this was also mentioned in the defendant's motion in limine, that there were some discussions about certain evidence not being relevant, and you were to just talk about very surface level things. But it seems like we got, instead of a scalpel, sounds like we got a shovel out. We're going to start digging some holes.
Point well taken, Your Honor. Actually, the discussion was limited to the allegations of abuse. That is to say, both Suzanne and I felt, rather than going down the rabbit hole of litigating whether or not the allegations of child abuse against the daughter were true or not, we would not go there.
So the agreement was limited only to allegations of child abuse.
Yes, sir. And truthfully, we never executed an agreement, but that was a professional discussion that we had, and I'm confident that Suzanne will acknowledge that.
All right, State.
We did have that conversation about the child abuse allegations. I do not remember specifically excluding anything before the child abuse allegations. And if there was a miscommunication, I apologize, but I had assumed that that would be a part of the let's not go down rabbit holes, because the issues that have just come up have already been litigated and have already been ruled on by another judge. So I was under the impression we were not going to get into those that happened in South Carolina.
Yeah, again, I don't know as a part of the agreement. I can say this. So there's two general ways a hearing like this can go. And I'm talking very, very broad strokes. One is how I thought we had agreed to do this was that pretty much we're going to let stuff in and object as we go, and then I'll decide the relevance or if things are relevant or not relevant. And I understand that that means a lot of things come in that might not normally come in, and those things may be relevant or not relevant. So I'm going to listen and hear a lot more testimony and see a lot more evidence than I might not normally, but it's to allow you guys to just put on your cases. The other way is we take a step back from that, and I will grant or overrule objections as we go. I personally think that'll take a lot longer, but it'll also limit how much evidence is put into the record, and we can do it that way too. My rulings so far, I would think both of you would agree, have been very generous towards admissibility, because that's what I thought we agreed on. So, but if that approach is then going to be, well, Katie barred the doors, here it all comes, and we're going to spend tons of time. We're going to stop here. We're going to get off the bus, and we're going to spend a day looking around over here. Then we're going to get back on the bus. We're going to go a little way down. We're going to get off the bus. We're going to look all around here. I'm not doing this so I can have hours upon hours of testimony about somebody shooting a gun in a house, punching a dog, putting a tracker on a car, peering into a window, punching a hole in drywall, and alleged domestic violence in a prior marriage. I'm not going to hear hours and hours of testimony. So I need to know. I'll start with the state, start with the defense. Are we going to do the plan that we originally laid out, which is, hey, put your stuff in, right? And then I'll figure it out as we go. Or am I going to throttle this down and I'm going to start listening to more objections? Not that I haven't been listening, but take more of the approach of, no, we're not letting irrelevant stuff in. We're not going to have hearsay. State.
Judge, I would not want to continue with everything that we're doing now. I don't necessarily think that we need to completely curtail it, but I do think that some of it needs to be throttled down. If there's an objection, I think that you should rule on it appropriately.
All right, so that's a mix. All right.
So I take that to be the former position, which I agree with. I am quite comfortable. There's no jury here. I am quite comfortable with the court parsing the evidence when the time comes for the court to rule and author an appropriate order. And that was why I said I'll address it later. I wanted to make my point and move on. And I'm satisfied if we continue to go that way.
All right.
It's going to be consistent with time savings and efficiency.
But it hasn't so far because we're spending a lot of time having this discussion now.
Yes.
So it hasn't been the time savings that I had planned. So I guess my question is, I don't know what statements you want to get in. I don't know what evidence that you want to get in that you're arguing comes in under 806, which, if I'm understanding your arguments, I don't think I read as expansively as you do. I think a hearsay declarant's credibility can be attacked or supported, if attacked, as if the hearsay declarant had testified, but that's still within the bounds of the Florida Evidence Code. I don't think it kicks open the door for every hearsay statement that has ever been made. But the second DC will tell me if I'm right or wrong. So let's call the witness back and we'll see if we're on the same page and we can go from there.
I believe we were at the end of defense cross, or I was at the end of my redirect where you can, I don't know if we need the witness back.
I would tell you this.
Agreed.
There was recross. The question was, how did you hear about Sully? And did you hear about it from Mr. Benefield or Miss Benefield? The answer was, I heard from them both.
So
now,
defense problem.
I'll just say, I don't know where this is going. I don't know how much you plan to get into defense. I've read, this is not the entire pile of what you sent me, but this plus everything else you sent, I've read it. I understand, well, the portions of the depositions, I didn't get entire depositions. I've read it. I mean, I understand that what he said about that, the incident with the dog. I understand what she's saying about the dog. I just don't know how far we're going to go down that hole.
I hear you, Judge. We're finished with Mr. Benefield.
Okay. I don't want to curtail you. If you have any questions, I want you to ask your questions.
I understand. I appreciate it. We're on the same page.
All right. So Mr. Benefield is done.
Yes.
Okay.
And he can be released.
That's my next question. After each witness, I will ask, can the witness be released from their subpoena? So, state?
Yes.
Yes, sir.
All right. So we're going to call the next witness, and can you let Mr. Benefield know that he is released from his subpoena? And who's your next witness?
I'm sorry.
Your next witness.
Oh, Stephanie Murphy.
It's gone to print, it has, Chrissy. Gone to print. Right, Stephanie Murphy is the next one in. Here she is. Oh, she's gone. Oh, no, that's not her. Stephanie Murphy. It's been lagging a bit because I've been doing this Canva. Look at what I got. Hang on. Pause it for a second. So this is the schedule. Fuck. For the rest of the week. So today, Monday, Tuesday. Oh, look at that. Take this down as well. Take the ticker down. Not catch up. Fuck, I done it wrong. So yeah, morning sessions, all of the mornings. Then we're going to be watching 11 o'clock Eastern, the trial. Alec Baldwin. I'll change the catch up bit in a second. There you go. Right. It is. This judge, I like him. I like him so far.
Do you solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth?
Okay, where did I put my notes?
Stay about 12 inches from the microphone.
No. Hello, ma'am. My name is Judge White. I'm going to be presiding over this hearing. As the deputy said, you get about 12 to 15 inches from that microphone. It adjusts up, down, left, and right to wherever you need it comfortable. And if you just speak in a loud, clear voice, it should pick up everything. Thank you.
Good morning.
Good morning.
Please state your name.
Stephanie Murphy.
And what do you do for a living?
I'm an attorney.
What type of law do you practice?
I practice family law.
And do you work for someone or are you self-employed?
I'm self-employed. I have a firm in Sarasota.
How long have you had that firm?
I've had the firm for approximately 15 and a half years.
And were you hired at some point by Doug Benefield?
Yes.
Do you recall when you were hired by him?
I first met with Doug Benefield on March 13th, 2018. He retained me on a partial retainer the following day on the 14th of March.
Okay. And what was the purpose of him hiring you on that day?
On that day, I was retained for a limited purpose of communicating with Ms. Benefield with regard to the upcoming birth of their child.
Okay. So the defendant was pregnant at the time.
Correct.
And do you recall when her due date was?
I believe the original due date was April 8th of 2018.
Okay. And you said your initial responsibility was to communicate with her.
Yes.
So did you attempt to communicate with her?
I did. I sent her a letter via email on March 15th, 2018 at approximately 9:59 in the morning.
And without getting into all the specifics in the letter, basically what was the gist of it?
The general gist of the letter was that with knowledge of the upcoming birth of their child, Doug wanted to express his interest and desire to be part of the birth process, to be present if possible, but also wanted to communicate that if Ms. Benefield felt uncomfortable about that, he wanted to respect her space.
Right, for the record, object to hearsay and relevance.
Yeah. Is this being offered for the truth?
No, it's just basically being offered to show that this is how the communication started and that the letter was sent to Ms. Benefield.
Okay. Did you want to respond to that? I'll just say I was not taking this as for the actual truth of this.
Yeah.
If it's intended to be for the truth of these matters, then that's a different issue.
No.
Well, I think it's obviously intended to quote unquote educate Your Honor. based upon the hearsay that this witness has to offer. So
Okay.
continuing relevancy.
Yes, sir.
Hearsay check.
Go ahead, ma'am.
Okay, thank you. Did you ever, let me back up. I don't know if you said this, but in what form did you send her this communication?
It was a letter that was saved as a PDF that was emailed.
Okay. Did you ever receive a response from her?
She never responded to me directly, no.
To your knowledge, did she ever respond to Doug?
No, not at that time.
At some time shortly after that, so the baby was born in, or when was the baby born?
Well, baby was actually born quite early. The next day after receiving my letter, she checked herself into Tampa General Hospital and then started a induction of labor process. And so the baby ended up being born about 3 weeks early, I think March 19th of 2018. I may be off a day or two.
So middle of March. baby was
Correct.
born. What, to your knowledge, was Doug there?
No, he was not there. He had no idea baby was born.
Did the defendant file for an injunction shortly after?
Yes.
And what date was that?
My memory is that it may have been, excuse me, May 1st of 2018. It could have been in April. There was a bit of a lag between when she filed it and when we had knowledge of it because the injunction was actually denied, but a hearing was scheduled. So Mr. Benefield was not served.
Okay, so just to be clear, you said the injunction was denied. Are you saying the temporary was denied?
Correct.
Okay, so an injunction was filed, a temporary was denied, but it was set for a hearing? Is that
Yes, that is correct.
All right. Do you recall when the first hearing was set approximately?
It was shortly after we found out about the injunction. So I think we found out, meaning I found out on May 6th of 2018 that the injunction had been filed, which is how we knew that the baby had been born and what the baby's name was. And then the hearing was originally set for shortly after that. I think just a couple of days.
Okay.
Ended up getting continued anyway at Ms. Benefield's request.
Okay, so it was set pretty close in time, but it ended up getting continued.
Correct.
Before the hearing was actually held, did you end up filing something on Doug's behalf?
Yes, quite a few things.
And generally, what did you file?
Generally, it was a petition for a parenting plan unconnected with divorce and a motion for psychological evaluation. Those were the initial pleadings that we filed.
Okay. Ultimately, were these issues all to be addressed at the same hearing?
Ultimately, yes. Well, let me clarify. No, because then when the hearing ultimately took place, it wasn't the original petition for parenting plan unconnected with divorce. It was actually an emergency motion for a temporary time sharing and parental responsibility. But both cases traveled together. And so pleadings or motions in both cases were heard at the same time.
Okay. So while the motions themselves may have changed, the two case numbers were heard at the same time.
Correct.
So at the time, Doug had an emergency motion for time sharing?
Yes.
And what, just briefly, what is that?
When there's a child, there's no such thing in Florida as custody anymore. Parents have time sharing with children. Ms. Benefield was withholding time sharing of their daughter from Doug. And so the appropriate way to seek time sharing was through the court versus taking matters into your own hands.
Okay.
He was also seeking parental responsibility, which is the decision making.
Okay. And when was that hearing held?
It was held on 2 different days. It was July 30th and September 17th of 2018.
So you did have part of the hearing on July 30th, 2018?
Yes.
And did not finish, I'm assuming?
We did not finish.
What judge was it?
It was Chief Judge Diana Morlan.
And before that first hearing, was there a motion to recuse the judge?
It was a motion to disqualify Judge Morlan.
And was it granted?
No. They appealed that decision and filed a motion to stay pending appeal. That was also denied.
Okay. So the hearing continued?
Correct.
Then it continued again for the rest of the hearing in September?
Yes.
Okay. So I don't want to get into the specific facts of the allegations in the injunction, but if you could just tell us generally what were the topics, the injunction?
It was a wide range of topics. The most alarming was she had allegations that she was poisoned by heavy metals and that the baby had also been poisoned in utero. She alleged violence of a dog.
Oh, I'm sorry. I thought we were going to talk more about the poisoning. So
Okay.
Violence with a dog.
Correct.
Poisoning.
Right. Threats, and that he had discharged a gun in the home.
Okay. After this hearing, did Judge Morlan make a ruling?
She made a ruling at the conclusion of the second day in September. Yes.
And what was that ruling?
Her ruling was
I'm going to sustain as to her ruling on these issues. I mean, I'll hear.
And
go ahead.
I'm sorry.
You put whatever you want on the record.
This we may need to have argument about, Judge. It is my argument, it's the state's argument, that the content and the manner in which I have the order recorded, the judge made this ruling set the stage for the defendant's behavior later on down the road, because she knew that this judge felt the way she did, and she had a hearing in front of this judge 3 days after she murdered the defendant. So I think it's effect on the listener, and I have some case law we can argue if you'd like, but this manner in which this order was given is highly relevant to the defendant's, the effect on her.
All right. So you're not introducing Judge Morlan's ultimate order to influence one way or the other to prove that it was correct.
Correct.
It's the effect on the defendant.
Correct.
All right.
Whether it be right or wrong, the ruling, I'm introducing it for the effect on the defendant.
Yes, sir.
I don't have a problem with that. The problem that I have, which I think the court is well aware of, is the characterization of the presentation.
Right. Absolutely. If it was for the purpose of, hey, judge, this other judge ruled this way, therefore, that's what we want.
Correct.
But if it's to show the effect, and yes, that one of the cases you had submitted illustrated that very point. So I get that. All right.
I want to make sure we're talking about the same thing. I don't have a problem with the state's theory that this decision prompted the subsequent action. What I strenuously object to is the statement by Judge Morlan, the characterization of the quality of the hearing. That I think should not be stated in this proceeding. I think it's irrelevant. The decision itself, I don't have a problem with. I can tell the court, well, let me just leave it right there. Right now.
All right. I don't know what the statement is. I'm going to have to hear it eventually, and then I just won't consider it. But it was, yes.
Hello, welcome to everybody. As I approach the bench, I can forward it a little bit, but before I do, just a reminder, everyone, this is a standing ground hearing from last year in preparation for the trial to start on the 22nd. You see, this is what I found interesting. If you look at her, she is listening in. She's got headphones to listen into the sidebar. So if you remember, Karen wasn't allowed to hear the sidebar. She's allowed to. So everything they discuss there, she's hearing everything. Interesting, isn't it? Well, she is if you worked. But, I mean, so you get some trials like that the defendants, they get to hear everything. So I've always been in favour of that. Oh, Kim, thank you for 10 gifted memberships, Kim. Thank you, my darling. I really appreciate you. Thank you so much. And hello, Owit, as well. No worries, my darling. Yeah, it's a great idea, Amy. Great. I had to double check that lady in Boston was like, Amy, is that you? Yeah, thank you for the gifted memberships, my darling. Yeah. I watched Travis Rudolph, and he was allowed to go to the bench with his attorneys. Yes, and Aaron said the same. Yeah, Travis Rudolph did. I love it. Fancy now. I don't, Diamond. I don't. Oh, let me go and check it. It must be on Facebook or something. Let me go and check. No, I have not seen it. Hang on. I can fast forward this as well. Hang on.
We've into a system. We've got to get it fixed. So why don't we do this? Kind of a good time for a mid-morning break. This issue solved. Ms. Murphy.
Yes.
The rule of sequestration has.
Thank you.
And the first thing I'm going to do is confirm you can hear me. Just give me a thumbs up.
Happy days. Happy days. Just explain to people again, 2 seconds. I'll go and try and find that motion. is every morning, right? Oh, shit. Wrong one. I got Breakfast Club. The reason I don't have a topic on them all, some of them will, one probably be Karen, whatever, is because Sean and me are going to be doing a show together either this week or next week. That's why I don't have topics on them. But whatever it is, there'll be topics in the morning. We'll probably do 2 hours and then go straight on to the Baldwin trial then. So 2 separate streams. So just to explain that one. Right, let's get this back. Nope. Is that one? Nope. 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 Happy days. Hey, basically, little G, that's what I'm going to be doing. It's just some people like to know what they're talking about. By freestyle, I do freestyle it. Tomorrow's obviously set in stone. It's going to be Ashley Benefield. But apart from that, it's going to be a little bit about Karen Reid, Colbert. You know what I mean? We'll just speak it up as we go along. It's fine. I agree. That where I got my name. Is it? Hack. Oh, I didn't know that. You didn't watch it with me, did you? Because that's where I got my T-shirt from, the Travis Rudel T-shirt from the family.
Oh, yeah, that won't work.
Left field, yay! Good morning, Bo. Bo. Doug Benefield is 54, and Ashley is 24. So, just interrupt for a second here, right? So, there was discussion about this, right? Because if you see Ashley, look, let's not put it. She's a bit of a looker. She's a bit of a looker. You know, I think if you got a pulse, you're gonna say, "Fuck, she's a bit of all right." So there's discussion about what would you do? Would you put more women on the panel or more men on the panel? Because the men would be attracted to her, but then they might be like, "What a bitch! She killed her husband. She led him on and stuff like that." Or are you women, or could have put a woman that might be jealous of her looks, but might sympathize with her? So there was a discussion between 2 lawyers about this. I was like, "Oh, that's intriguing. I don't know which way I'd go." So those are ones yeah, I know. Trust me, I know. No more. I don't have that issue, so it's all good. 30 years as well. Fuck it out. Young, dumb, full of cum. That's what they say, isn't it?
All right, welcome back, ma'am.
Thank you.
Do you ready to try and discuss the case with you or anything about your testimony?
No.
All right.
So we were talking about the end of the hearing on September 17th, 2020, where Judge Morlan made a oral order.
Correct. She made an oral ruling at the conclusion of the hearing.
And was the defendant present to hear this ruling?
Yes.
She was in court then?
Yes.
All right. I'm going to show you State's Exhibit number 1. Do you recognize that?
I do. Those are my initials.
Okay. What is it?
That is the CD of the oral pronouncement at the end of the injunction and emergency time sharing hearing.
Okay. And you said these are your initials. So
correct.
When you listened to it, did it accurately reflect your memory of what was said in that hearing?
Yes.
State would enter an evidence, State Exhibit 1.
Same objections?
Yes, sir.
Yes, sir. Overruled for the same reasons. I'm not accepting it for the truth, just the effect on the listener.
Okay. And then the state will publish it's about 10 minutes long.
Mr. Sessions, start with that one thing, even though I find it very reticent to ever say, well, someone else investigated this, so there's no problem. But I do appreciate the fact that Mr. Sessions argues that people investigated and found that his client wasn't the perpetrator of any domestic violence, et cetera. Because I just read a report by a doctor that just indicated that he had done a full battery of psychological evaluations on Mr. Benefield in this case. He had absolutely no concern of self-harm, domestic violence or any other type of spurious activity on behalf of Mr. Benefield. Let me just go ahead and say as follows, that this court will find that as far as credibility is concerned, I would find, and I'm going to say this in the gentlest form I possibly can, that there is absolutely not a single scintilla of credibility that I'm attaching to anything that was testified to, at least in this hearing of Ms. Benefield. Court finds that it starts from basically the absurd of the conversations of what she would have had with a child, searching the room, finding a shadow box, being so upset, but also at the same time testimony where she said, well, they were absolutely liked me a lot. They confided in me every conversation. I knew all these horrible things were going to happen because the girls felt good talking to me. We then move forward to the actual presentation that she's had in this courtroom since she entered into this courtroom, the turning on of tears when she thinks it's appropriate, then we move on to the entire insinuation that there is some type of poisoning going on in this particular case. There is not a single scintilla of credible evidence that Ms. Benefield
Right, it should stop lagging now because I've been uploading stuff, so let's...
has ever been poisoned or suffered from any illness of any poison. Court finds that Dr. Hilliard's testimony was suspect. I don't think that the court finds that he reviewed one record appropriately. And in comparison to Dr. Sawyer, I think his testimony, in a word, was bunk. I do find that Dr. Sawyer's testimony was quite informative, and that his information concerning the answered questions that I had, how there were testing for certain metals on and then testing for certain metals that weren't there. Most important to this court was the explanation of the misinterpretation or the use of an improper range, which I think even across examination, there was a misunderstanding that there is a range of these metals are in the human body, not just a single number. So that brings us to the following timeline. I have that in 10/20/2016, there's the respondent goes up there. They're at the respondent's home. Petitioner is up there. He's had back surgery. She moves back into the respondent's home permanently on December 2016. That in about January 2017 through, I'm going to say 5/8/2017, there appears to be a marriage in which there are arguments, but there is still a very committed relationship to the point where they're talking about having a reversal of vasectomy to have a child. That on 5/8/2017, the clear evidence is that there is the vasectomy alteration or reversal, and that from that point, they begin to pursue having a child. The court will find there is one incident of alleged domestic violence, and I got to tell you, it is de minimis, even though it's huge. Whenever how it was executed, the shot into the ceiling, court is going to find that at no time was the shot by Mr. Benefield at or in the direction of Miss Benefield. The court has seen Mr. Benefield testify, and the court finds Mr. Benefield is taking on responsibility for that single misstep. But that is a remote type of domestic violence that has occurred. Subsequent to that, it is clear that Ms. Benefield continued to pursue a relationship and have child with this gentleman, that she had a lavish wedding, invited numerous people there, had many people that she could have confided in, saying, I'm in a hellish situation, things are out of control. Just last week, he shot a bullet in the ceiling. That's absolutely not what happens. Instead, she goes through with this lavish wedding. She goes on developing a ballet with her husband at that time, posing in magazines, portraying to everybody in the world that this is a very happy marriage, that we're going down, we're going to start this national ballet at a significant cost, both emotionally, physically, and financially to the parties. That she finally they finally find out that in July 2017 they have conceived a child, and that or they think that that's the date they've conceded in retroactive review, which tells this court that during that period after the shot, that they were still engaging in an intimate relationship. The court does not find credible any type of animal cruelty in this particular case, nor does the court find that the other incidences alleged of punching the wall were ever directed completely at her, nor were they meant for intimidation. The court's also going to find that 8/3/2017, they do find about the pregnancy. It's confirmed. And at that time, because of illnesses due to the pregnancy, it is determined as a family, as well as because of the ballet, that they're going to move Mrs. Benefield to Florida from South Carolina. During all this period of time, what we have is a household that is continuing on. Miss Benefield being in the home, not making anyone alert. The medical records are devoid of any conversations between her and people that would have been providing protection, those being doctors, etc., indicating in the least that she has any type of poisoning that is appearing in her system, that she has been the victim of domestic violence, and or that this child Eva has been.
No, this is a hearing. Just to clarify, I'm sorry, I don't normally stop and stuff, but just to clarify, people, this is stand your ground hearing from last year. Judges making decisions. This will be a jury trial.
The victim of domestic violence. Then we go on, and suddenly we have she moves to Florida. But even in Florida, we have Irma come through. I think September 11th, that weekend. Mr. Benefield comes all the way down. He makes sure she has a generator if she needs for the storm. He then leaves, and she feels comfortable enough and well enough to go all the way back up to the home that she shared with Mr. Benefield to collect property and transport those items down to Florida for her own use, and without any fear that this gentleman is going to harm her when she's up there. They one of the other things allude to as far as credibility problems were the issues concerning the split records that she's asking the Lakewood Ranch to have to, I guess, somehow cover any type of problems or contradiction there might be with the poisoning allegations, as well as the emails that were introduced today between the cousin of Mr. Benefield and Miss Benefield, I guess, trying to curry some kind of upper hand in the in either of these two cases against Mr. Benefield. Court's also going to find that the wife has at this time demonstrated a complete disregard for allowing Mr. Benefield to have any active role in the birth of his child and or the life of his child that he has now not had any contact with. The court's going to find there's been no violation of any injunction. The court did look at and has listened to the testimonies that were provided concerning the injunction that was entered. Quite frankly, it sounds like the court was when you listen to the transcript, was actually telling both of them they need to stay away from each other. And then certainly there was no violation of it whenever there was the oral pronouncement, only to be followed by a written pronouncement. Court is also finds there are some issues with the credibility of Miss Benefield when she's actively sitting here telling this court she doesn't like to have publicity, but at the same token she's participating in articles concerning the alleged poison, etc. As far as the last comment on the poisoning, there is not one piece of evidence, like I said, that has been established that even if she was being poisoned, that there has been a suggestion of a nexus of the who, how, and where the poison. That would be rank speculation for this court to jump into the idea that because it happened, it had to be him, especially when I have, in all senses, not a credible witness is the only person that's asking me to speculate. So with that in mind, the court is going to find that at this time, there is absolutely no evidence. And I'm saying no evidence. I'm not saying by the preponderance of the evidence standard, that hasn't even been close to that there's been a indication that there's an immediate likelihood of domestic violence. There's only the one remote incident. And as of today, there's no reasonably prudent or logical person would think that you're the threat, that you're being threatened by immediate domestic violence. So for those reasons, the court is going to deny the request for an injunction in this particular case.
So after the judge's ruling on the injunction, which would be the defendant's motion, did she make a ruling on your motions?
Yes.
And that was time sharing with the child?
It was time sharing and parental responsibility.
Okay. And what was the order, or what did the judge say Doug could do?
There was a temporary time sharing schedule that was increasing in frequency and amount. So it started with the first day that he was going to be able to meet his daughter just a handful of days later. After a period of time of seeing her according to the schedule, then it jumped up to weekend time sharing, overnight sharing. Then there's another jump. And so he was able to take his daughter back to South Carolina for time sharing. There was also, I believe, some extended visits, maybe holiday related. But then the other main component of that order was with regard to shared parental responsibility, which again is the decision making. And Judge Morlan ordered that Ashley and Doug were to exercise shared parental responsibility so that they would have to confer and make a good faith attempt to agree on major decisions.
Okay, because look, we are Karen Reed first and foremost. I'll pause this for 2 minutes, right? Hi, Lorraine, by the way. Let me just show you what's happened with Carrie. So there's nothing to see really. But let me just show it to you because I don't want you guys to miss out or leave and stuff like that. So Ted Daniels, good morning, everyone. The new filings on Mass Court. So these are new filings. Attorney appearance on this date, Martin G. Weinberg added as limited appearance counsel for defendant. Defendant's motion dismissed with certificate of service. Affidavit of David R. Yannetti in support of defendant's motion to dismiss. Affidavit Alan Jackson to support defendant's motion to dismiss. So yeah. So that none of the paperwork is out as far as I believe, but Diamond and Carol said that they're trying to vacate the murder one because allegedly he was 12-0 for not guilty of murder and it was only manslaughter. They couldn't agree on. And then the other one is people asking about who this guy is. I have no idea he is, but very quickly. This is the guy, nationally one of the best criminal and white-collar defense lawyers based in Boston. Martin G. Weinberg, I'm not sure how you say his name, is nationally prominent criminal defense lawyer, considered by many within the legal community to rank among the nation's best criminal and white-collar defense lawyers and best litigators and appellate advocates. So yeah. So there you go. That's him. So the only charge on the table is vehicle manslaughter, not guilty on others. Oh, okay. It said they were 93 guilty of vehicle manslaughter. Oh, okay. Okay. He does look badass. Oh, and the other thing is all the women would be like, oh, he's so fit. He's got no hair. So sexy. I know. So sexy. Right. So there you go. I don't think so. I don't think Patty works for them. No. I think he's just a got his own business. I don't know. Anyway, there'll be more stuff coming out later on today once the filings are out. So we'll know more later. TMZ says 93. So hang on, 93 guilty for vehicle manslaughter, not the other charges. Not guilty for everything else, but take it with a pinch of salt. Go fuck yourself, Kimmy. Go fuck yourself. Right, hang on. Where the friggin' Nora has this gone? Here we go. We're back. Right, I won't stop her anymore now, unless something big comes. Share screen. We'll see what happens here. As we always say, calm your tits, everyone. Calm your tits. Don't worry about it. It's all good. We don't know what anything is. So anyway, we'll get into it. Sean's wiped off on you. I used to swear before, but Sean did definitely. I think Sean got a row off his wife for leading me down a bad way. But Kimmy, no. Yeah, I will be later as well. There you go. Hey, Kia, Jackson still working with defense. Yeah, at the minute, yeah, I think so. We'll see. Donna Graves. Hello, Donna. How are you doing, my darling? Oh, maybe, Jill. Maybe. Yeah, well, we're going to be back together either this week or next week on his channel. So and then he'll be back here for all Karen Reed stuff as well. So thank you. Right, here we go. Yeah, I know. Right, let's not distract. Let's get back to this for a second. Here we go. Ballerina murder trial. Let's go.
But the court specifically ordered that Doug Benefield would have ultimate decision-making authority regarding health-related or medical issues, and the order made very clear findings about.
And the only thing else, I see a lot of people saying how they've missed each other on chat. I love seeing those guys. I've missed all of you. You're awesome. Well, most of you. Kimmy's not awesome. She could go fuck herself. But everyone else, you're awesome.
her extreme concern with regard to Ms. Benefield's medical decisions up to that point, which is why she ordered the ultimate decision-making authority.
And the concern was for the medical decisions for the child.
Correct.
So why is there an escalating frequency of visitation with the child?
Well, Doug had never even been allowed to meet his daughter. So she was, I believe, 6 months old by the time he met her. And so it's just appropriate that you don't just dump a baby with who was at that point a stranger.
Okay.
So it was just to grow in a reunification or a unification, I guess. There's nothing to reunify.
To get the child used to who she was going to.
Exactly.
Okay. So the first time sharing where there was an exchange of, and the daughter's name?
Her name is Emerson Grace Caney.
Okay. And can you spell the last name?
I believe it's Caney. I have to double check my file to be completely certain.
Okay. And where were these exchanges of custody to take place?
Well, according to the court order, they were to take place at Manatee County Sheriff's Office, and that's where the first exchange took place.
Were you present at the first
Yes,
exchange?
I was.
And did you arrive with Doug or were you separate?
We arrived separately. By the time I arrived, he was already there. We were both there earlier than the scheduled exchange time.
And was this the first time Doug was meeting his child?
Yes.
What happened during this exchange? Did the defendant ultimately show up with the child?
Yes, she did.
And just explain how that meeting went.
Okay. I had been sitting with Mr. Benefield in his truck, and when he saw Ms. Benefield enter the parking lot, he moved the truck closer to the entrance to the building, and she was out in front of the building with the child. Doug and I then approached Ms. Benefield, and I hung back a bit, and Ms. Benefield saw me, looked at me, and then immediately said, "Are you dating her?" She was very indignant, very upset, and then I responded to that question. Of course, I said no. And then they proceeded to have a conversation where Doug was trying to engage with Emerson, talking to her, ultimately was able to hold her. And Ms. Benefield was in very close proximity to Mr. Benefield, probably less than from me to the judge's bench, especially when she transferred the baby over to his arms. They kept talking for 5 or 10 minutes or so, and I kept waiting also there. Then Mr. Benefield turned to me and said, "Okay, we're going to go. Ashley's going to come." And so I pulled Doug aside. We had a communication about it. I warned him that it was not a good idea given all the allegations that she had raised up to that point. And he said that he was aware of the concerns. He agreed with me, but he wanted Emerson to be comfortable, and he thought having Ashley there, as she was insisting, would help Emerson be a little bit more comfortable. So then I watched them Ms. Benefield strap Emerson into the car seat in the back of Doug's truck. She got in the back seat and they left. I, of course, just left in my own vehicle.
And approximately when was this?
This was September 21st.
September 21st of
2018.
2018.
Just a handful of days after the hearing.
So from this point on, at least from your perspective as the family lawyer, was there sort of a peace between the two?
Well, there was. In fact, they had an agreement that we memorialized into a joint stipulation to expand the time sharing that Judge Morlan had ordered. So within a handful of days after seeing his daughter for the first time, Ashley and Doug had a written agreement signed by both attorneys and submitted to the court that said you get to see the child even more, exchanging the child anywhere they agreed. If there was no agreement, the exchange default would be at the Manatee County Sheriff's Office, but more frequently, not supervised by her. And that then was the norm for quite a while.
And how long did that last, approximately?
About 11 months, I would say. From September of 2018 until August of 2019, they were together all the time. Doug's time sharing was always with Ashley present, so they were certainly behaving as a family. They were quite active on the social scene.
I was going to say, did you ever see them?
I did. They were in magazines. I think they were even in SRQ magazine at some kind of ballet gala event together.
So at some point, this piece did not last.
Yes, it did not last.
About when did things start to go downhill?
Unbeknownst to Doug, they were about to go downhill in August of 2019. He was scheduled to move in with Miss Benefield and her mother. So he'd kept an apartment or a little condo here in the Sarasota area, but his lease was running out. So they had agreed that he was going to move into their home. They moved all of his things inside to their home, emptied the storage unit of his contents into Ms. Benefield's home. And the day he was scheduled to move in, as he always said, she ghosted me. She didn't answer the phone. And so I think it was August 16th of 2019 was the day that he was supposed to move in, and then suddenly everything changed.
Okay. So
Just for the record, you want to continue an objection to hearsay and relevancy.
Yeah, we're getting pretty in depth with this whole situation.
okay, and I can move along.
Okay.
So at some point, did Ashley start filing complaints
Yes.
against Doug?
Yes. She started again. Yes.
And how many complaints were there, if you recall?
I would say a half dozen. They started, I think, in December of that year. And then they just kept on going for another 4 or 5 months. And there were complaints about the child.
Okay.
They were
So
not about her.
not about her, complaints of abuse of the child.
Correct.
Okay. And at some point, did Ashley file for another injunction?
Yes.
And were you involved in that?
Yes.
Who, I'm sorry, as a part of that investigation concerning those complaints and that request for an injunction, was a psychological evaluation ordered?
It was not ordered by the family court, but there was a psychological evaluation that was put into place through CPS. And I believe it was Detective Morlan.
Okay. So at some point, a psychological evaluation of both Doug and Ashley was ordered?
Yes.
All right. And to your knowledge, Doug participated in that?
Oh, yes.
Who was that doctor?
Dr. Breder.
At some point around this time, did Doug file for divorce?
He did. In November of 2019, we filed a motion for leave to amend and then a amended petition for dissolution of marriage.
Was that your case number? Did it run along with her injunction case number as we talked about before?
Yes, they were companion cases.
Companion cases?
Yes.
Okay, thank you. When was it set for a hearing?
Again, it was a hearing that was set and then moved a couple times. So I think it was originally set for hearing in May of 2020, moved to August, and then moved to September of 2020.
And do you recall the date in September?
It was scheduled for September 30th, 2020.
Were you ordered to mediation first?
Yes. At Ms. Benfield's request, she filed a motion for mediation. The court entered an order of referral to mediation.
Okay. And during the mediation, were you present at the mediation?
Yes, we were all present via Zoom, but not in person because it's during COVID.
Okay. But the defendant was there via Zoom?
Yes.
And Doug was there via Zoom?
Yes.
And the mediator?
Yes. As well as Ms. Benefield's attorney was also present.
And who was that?
Faith Brown. At the time, she had been let go from her prior attorney.
Okay. So what did Ashley say at the mediation about their relationship?
Both of them said.
Sustained.
What did Ashley say? It's the defendant.
This is during a mediation? Is there some exception? Mediations are generally private and confidential.
I can move on. I thought it was a hearsay. You're saying something else.
No, I'm assuming, you tell me what your objection is.
Okay.
Yeah, I mean, I don't, unless you have some case law that there's an exception to the general, I'm going to say secrecy, but the privilege, the mediation privilege. I'm not aware of any case law, but you may have some that there's an exception in a criminal prosecution.
I do not, Judge. I'll move on.
All right.
At some point after the mediation, did Ashley agree to drop the injunction?
Oh, she had agreed to drop the injunction before the mediation, but it wasn't just that she was going to drop it. It was a quid pro quo situation.
And what was the quid pro quo?
That he dismissed his divorce case and again, another emergency motion for time sharing for the parenting plan, and the joint motion to release the psychological evaluations conducted by Dr. Breder.
Okay. And in fact, were those things all dismissed except for the psychological evaluation release?
They were not.
Okay. The hearing that was set for 9:30, what was to happen at that hearing?
There had been a lot of discussion leading up to that, and the plan was that the September 30th hearing would not be held on the injunction because the agreement was that once the psychological evaluations were provided, then the injunction would be dismissed and the family law case would be dismissed. Okay. So the 30th hearing was supposed to be the joint motion for release of psychological evaluations.
Okay. And what day was Doug murdered?
So that he was murdered on Sunday, September 27th. 2020.
3 days before this hearing was scheduled.
3 days after the mediation, 3 days before the court date.
And who was the judge scheduled to be at this hearing on the 30th?
Chief Judge Diana Morlan.
So the same judge that had heard the rest.
Same judge.
In all of the times that you dealt with Doug, did he ever have what I would term like an overly angry demeanor towards Ashley in your presence?
No, which is kind of a source of conflict with Doug and I, actually. He was very passive, very accepting, and always looking for excuses or reasons. Not angry, just surprising. He was also very suspicious of her, but never angry.
Okay. And did he always blame her for everything, or?
No, not at all. I think he often blamed Dr. Hildegard Staninger, who was related to the Carlson labs, who obtained, involved with the poisoning allegations and the lab results. But no, not always Ashley. He was always trying to look for, some explanation as to her conduct.
Thank you. I have no other questions.
Thank you.
All right, Cross.
Good morning, Ms. Murphy.
Good morning, Mr. Taylor.
You practice family law,
I do.
and you've been doing it, I think you told us, approximately 15 and a half years you've had your own firm?
I've been practicing family law for approximately 21 years, but I've had my own firm for about 15 and a half years.
Okay. And in the course of your practice, have you had the opportunity to represent both petitioners and respondents in domestic violence injunction actions?
I have.
And have you represented them, Ms. Murphy, strictly in family court, or have you also continued in representation in those cases where the disputes end up in criminal court as well?
Only in family court. I do not practice criminal law.
Okay, so on those occasions, you would refer it out?
Yes.
All right. It's the nature, is it not, in family court matters that the litigation is often, shall I say, spirited?
It can certainly be the case.
Okay, it's not unusual.
It's not unusual.
Would it be fair to say that the litigation can sometimes, depending upon the parties, be quite aggressive?
Never to this level in all of my 21 years, but it can be aggressive.
All right.
This was extreme.
And it can also be determined, can it not?
I'm afraid I don't understand that question.
Litigation in general, in family court matters.
Determined meaning?
Determined meaning neither side lets up. You have two people who fundamentally develop a real dislike for one another, and they just pour their heart and souls into the litigation.
Yes, unfortunately, that happens.
Yeah. They shoot more family lawyers than they do criminal.
I've heard that. I think there's more violence on the family law floor than on the criminal floor.
The litigation can often be petty as well, can it not?
Sometimes.
Yeah, where you get two parties that are arguing over a pet turtle, for example.
Right. This was the opposite of petty, but yes, it certainly can be.
All right, and you are, of course, like all of us, an advocate.
Yes.
And in this case, you were an advocate for Doug Benefield.
Yes.
And he paid you, did he not, to be his advocate?
He did.
During the hearing that we heard, the ruling for which I think it's a safe bet that the petitioner did not prevail, but would you agree with me that Judge Morlan did recognize that your client, Mr. Benefield, had fired a gun in the home when Ms. Benefield was present?
Yes, she said that in her ruling.
And she also recognized that he had apparently punched holes in the drywall.
She did say that.
And in fairness, I believe Ms. Murphy, she dismissed the firing the gun in the ceiling of the kitchen as too remote in time.
I believe that's what she said, yes.
And as to the punching of holes in the wall, I think she said it was not directed at Ms. Benefield, but just out of frustration.
I don't remember that she said that. She certainly could have.
Okay. Having just recently heard it. So in cases of domestic violence injunctions, would you say what percentage of your clients are females and males that seek domestic violence injunction protections?
Well, I can't tell you it would be my clients. I think in the cases in which I'm involved, the majority is the female client is seeking an injunction against the male.
Okay.
That's not necessarily indicative that the female is always a victim of domestic violence, because men can also be victims of domestic violence.
Yes. Now, through your 21 years worth of experience in family court, I'm sure you've come to learn that there are some stereotypical factors that seem to be rather common with a lot of abusers. Would you agree?
I do not necessarily agree with that. No, there are different types of abusers.
All right. Would you say that it's reasonably common in those instances where you've represented females seeking domestic violence injunctions against males, that the males are often controlling?
That is sometimes the prevailing foundation for why the domestic violence occurs, but not always.
Is that a yes?
No, it's a no, not really.
It's a no, not really, as opposed to sometimes?
Sometimes.
Okay. I'll take sometimes.
Okay.
All right. Have you had experience in those instances where you've represented females seeking protection from domestic violence, that the males are sometimes jealous and very possessive?
Judge, I'm going to object to this line of questioning. Is it relevant?
I think it may be. I don't know. The witness can certainly say yes or no, or agree or disagree.
That is one of the most rare reasons for the domestic violence in the cases that I've had in which I've represented the women. So jealousy is usually not a factor or a major factor.
So you've seen it?
I've seen it, yes, but not often.
That was my question. Have you experienced in representing some of these females seeking protection for domestic violence against males that they have employed a strategy, which obviously has not been successful, of appeasement over the course of time, and finally it builds to a sufficient crescendo that they end up as a client of yours?
I have seen that.
Okay. And by appeasement, we mean, do we not getting along, going along for fear that the reprisal will be greater?
Yes, that is true for both the female victim, if you want to use that word, as well as the male victim.
Mm-hmm. When you bring a petition for protection against domestic violence in the family court, are you foreclosed from returning and seeking a second petition?
Do you mean if a petition is denied, can you then file a different petition on the same allegations?
Not on the same allegations.
Okay, then, no, you're not foreclosed. You can file as many domestic violence injunctions as you like.
Correct.
No, regardless of how many times they've been denied.
Correct. So in other words, you've had a domestic violence petition denied, and then 2 months later, additional acts occur. You are entitled to go back to family court and file another domestic violence petition.
Of course.
And in fact, have you done that on behalf of clients in the past?
I just want to clarify, I don't file petitions for injunction. So a party would file that on their own at the clerk's office. So my involvement is usually after an injunction has been filed. That is when my involvement begins.
And have you represented people who have gone to court multiple times? Or do you only go one time?
Oh, no, I could go multiple times. I just don't think that I've ever had a situation where I've represented the petitioner who has made multiple injunction petition filings. I represented several respondents who have been themselves and the victim of spurious litigation and abuse of the injunction process by repeatedly filing injunctions.
When Mr. Benefield was living here in Manatee County, he had his own apartment. Is that correct?
He wasn't not living here full time, but yes, he had an apartment at times during this period of time.
You're not aware of any point in time where he resided with Miss Benefield in the home where the shooting took place?
My understanding is that he did not.
I don't believe I have anything further. Give me a moment, Your Honor. That's all, Your Honor. Thank you.
Thank you. Redirect?
No.
Can this witness be released?
Yes.
Mr. Taylor? All right, maybe you're releasing your subpoena. Thank you very much. State, you ready for your next witness?
The state would call Amanda Conolin.
It's interesting because I think half of you were listening to this, and the other half all are deep into the Karen Reid weeds and stuff like that. If the motion comes out, we'll stop and we'll read it. But yeah, it's interesting. 1204 murder, which is no surprise. But if it's 9-3 vehicle manslaughter, I'm surprised because that's 5 to 20 years in prison for Karen. 5 to 20 years. Fuck. Anyway, let's get back to this. This is an interesting case, Denise. This is, what's it? Crime. Oh, crime scene or something.
Well, ma'am. As the deputy said, just make yourself comfortable. That microphone adjusts up, down, left, right, however you need it. And if you speak in a loud, clear voice, we should hear everything.
Good morning. Morning. Please state your name and spell your last name for the record.
It's Amanda Conolin, Conlin.
And how are you employed?
Sheriff's Office Crime Scene.
And how long have you been so employed?
16 years.
And can you explain generally your duties as a crime scene technician?
To document the crime scene through photos, video, sketches, collect evidence, process evidence.
And did you obtain any education that helped you with that position?
Yes.
And what was that?
I went to St. Petersburg College for crime scene.
And did you get training once you began working with the Sheriff's Office?
Yes, we're sent to training all the time.
And so that has continued?
Yes.
Thank you. I want to draw your attention to September 27th, 2020. Were you working that evening?
Yes.
And were you asked to respond to a scene at 11331 White Rock Terrace?
Yes.
And is that here in Manatee County?
Yes.
And do you know approximately what time you arrived there?
About 8:28 that evening.
And were law enforcement officers on scene prior to your arrival?
Yes.
And without telling me what you said, did you speak to them to kind of find out what was going on?
Yes.
After speaking to them, what, if anything, did you do first?
I went next door to the neighbor to collect a gun.
And are these single family homes?
Yes.
And where was the neighbor's home in comparison to the home at 11331?
Right next door.
And did you in fact go over there?
Yes.
Okay. And did you retrieve a firearm?
I did.
Who did you retrieve it from?
From the homeowner.
Was that a Mr. Saint or Sant?
Yes.
And did a law enforcement officer accompany you to secure the firearm or make it safe?
Yes.
Okay. And who was that?
Ackerman.
And did he in fact secure it?
He did.
Okay. And did you observe it to be loaded?
Yes.
And did you observe what type of what caliber it was and or what type of ammunition was contained in the firearm?
It was a .45 and Hornady was the brand of the bullets.
HORNADY?
Yes.
Okay. Thank you. Did you at some point enter the home at 11331?
Yes.
And was that as a part of the execution of a search warrant?
Yes.
And what's the first thing you do when you enter a crime scene?
Start taking photographs.
And do you document the entire scene first with the photographs?
Yes.
And then after you have documented the scene as it lays, what's the next thing that you do?
And then I would place down evidence markers of evidence throughout the house.
And those are the yellow tents that we often see in these photos?
Yes.
Okay. And is that the process in which you followed in this case?
Yes.
I'm going to show you what's been pre-marked as states 2 through 19. Will you review these and tell me if you recognize those items?
Yes, I recognize them.
And how do you recognize them?
They're photos that I've taken.
And with the exception of number 3, I believe that's a floor plan.
Yes.
And as far as 2 and 4 through 19, they appear to accurately depict the scene as you saw it the night you were there, September 27th, 2020.
Yes.
And then as to number 3, does it appear to accurately depict a portion of the home as you recall it from when you were there in September?
Yes.
Your Honor, this time the state would ask to enter states 2 through 19.
Got no objection.
Received. Thank you, Your Honor. So let's first look at states 2, and I'm going to display them digitally before you. And can you tell me what we see here in states 2?
Let me just ask, instead of turning down the lights, Ms. Conolin, are you able to see these sufficiently?
Yes.
Okay.
It's a little difficult with the lights on for us to see it.
Oh, it is?
Yeah.
Okay, fair enough. Thank you. I didn't want anybody nodding off.
Thank you. Ms. Conlon, I'm going to give you a pointer.
And again, sir, if you need to reposition anywhere around the courtroom, wherever you need to go to see, please feel free.
Ms. Conlon, what is it that we see here in States 2?
It's a firearm.
And what firearm is that?
I believe it is the 45.
And is that it's back in your lab as opposed to when you collected it in the home? Is that correct?
Correct.
And we see a magazine. It appears to have ammunition in it.
Yes.
And then the firearm, which has been locked back, and a holster. Is that correct?
Yes.
And then there's one round laying in this picture. Would that be if it had been in the chamber?
Yes.
Thank you. I'm going to show you States 3. This is the floor plan we talked about a moment ago. It's not the complete home, is that correct?
Correct.
When you entered the home, how did you enter?
I entered through the garage, which would be right in this area.
So that the laundry room has what appears to be 2 doorways. The bottom one would be an exit to the garage?
Yeah.
So when you approached the home, you walked through the garage?
Yes.
And what observations did you make, if anything, of the driveway or the garage as you entered?
There was a U-Haul truck. There was a pod there. There was boxes. You could tell they were moving.
And when you entered the home, did the home appear to be furnished, or did it appear as somebody had already completed much of a move out?
There was still a couch in there. There were still some furniture, but the majority was being boxed up and everything.
And we see 2 bedrooms here. Were there only 2 bedrooms in this home?
No, there's a third one, and it's past the living room, kitchen. So
Which would be the top of this picture.
Yeah,
correct?
it would be up there.
And how would you categorize that bedroom?
The master bedroom.
And then we have 2 bedrooms here on the left, one being a child bedroom and then one being Miss Benefield's bedroom. As far as you know, is that accurate?
Correct.
What did you enter the room called the child's bedroom?
Yes.
And what about it made you believe it was a child's bedroom?
Because it had kids' stuff in it, kids' clothing.
Did you find anything of evidentiary value in that child's bedroom?
No.
Did you enter the bedroom that we have on this floor plan marked as Miss Benefield's bedroom?
Yes.
And did you find Did you find things of evidentiary value in that bedroom?
Yes.
And did you document that bedroom in the remainder of these states?
Yeah. Yes.
Thank you. What I'm going to show you first is States 4. Oh, sorry. Can you describe what we see here in States 4?
I'm in the corner in the back, just taking overalls. There's blood on the floor, and there's a bullet hole right here.
And I think we have a close-up of that bullet hole once you marked it.
Yes.
That hallway there, is that the hallway we saw on the floor plan that adjoined that child's bedroom?
Yes.
Thank you. And what is on the other side of this wall where you said there's I think you can actually see the bullet hole there. And then there's a socket on the wall. What's on the other side of that wall?
The bathroom.
This is States 5. Is this the same area in the bedroom?
Yes.
And the item or the area there, that's a closet with the bifold doors?
Yes.
Okay, thank you. And when you entered the room, was the mattress up against the wall like that?
Yes.
Had anything been moved or touched to your knowledge prior to you taking the pictures?
No.
Where are you standing in this is State 6. Pardon me. Where are you standing when you take this photo?
I'm in the doorway.
Where the one we saw, the bathroom would have been on your right?
Correct.
Okay. And we see tent markers here, 1 through 6. Is that correct?
Yes.
Can you tell me what was at tent markers 1 through 4?
1 through 4 are casings.
And did you collect those items?
Yes.
And do you remember the caliber of those casings?
The 45.
And were they also the Hornady?
Yes.
Okay, I think I'm saying it wrong, but
I might be saying it wrong too.
And then I see here, there's a black tripod thing there in this top picture. What is that?
It's a light.
Okay. And that's something you placed or another crime scene tech placed there?
Yes.
Okay. And how about number 5? What is that tent marker number 5, which is near that tripod?
A projectile.
And then number 6, what is number 6 marking?
Blood.
I'm going to show you states number 7. Is this the projectile you said was at state or at number 5?
Yes.
Okay. And did you collect that item?
Yes.
Now states 8. I think you're looking back towards that wall in the hallway. Is that correct?
Yes.
And can you tell me what it is at state 7?
The hole right there.
Okay, and I'm just going to zoom in so you can. And there appears to be something below it other than your sticky number 7.
Yes.
And what is that?
It's a ruler.
Is that just for scaling?
Yes.
Thank you. I'm sorry, I got ahead of myself. Did you find any other holes other than state 7? There was a, what'd you call it, bullet hole?
Yes.
Yes. Did you find any other holes that corresponded with state 7?
Yes.
Okay, and so can you tell me about those?
So they would be in the bathroom in the cabinet. So I marked the one after that 8, and then 9 was the exit hitting the cabinet door, and then 10 is the actual on the other side of that cabinet.
So 8 would have been the back of the cabinet?
Correct.
The
Yes.
opposite side of 7?
Yes.
And then it traveled through the cabinet door, which you did as 9 and 10?
Correct.
And then did it ultimately land or strike somewhere and come to a stop?
Yes.
And where was that?
It's right outside the bathroom door.
So I'll show you states 9. Is this the frame of the bathroom door?
Yes.
And if you could just tell us what we see here.
It's going to be the projectile inside that hole.
And you mark that up.
Right, I know some people are asking for it. Right, 2 seconds. Let's just finish the Karen Reid stuff, and then we'll go back to that, because I know a lot of people are chatting about it. So this is Karen Reid's. Hang on, can you see this? And then we'll go back to it. I do not like to do this, but I know a lot of people are interested in it. So, wrong one. Wrong one. Fuck. Hang on. Let me try and make this. Let me do this way then. And then, hang on. I've got a better way of doing it. Hang on. Okay, stop. In the name of love. So, okay. So this is from Alan Jackson. I'm a partner of the Los Angeles law firm of Workham Jackson and Quinn. I've been right, fine. On Tuesday, July the 2nd, 2024, I was contacted by Juror A, true name identity withheld to maintain anonymity, based on a conversation with Juror A, and that juror's description of who she is, where she was seated, and certain identifying information, name, occupation disclosed during the voir dire process. I was able to positively identify which juror she was. Juror A told me that she was seeing inaccurate reports about the split among the jurors related to the mistrial around the court declared the day before. Juror A stated that she wished to be respectful of the privacy of the deliberative process, but did wish to inform me of the true results of such process. Juror A indicated that she believes it's important to disclose such. Hang on, let me get the next one up then. Results, because she believes that those results significantly impact Ms. Reid's rights. Juror A told me that the results of the deliberations was that the jury unanimously agreed that Karen Reid is not guilty of count 1, second-degree murder. Juror A was emphatic that the count 1, second-degree murder was off the table, and that all 12 of the jurors were in agreement that she was not guilty of such crime. Juror A told me that shortly following the determination regarding count 1, the jury also unanimously agreed that Karen Reid is not guilty of count 3, leaving the scene with injury, death. On July 1st, 2024. The jury presented a note to the court. All counsel were ordered to the courtroom. The note was not presented to counsel for review. Rather, the court indicated that the jury was at an impasse. Once the jury was seated, the court then read the jury note verbatim in open court, and without providing any opportunity for defense counsel to be heard, the court declared a mistrial and excused the jury. Neither Ms. Reed nor her counsel consented to the entry of the mistrial. Fucking Bev. Defense counsel was denied the opportunity to request that the court inquire on which counts the jury may have been deadlocked, which is common sense, including lesser included offences, and on which counts the jury may have arrived at a verdict. Nor did the court on its own inquire of the jury foreperson on which counts the jury were at an impasse, and whether the jury could or did reach unanimous agreement on any of the other counts. Had the court so inquired, it appears clear that not guilty verdicts would have been recorded for counts 1 and count 3. Ms. Reed was denied her right to receive those verdicts in her favour. The foregoing is true and correct to the best of my knowledge and belief under penalty of perjury and the laws of the United States and the states of California and the Commonwealth of Massachusetts. So there you go. That's basically what's been put in today. So, which is a bit scary because considering that they allegedly voted 9-3 guilty for vehicle manslaughter. So they're basically saying some people thought it was an accident, I imagine. No, nothing. Bev fucked it. This is Jackson's filing. So basically, this is Jackson. It's going to be the same for Yannetti and everybody. So Bev screwed up, yes. Bev should not be the judge for the second trial, if there is one for second trial. She's messed up royally here. Right. So, no, there was two. There's voluntary vehicle manslaughter. They added as a lesser charge as well, I believe, how it was worded. So, I think it's, but even if it's intentional, you can still intend to hit somebody, but by accident or whatever. There's ways they word it. It's complete bollocks. But right, let's get back to the other one now. So I've done that for you guys. Oh, sugar and spice and all things nice. There'll be more info coming out as the day goes along, people. So I'll probably cover it tomorrow morning as well, once we know a lot more. So here we go. Let's get back to this then. I do not like to cut off the stream like that, but I know a lot of people here want to see that. So do I. So, right. Here we go.
11.
Correct.
This is states 10. What do we see here in states 10?
The trajectory rods, just to show the path of the bullet.
So those are something you placed there to make sure that was the same bullet that went through those holes at number 7 and 8, 9, and 10?
Correct.
And did you ultimately dig the projectile out of tent marker 11?
Yes.
Okay. And I believe states 11 is a close-up of that hole prior to your digging it up. Is that correct?
Yes.
Okay. And then what do we see here in states 12?
That's the bullet that I dug out at 11.
Thank you. Did you find any other holes anywhere else in the home?
Yes.
Okay. And where was that?
The living room.
And did you document that?
Yes.
I'm going to show you states 13. Can you kind of orient us in the home? Or if I can switch back to the floor plan if it would help.
No, that's the front door by 16. So it's like right in the living room area.
And now that wall that we're looking at, is that, I see a window, so that's an exterior wall of the home?
Yes.
And where would the bedroom be in this photo? Or not in this photo, but where would the bedroom be in comparison to where this photo was taken?
Behind me.
And what is this small brown item. I believe we see it in states 14.
It was struck by the bullet.
And it's some kind of canvas thing.
Yes.
So this is states 14. And then states 15, is that the bullet that traveled into the living room wall?
Yes.
And you collected it?
Yes.
I'm going to just go back to states 3. If you could kind of show us on this diagram where that bullet strike was.
It would have been right here.
So that's the door we saw and the window we saw.
Right. Yes.
Thank you. Did you find and collect any other firearms in this home?
Yes.
And how many?
2 others.
And where were they located?
One was in the bedroom with the blood, in the closet, in a backpack.
And so I'm showing you state 16. Is this the closet you're talking about?
Yes.
And where's the backpack?
Right there.
And then I believe state 17, is that the firearm in the backpack?
Yes.
Thank you. Did you find, you said you found 2?
And then one was in the kitchen pantry.
And I'm showing you states 18. Is this a portion of that kitchen pantry?
Yes.
And where was the firearm?
It was below that picture. Yes.
And so that's we see a basket here, and then this is another
That's
basket.
one. Yeah, that's one. Yeah.
And so states 19, that's a firearm.
Correct.
Okay. And you collected both of them?
Yes.
Thank you. Were they both loaded?
Yes.
Did you locate any cell phones in this home?
Yes.
And did you collect them?
Yes.
I'm going to show you what's been marked as states 20 and through 22. Judge, these are entered by stipulation number 2. But are these photos you've seen before?
Yes.
And is it your understanding that they were taken by first responders when the victim was still on scene?
Yes.
And I didn't ask you, but when you arrived, had the victim already been taken away by EMS, to your understanding?
Yes.
Okay. Were you ever given any information by law enforcement to help you in your investigation about why there was a drag mark?
Yes.
And what was the information that you were given?
That's they had pulled him out to start working on him.
Okay. And is it your understanding these pictures were taken in the bedroom prior to that?
Correct.
Your Honor, the state, they were entered by stipulation, but the state would ask to publish.
All right.
20 through 22.
Yeah. Can I please have 20
I'm sorry.
I have them here if you want on the screen or not, either which way.
I can look at them here.
Okay, thank you.
Okay.
On the night of the incident, did you have any involvement with the defendant, Ms. Benefield?
Not that night, no.
And was it your understanding that another crime scene tech took photos to document her appearance on that night?
Yes.
And who was that?
It was Megan.
And Your Honor, I believe these are entered by stipulation number 4, but Ms. Conolin, would you take a look at states 23 through 26 and tell me if those are the photos you understand? It's Megan Dvorak, is that
correct? Yes.
She took those.
Yes, these are Megan's pictures.
And Your Honor, the state would ask to publish them. Would you like me to do it on the screen or would you like to just look at them?
Just to confirm, there you are. 20 to 22 and 23 to 26 are stepped in.
Yes.
All right. They'll be received.
Thank you, Your Honor. And Ms. Conlon, later, were you asked to document Ms. Benefield's appearance again?
Yes.
And do you recall what date that was?
It was the 1st
of October?
Yes.
And where did you go to do that?
At the sheriff's office.
And did you in fact take photos of her?
I did.
I'm going to show you states 27, 28, and 29.
Yes.
And are those the photos you took of her on October 1st, 2020?
Yes.
And do they appear to fairly and accurately depict her appearance that night?
Yes.
Your Honor, the state would ask to enter 27 through 29.
Any objection?
None, Your Honor.
Received.
And while you were there, did you observe any injuries to her body?
Some scratches, light bruising.
And this is 27, is that taken October 1st?
Yes.
And then this is 28, are those the scratches you were talking about?
Yes.
And 29?
Yes.
Did Ms. Benefield complain of any injuries to you that night?
She never spoke.
Thank you. I don't have anything further, Judge. The defense may.
And Judge, I just want to correct something before the defense does cross. The picture that came in as State's Exhibit number 2, it was my fault. I switched the pictures on accident. That firearm is the one that was found in the backpack in the closet, not the one that was found in the neighbor's house. But all the testimony about the neighbor's house and the gun being at the neighbor's house is accurate. It's just the picture is a different gun.
Okay. And are you going to need the pictures? Or do you want the lights back up?
I think for right now, we could have the lights back up, Your Honor.
Absolutely.
I may request that they go down.
Just let us know.
Do you want the hard copies?
Let me check. Deputy Conolin,
I'm not a deputy. Just a crime scene tech.
crime scene tech. How shall I address you, Miss Conolin?
Yeah, that's fine.
I have a few questions for you. No heavy lifting. I first want to ask you about crime scene. Your purpose as a crime scene technician is to arrive and document as accurately as possible the circumstances that you find.
Yes.
And traditionally, ideally at least, you should be the first one that enters the crime scene, if you will, so that what you document is an accurate depiction of how it existed at the moment.
Correct.
All right. In this instance, that wasn't particularly possible, correct?
Correct.
All right. And in fact, before you arrived, Douglas Benefield, who subsequently was deceased, he was moved in an effort to be worked on by not only the deputies on the scene when they first arrived, but by the EMS people as well.
Yes.
All right. So in your documentation of this scene, anything that might depict certain things could have been modified based upon prior efforts inside the crime scene.
Correct.
Now, you told us approximately, I realize going from memory is difficult. Did you write supplementary reports?
I did.
Okay. Do you have them with you today?
I do.
Good. Can you tell us approximately, feel free to refer to your notes if necessary. Can you tell us approximately what time you arrived on the scene?
Approximately, it was 8:28
8:28
in the evening.
in the evening, PM.
PM. Yes.
And your reports, Ms. Conolin, would they document what time the incident was reported or alleged to have occurred?
Not in my report, but I had the notification time that I was called, which was going to be 1937, which is 7:37 PM.
7:37.
Correct.
Okay. And would it be fair to say that notification to crime scene goes out pretty much immediately?
Correct.
All right. Because once again, you want to be first on the scene to be able to preserve it.
Correct.
Okay. So in this case, assuming that the incident occurred sometime close to 7:37, you arrived approximately an hour later.
Correct.
All right. You said something in your direct testimony that was interesting. You had entered the residence pursuant to a search warrant.
I have to wait for the search warrant. The residence I entered was the next door neighbor's residence
Yes.
to collect the gun. But
Yes. But for purposes of the incident where the shooting took place, you entered after being notified that the search warrant had been secured.
correct.
Okay. So this is what I want to establish. If you got notified of this incident at 7:37 and you arrived and entered at approximately 8:28, approximately an hour later, somewhere in between that time, a search warrant was drawn up and provided to a judge who signed it to allow you to enter.
Correct.
That's some pretty fast work, no?
That's pretty typical for our agency.
Okay, so in other words,
They're pretty used to writing them pretty quick.
okay, so the incident happens, bing bang, you put the search warrant together and you're in.
Yes.
Okay. Now, just so we're clear and there's no confusion, and I don't mean to imply in any capacity that there was any sleight of hand involved. The actual weapon that was pictured in the slide was the gun that came out of the backpack,
Correct.
which I think is a 6-hour.
The backpack was a 380, yes, 6 hour, I believe.
380.
It was a 380 in the backpack,
Right, not the 45.
not the 45.
Okay. And the photographs that were taken of Miss Benefield, some were taken that evening, correct?
Correct.
And then there was another opportunity to take a second set of photographs a couple of days later on October 1st.
Correct.
And why would there have been a second set of photographs taken on October 1st?
To see if any more bruising would come up, better pictures.
Yeah, in other words, a lot of times bruises are not readily apparent immediately and they develop over the course of a day, 2, 3 days.
Correct.
Okay. Now, give me just a moment, please. Next. Next picture. Yeah.
She's on bail, little G. She's on bail. How much the bail is, I don't know, but she's on bail. Unless in last year she's come back in, but I don't think she has.
All right, Ms. Conolin, I want to ask you a few questions with the help of my very able-bodied assistant, Mr. O'Keefe. And we're going to put a few of those photographs up. I want to ask you some questions about them.
If you're going to refer to any that are already in evidence, I prefer we use the ones that are already marked. If there's additional ones, then obviously you can lay the predicate or get a stipulation for admissibility.
I just want to see.
Good. All right, Ms. Conolin, let me direct your attention to the exhibit that is now up on the Elmo. I want to ask you, with respect to Ms. Benefield's left side of the face, specifically the left eyelid, does that appear to be the same size as the eyelid on the right, or does it appear to be swollen?
Objection.
Yeah, I'm going to sustain. I mean, I can see that for myself. I don't need the witness to narrate what the evidence is, unless there's something specific that you want to draw out about it, but.
No, that's fine. The only other question I was going to ask was about the left cheek, Your Honor.
Okay, but I also think that she didn't take these.
I understand.
Okay, go ahead. So I'm going to sustain.
Okay. With respect, Ms. Conolin, to Ms. Benefield's left cheek, do you see that as swollen as compared to the right cheek?
Sustained.
All right. Next. This was a photograph that was taken when?
That was the first night.
Okay. And this was taken by you?
No, that was taken by Megan.
By Megan. Are you familiar with this photograph?
I am.
All right. Does this photograph, it's hard to depict in this exhibit under the Elmo. Does it show whether or not the scratch?
Objection, Judge.
Yeah.
Well, I understand, but let him finish the question. I don't know where he's going. It's not uncommon for lawyers to start this way and make a, not wrong turn, but left turn.
I'll
Go ahead.
withdraw the question.
No, ask your question, please, but I don't know where it was going.
I understand, but I also know what the ruling is, so.
If it's
yeah.
just to narrate
Out of
what's,
concern for the court's time.
yeah, I
understand.
mean, and then you can argue that, certainly.
I'll be able to argue with you.
Absolutely.
Yeah.
100%.
Okay, thank you.
Redirect?
Yes, briefly. Ms. Conlon, in your many years at the Sheriff's Office, you've responded to homicide scenes regularly.
Yes.
And is it your understanding from your experience that a lot happens prior to your actually getting called out?
Yes.
And so if you get a call out at 7:37, you can't say how long law enforcement had been on scene prior to your getting there, can you?
No.
Because in theory, patrol arrives first.
Correct.
And at some point, there's a determination that there's a homicide before the homicide unit gets called out.
Correct.
And are you next in line after the homicide unit?
Yes. Yes.
And you're not the person writing the search warrant. You just wait before you enter.
Correct.
Okay, thank you. Nothing else, Judge.
Sir? All right, can this witness be released, State?
Yes.
Mr. Taylor? All right, maybe releasing your subpoena. Thank you very much.
What are we thinking so far? How are we finding it, people? Are you enjoying this or not? I like this, Judge. Oh, Heather. Oh, crops. What have we done there?
Because I don't think you can, the witness needs to point out things while you're looking at pictures.
I can see right here. I'm not going to get in the way of you presenting your case, but I'm fine if you want to put them on the overhead, and I'm fine if the witness is sitting right here and Mr. Taylor could approach as well and see exactly where things are being pointed to without putting up the photos. Either way.
Just to remind Your Honor, we have the Talbot motion pending as to this witness.
Correct.
Do you solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth?
Yes, I do. Well, Dr. Vega is sitting down. The way I read the motion was specific to one particular injury.
Correct.
So let's do this. When we get to that point, and please feel free to disagree if you want. I think when we get to that point, object, so it's preserved, you have your contemporaneous, let the testimony finish, then you can cross on that, and then whether if I let it in, it's all there. And if I agree with you that the foundation hasn't been laid, or it's otherwise not admissible, then it's still proffered and it's in the record. Would that be okay?
Yes, sir.
Okay. Hello, sir. Make yourself comfortable in the chair, 12 to 15 inches from the microphone. Loud, clear voice will pick up everything, and it does adjust up, down, left, right. Thank you.
Thank you, Your Honor.
Good morning.
Good morning.
Please state your name.
My name is Russell Scott Vega. The last name is spelled Vega.
And where do you work?
I'm the Chief Medical Examiner for the 12th District of Florida, and that includes Manatee County, where we are now.
And what is the 12th Circuit?
It includes 3 counties, Manatee, as well as Sarasota to our south and DeSoto County to our east.
And you said Chief Medical Examiner. So what does that mean?
That means in the medical examiner's office, I supervise the other medical examiners. I set policy. I basically manage the office.
You're the boss.
Yeah.
Okay. And what is your education to do the job that you have?
I started in undergraduate, majoring in physics and biochemistry at Florida State University. Then I went to medical school after that, University of South Florida in Tampa. After medical school, I did 2 years of training in general surgery and then 4 years of training in anatomic and clinical pathology, and then a year of subspecialty training in forensic pathology.
Hold on one second. I'm sorry.
Out of respect to the court's time and to Dr. Vega, whose credentials I'm familiar with, we're happy to recognize him as an expert.
All right. Do we willing to stipulate or accept that stipulation?
Yes, I do have a few more questions about specific things that he's done, though.
Okay.
Okay. And how long have you been the Chief Medical Examiner, if I didn't ask you already?
It will be 20 years, October 1st.
Okay. As part of your duties as a Chief Medical Examiner, do you still perform autopsies and do the work that your other medical examiners would do?
Yes.
Okay. How often would you say you perform autopsies?
I'm on the schedule every month, so not necessarily on a weekly basis, but certainly on a monthly basis.
Okay. And over your career, how many autopsies would you say you've done approximately?
Yeah, I don't have an exact count, but probably in the 3,500 to 4,000 range.
Okay. How many of those approximately would you say are gunshot wounds or contain some aspect of a gunshot wound?
It's in the hundreds, but I wouldn't be able to tell you more than that.
Is wound interpretation part of your duties as a medical examiner?
Yes.
Okay. And what exactly is wound interpretation other than exactly what it sounds like?
It's being able to examine a body and identify injuries present on or in that body and be able to, in that identification, determine what the nature of the injury is, possibly what kind of implement, tool, or weapon was associated with inflicting that injury, and other things about the nature of the injury, such as when it occurred or things associated with the circumstances under which the injury was sustained.
Okay. Did you do the autopsy of Doug Benefield?
Yes, I did.
And when was that?
That autopsy was on September 28th of 2020.
Okay. And generally on Mr. Benefield, how many wounds did you find?
I found 2 clear gunshot wounds, 1 possible gunshot wound, and then 2 other separate smaller injuries, 1 to the head and 1 to the back of the thigh.
Okay. Were pictures taken during this autopsy?
Yes.
Okay. I'm going to show you States Exhibit 30 through 38. You can just take a look at these. Oh, because I think it's set to that. Statement entering the evidence state.
These are photographs that were taken at the time of the autopsy of Mr. Benefield.
And do they accurately reflect the autopsy as you recall, parts of the autopsy as you recall?
Yes.
Statement entering the evidence states 30 through 38.
Objection?
No.
Received? Are you going to publish them now?
Yeah.
Folks, the state is about to publish photographs that were taken during an autopsy. I would imagine that most people here probably have never attended an autopsy or seen photographs from an autopsy. I didn't see them, but I don't think they're the full autopsy.
No.
I would assume they're external
Yes.
photographs.
Yes.
However, for those of you who may have an emotional connection.
Okay, so trigger warning for all of you people. There'll be photos. I'm not sure how much we'll see, but here you go. Turn your computers off if you don't want to see it.
Just so we understand who we're talking about, is this the patient, Doug Benefield?
Yes, this is a photograph of the decedent.
The decedent.
Mr. Benefield, from the essentially mid-chest up.
Okay. And I'm going to show you the next exhibit, states 31. Can you tell me what we're looking at here?
Yes, so this is the decedent's right arm and the right side of his chest. And this shows 2 injuries, really. 1 superficial injury to the right arm. And I can use the laser pointer if you like. Okay.
Judge, this is the wound that's the subject of the motion.
Understand, I'm going to reserve on the objection. And once I hear it, then I'll make a final ruling. But yes, noted.
So we see 2 injuries here, 1 on the chest here and 1 on the right arm. The chest really is a more complex injury. There are really 3 components here. There is what was circular gunshot perforation here. There is an incision that was made by doctors who were treating him in life-saving measures that was made from the edge of the gunshot wound downward here. That was to insert a chest tube or tube to relieve pressure and blood from the chest cavity.
And I didn't ask you this, but sometimes people are pronounced deceased at a scene, and sometimes that happens at the hospital after medical intervention. And I think you've answered this, but which type was this?
This was the second type.
Okay.
Yeah.
So he had signs of medical intervention.
He did indeed.
And are you trained to identify that as opposed to an injury?
Yes, I am.
Okay. You can go ahead. So the top of that chest wound would be the bullet, more of the bullet entry wound.
That's right.
Okay.
That's right.
And then go ahead.
In addition to that, there's also there is some bruising that's evident in the skin around that hole. And then separate from that is the arm wound here.
Okay. So let's talk specifically about the chest wound first.
Yes.
So this wound, I don't know if you said it first or if I said it first, was an entrance wound. How do you determine the difference between an entrance wound and an exit wound of a firearm?
Well, there are characteristics of the hole in the skin itself that can be helpful in that regard. But the easiest way to be able to tell the difference between an entrance and an exit is if you have one hole and the projectile still in the body and you have a track between those 2 points.
Okay.
That's what we have here. So that helped me be very confident that this was an entrance wound.
That's the entrance wound.
If you have 2 holes and no projectile, usually it's pretty clear, but it can be a little bit harder.
Okay. But in this case with the chest wound, was not difficult.
That's correct.
Okay. So this is State's Exhibit 32. It's a closer up image of the chest wound. Can you just point out where the bullet injury would be?
Yes, that's right here.
Okay. And then State's Exhibit 33 is the back of Mr. Benefield, and there's a lot of discoloring at the top of the shoulders and the lower back. What is that?
Yes, so you're correct. This is his back, and for clarification, this is the neck and the back of the head, the left ear, and there's this pink purple discoloration here, but especially up here on let's just say the shoulder regions. That's lividity. Lividity is the pooling of blood that occurs in the body after death. That part of what we see is not injury or in any way related to what happened to him prior to his death. It's simply essentially what we would call an artifact or a postmortem finding.
Okay, so this is the darkness that we're seeing here is just sort of a natural process.
This here and this here. That's correct.
And what about this picture is not a natural process?
Within this area that's not discolored, and the reason for that is that there was pressure on the skin here that prevented the blood from pooling after death, so that's why it's more pale. But in the at least contained within that zone is this smaller, darker purple area, and that is not lividity or a postmortem finding. That's associated with injury.
Okay. Did you inspect that area to find out what it was?
Yes.
Okay, and what was it?
I could palpate, I could feel a lump under that area of the back, and upon further examination by cutting the skin and examining underneath, there was a projectile there.
Okay, so I'm going to show you States 34. What are we looking at here?
This is a photograph that was taken after I had done the incision and essentially uncovered the projectile that was in the subcutaneous tissue, the tissue under the skin.
Okay.
And that's the projectile right there.
And during the autopsy, were you able to connect the path of the initial hole to this projectile?
Yes.
Okay. And if you could just explain what it went from which side to which side?
So referring back to the photograph, if you will, we don't have to show it, but it was on the left side of the back, and the entrance wound that we saw was on the right side of the chest.
Okay.
So the path that the bullet took was across his chest from right to left.
Okay.
It was also somewhat from front to back. In considering a standing position, it was horizontal, roughly, meaning that the entrance wound was at the same height above the ground, if you were standing, that the bullet was found. So there was no significant upward or downward trajectory through the body.
Okay. So on that plane, it was fairly horizontal. It didn't go up or down much.
Yes.
Okay. So I just want to, I can either do it on myself or you can do it on me. So, or I can do it on me. Point to where the entrance wound would be on you.
So on me, the entrance wound is basically where I'm pointing now.
And then the exit wound or where the projectile landed would be where?
Back here. I probably can't point quite as accurately on myself there. But
Okay. So there was a definite right to left motion of this projectile.
definitely a right to left trajectory through his body.
So the next photo I want to show you is States Exhibit 35. This is a different wound. This is the arm wound. Can you tell?
This is the arm?
Yes, this is the arm.
Yes, sir. All right, reserved.
And what can you tell me about what we're looking at here on the arm?
So the arm wound is a superficial wound. It's essentially a scrape of the skin. So the surrounding skin is normal, right? And then this area, the superficial part of the skin, what we might call the epidermis, and maybe a little bit of the skin underneath that, of the dermis underneath that, has been scraped away, and it leaves this red, irregularly shaped wound here.
Okay. And you said relatively superficial. So what does that mean?
That means that outside of the skin being scraped away, there's no deeper injury, there's no additional damage, there's no underlying injury to the bone or the soft tissues, there's no bruising. It's just this scraping of the skin, and that's it.
And being that it's superficial, does that limit your ability to determine where it came from or what it's from?
In this case, I would answer that yes. In general, sometimes the pattern or the nature of the appearance on the skin can give you a very clear idea of how that injury occurred. But in this case, it's a relatively irregular and what I would say not characteristic of any particular mechanism of injury.
Okay. If you had to make an educated decision about what you think this is, what is your opinion about that?
I think more likely than not, it is a.
I understand. I'm sorry, just we have to get objections on the record. I'm
Sorry. Go ahead.
Certainly. More likely than not, it is a what I would call a grazing gunshot wound. Grazing gunshot wounds are wounds that just barely scrape across the skin in their path rather than going into the body. And so they leave a scrape pattern on the skin where they do that. Grazing gunshot wounds sometimes, frequently, have a much more characteristic appearance. And this one did not really have those characteristics. But given that we have 2 clear gunshot wounds in the body, and this additional injury could be, by its appearance, a grazing gunshot wound, I think it more likely than not that it is.
Okay. And you said it's not typical of a graze wound. What do you mean by that?
A typical grazing gunshot wound looks like a furrow or a trough across the skin. It's long, narrow, and typically it has characteristic shapes at either long end and has skin tag tears along the long edges, if you will. And this really didn't have any of those characteristics.
Okay. So that made it difficult to determine exactly what it was.
Yes.
Okay. Then I want to move to the leg wound. This is States Exhibit 36. If you could orient us, what are we looking at here?
So this photograph is taken with the leg turned, and you're looking at the back surface of the leg. And when I say leg, I'm referring to the calf. So the part of the lower extremity, which is below the knee. So this is essentially where the knee is here.
Facing away from the camera is where the knee would be.
Correct. And behind the gloved hand. So this is the back of the calf, and the body here is turned over. So it makes the orientation a little bit more, I'm sorry, the leg is turned over, so it makes the orientation a little bit harder to see.
Okay.
But this is the back of the right leg, and the injury itself is, the hole here that's on between the 2 parts of the ruler.
I'm going to zoom in on this. So if you could tell us, can you tell, first of all, is this a gunshot wound?
Yes.
And is this an entrance wound or an exit wound?
This is an entrance wound.
And how you tell it's an entrance wound?
An entrance wound typically has a round or oval shape based on whether or not the projectile is going into the skin from a perpendicular, straight-on orientation or at somewhat of an angle. The angle creates the oval shape typically, and this is an oval shape here. It has some scraping or abrasion at the edges of the wound here, and those characteristics are typical for an entrance wound.
Okay. So you mentioned oval shape is indicative of a projectile coming at an angle?
Yes.
So that would be as opposed to maybe from side to side of the calf, it is at some sort of an angle.
Well, it could be side to side as a comparison, but the main thing is to think of it as not being at a perpendicular angle to the skin. So that angle, you could have an oval which is horizontally oriented because the angle is like that to the skin.
Yes.
Or you could have an oval which is vertically oriented, like this one is, because the angle is up and down related to the skin.
So with reference to this entrance wound, assuming someone were standing, so that would be the normal anatomical positioning?
Yes.
Okay.
Yes.
So the angle of this entrance wound would be coming from which direction? Coming from where?
From below the level of where the hole is. So it would be coming from essentially the floor.
Okay. So if someone were standing and someone were laying on the floor, they could shoot up and maybe get this angle.
Yes.
We're not saying that's what happened. It could happen.
Yes.
Okay. So I'm going to show you the next, which is States, I have to close it. States Exhibit 37. What are we looking at there?
So this is the right leg seen from a different perspective. We were looking before at the right leg twisted from the left side of the body. Now we're looking at the right leg untwisted from the right side of the body.
Okay, so when you say twisted, as we're looking at that leg now, when you took the picture before, twisted this way, you mean?
Yes. And
Okay.
Let me.
You could show.
It was rotated like this.
Perfect.
So that you could see the back of the leg.
Thank you. So now the leg is flipped back, and what are we looking at here?
So this is the right knee here. This is the right leg, right foot, and this is the exit hole for the gunshot that started with the entrance that we just saw previously, and that's just below, but basically on the side of the right knee.
And I have one more picture, a little closer up of this. So well, let me back up a minute. Where would the entrance wound approximately be on this picture?
So the entrance wound is back here at more or less this level, where we can't see it because it's on the underside of the leg. And even if this rail were not here and you could see the entire leg, you probably wouldn't see it because it's on the back of the leg, not the side.
Okay. And then the last picture that's a little closer up, I just want to ask you, how can you tell that's an exit wound?
As opposed to the previous entrance wound that we saw, which was an oval hole, this looks more like a tear in the skin, and that is characteristic of exit wounds. This tear is irregular and V-shaped. Exit wounds tend to have non-predictable, irregularly shaped tears in the skin, and this is pretty common appearance for an exit wound. And as I described previously when we were talking about the chest wound, being able to pair two holes together, the sort of features that make one hole an entrance and one an exit are amplified when you see the two together, and one is characteristic of an entrance, the other is characteristic of an exit. That makes it a much more certain determination. Sometimes you have two wounds, both of them can look more like entrances, and then it might be hard to tell which is which. They might look more like exits, depending on individual characteristics in that particular case. But in this case, pretty straightforward. The one we previously described looks like an entrance. This looks like an exit, so that's the pairing.
Okay. And the path went straight through.
Yes.
Did the projectile hit bone, or was it just tissue?
It did hit bone.
Bone. Okay.
Yeah.
So if you could just verbally say, what was the directionality of this wound path?
So this wound traversed the leg in an upward angle from the back toward the front, and also from the left toward the right.
Okay. So are you able to, let's assume that there were 3 shots. Let's assume that one's a graze wound. So one shot was found inside the body, one went through and through the leg, and then there was a graze wound. Are you able to say which one of those happened first?
No.
Okay. And why not?
Sometimes wounds that are in the same part of the body, especially say gunshot wounds through the head, the fracture pattern can tell you that. But if you don't have something like that, there aren't physiological features that allow you to time them unless there's been so much time between that there's healing, for instance.
Right.
So there was none of that here.
Okay.
So there were just simply no physiological findings that would allow me to tell which came first.
And also, do you have limitations on being able to ascertain where the shooter was versus where the victim was when shots were fired?
Well, one thing that being able to determine an entrance and an exit through the body, or in the case of the chest wound, the entrance and the location of the projectile within the body, it allows you to determine the relative position of the gun when it was fired relative to the body of the decedent.
Okay.
So that gives you some of that information, but not all of it, because a gun can be held in different ways. It can be held toward the body or away from the body. It can be held at different heights and locations relative to the shooter. So some information, yes, but not. It doesn't allow you to tell you entirely where they were relative to one another.
If it can tell you where the gun is in relation to where the body is, it doesn't necessarily tell you where the shooter's body was positioned, only that the gun must have been at this angle. Is that what you're saying?
Yes.
Okay. So it's kind of confusing. So let me give you an example. We'll talk about the leg wound. It was right leg, correct?
Correct.
And it's going from here out here.
Correct.
Okay.
Yes.
At an upward angle.
Yes.
So if I were to be standing here, someone would have to be on the floor to shoot up my leg, right? At that angle.
More or less, yes.
Okay. How about if I were falling this way and someone shot? Could that angle be duplicated?
Yes. especially if you fell backward and really externally rotated your leg out to present the back of the calf to a gun that might be firing well to your left.
And is there a scenario that could work where the calf or the knee is bent in this direction and the shot comes from behind?
Yes.
Okay. One moment. Did you do any toxicology on Doug Benefield, on the body?
I took samples and submitted them to the lab for toxicology analysis, yes.
And were there any drugs or alcohol in his system at his death?
No.
I wanted to ask you a question about the chest wound. What organs did it hit, or what important things did it hit?
So the projectile path went through the chest wall on the right side, and then it hit the right lung. It went through the vertebral body or vertebral column of the spine. Did not appear to hit the spinal cord in that track. After passing through the spine, it then hit the left lung, and then went through the chest wall on the left side to end in the tissues where we found it.
And do you think that type of injury would incapacitate someone immediately?
It certainly could. These things are, it's not easy to, really accurately predict, because different people have different responses to the shock of the trauma and the pain and debility that would occur immediately. But there was nothing about the injury that would absolutely cause immediate incapacitation, like an injury to the a clear injury to the spinal cord.
Severed spinal cord.
Right. Or a severe traumatic brain injury, or maybe even a severe injury to the heart. Those things you typically would expect to have near immediate incapacitation from. This didn't have that. So potentially, could there have been some activity, some ability to take some purposeful movements or motions or things? I think it's possible.
Possible, but probably not likely.
Not likely to do a great deal. I think, in my experience, most people who suffer injuries like this do fall pretty quickly from the place where they're shot.
Okay. And were you able to determine the cause of death?
I was, yes.
And what was that?
I determined the cause of death to be the gunshot wound to the chest that we've been describing, with perforations of the lungs, and the medical term I use is hemothoraces. That's blood accumulations that are occurring in the chest cavities around the lungs on the right and left sides.
Okay. And I noticed that you didn't mention that you had mentioned earlier that there were a couple other injuries, one in the head and one, I don't remember where you said it was, but I noticed that those didn't play a part in that cause of death. What are those injuries?
So there was an injury to the back of the head, a typical scraping and bruising injury that we might see from someone falling and striking the back of the head.
Okay. So if he were shot and then did fall, it might do that to his head.
Yes.
And where was it located on his head?
Essentially what we would call the occipital protuberance, or the back of the head, where I'm putting my hand now.
Okay. And what was the other injury you observed?
The other injury was a very minor injury to the back of the thigh, really barely noticeable. I don't really have an opinion as to what caused that injury, but it wouldn't have been anything that was debilitating or causing any problem, and certainly wasn't associated with the cause of death.
Okay. And is it possible that that injury was inflicted or he had that injury at a different time?
I mean, it's possible. I didn't see clear evidence of healing in that injury, but it could have occurred outside of the circumstances of the shooting.
Okay. So the cause of death was that chest gunshot wound. What was the manner of death?
Manner of death, I determined to be homicide.
Okay. Thank you. I have no other questions.
Mr. Taylor. And again, for my purposes, I consider your objections to the right bicep wound to be preserved, even though I know you're going to ask questions about it. I consider it preserved.
Yes, sir. Thank you. Afternoon, Dr. Vega.
Good afternoon.
Nice to see you again. I have a few questions I'd like to ask you. I want to start, if I can, with the wound to the chest.
Yes.
what made the projectile, otherwise known as the bullet, you said that the track of the projectile was from anterior to posterior, front to back, and right to left, correct?
Yes.
All right. Were you able to determine what caused the bullet to take the turn from right to left? Did it deflect off bone, a rib? Do you know?
There was no deflection. The trajectory of the projectile prior to entering the body did not change significantly in terms of how it passed through the body.
Okay. Now, if you were going to scientifically determine the trajectory of this bullet, which you've told us is front to back and right to left, you know from your examination that you recovered the projectile from the back of the deceased, correct?
Yes.
So you would be able to show scientifically the entry wound, which was approximately where the right below the nipple, and trace the path through the body where you come to find the projectile lodged in the back. Correct?
Yes.
All right. And with respect to the wound to the leg, from the interior of the right leg, which exited the posterior, the outside of the knee, you showed us the entry hole and you showed us the exit on the outside of the right knee. Said that they were typical of these types of gunshot wounds, and you would theoretically be able to trace the path of the trajectory of the bullet from the entry to the exit, correct?
Not even theoretically. I mean, I was able to make that
As a
that
fact.
track. Yes.
Okay. And I think to add even more measure to it, a projectile was recovered that was tested that had blood on it that came from the shot to the leg.
There was a fragment of projectile that I was able to recover from that path through the leg. Yes.
And if matched with the remainder of the projectile, which was in the room, it had a small piece missing, equivalent to the fragment that you recovered in the wound for the knee.
That's possible. I'm not aware of the analysis of the projectile that was in the room that I never examined.
Okay. Now, with respect to the wound to the arm, we don't really have any facts that we can lay out equivalent to the wound to the chest, for example, or the wound to the knee. Correct?
I think the observations are much more limited. There's much less data there to look at to try and make a determination.
Right.
Yes.
Which is why you can very candidly describe this as a probable grazing gunshot wound.
Yes, that's the terminology I used in my report.
Yes, because you weren't certain.
That's correct.
All right. And as you sit here today, you're not certain.
That's correct.
All right. So what allows you to conclude that it may be a grazing gunshot wound is your experience?
Yes.
Okay. Do you remember I had the privilege of sitting with you and taking your deposition?
I do.
That was testimony under oath.
Yes, sir.
All right. And we talked about the wound to the arm. And I had presented you with, I think, 5 medical authorities that suggested that these type of wounds are always difficult to determine, and you agreed with that.
I remember the discussion. I don't remember the specific number of people that you might have gotten opinions from or such, but yes.
But you would agree, as you sit here today, that they are difficult wounds to determine.
Yes.
Okay. And in fact, I had asked you at your deposition how you determined the nature of the wound, and you corrected me and said you hadn't really determined the nature of the wound, which is why you described it as possible.
Yes.
All right. I want to ask you a couple of questions, if I may, Dr. Vega, about homicides. Not all homicides are crimes, correct?
Correct.
We have what's known as justifiable homicide, where, for example, a homeowner shoots an intruder at night in their home. example of a justifiable homicide, correct?
Certainly could be.
All right. And we have excusable homicides where a law enforcement officer, and arriving on a scene, encounters the perpetrator who has a weapon, and the law enforcement officer shoots and kills the perpetrator. That's excusable homicide.
It sounds like it could be, yes.
All right. Do the absence of defensive wounds, Dr. Vega, necessarily exclude aggressive behavior?
No.
Okay. So somebody could be the aggressor and still not have defensive wounds.
I think that's possible.
All right. It also does not exclude the aggressor being the one that initiates a confrontation, does it? The absence of defensive wounds.
No.
You told us, again, very candidly, that you cannot, at least in these circumstances, determine the order of the shots with any reliability.
That's correct.
You've previously testified, and I would assume it's your testimony here today, that the deceased was facing the shooter at the time that the chest wound was suffered.
Yes, although based on the right to left component of the trajectory, the weapon would have been to the decedent's right side.
Facing, but not directly.
Correct.
Okay. Your autopsy report, you have it with you?
I do.
Okay. You might remember this off the top of your head in preparation for today's testimony. The examination was completed on September 28th, 2020, correct?
The autopsy was performed on that date.
Yes. The autopsy examination.
Yes. There are components of the autopsy, though, that were not done on that day. For example, toxicology and the microscopic examination. That requires tissues to be processed into glass slides, and then glass slides have to be delivered. And then I look at them when I have the opportunity. I add those findings to the other findings that I got the day of the autopsy, and that all goes into compiling the final report.
All right. And you signed off on the final report, did you not, on November 3rd, 2020?
I did, yes.
Okay. As the medical examiner, and you're the medical examiner for not only Manatee, but also Sarasota County, correct?
And DeSoto, and right now, Charlotte County as well.
Find yourself a little busy. Do you have a working relationship with law enforcement?
Yes.
All right. That's pretty much the nature of the position, is it not?
It is.
All right. Do the detectives and the law enforcement personnel generally wait to hear from you, or do they periodically check in and say, so what do we got, Doc? Do you have a tentative opinion that you can give me? Is there any of that takes place?
It depends on the nature of the case, but certainly some cases there may be no communication at all until our final report comes out. In other cases, there may be discussions at various points during the evolution of the case from the autopsy to the final report. It very much depends on the nature of the case, the needs of law enforcement, et cetera.
Sure. So, for example, like a poisoning allegation, that may be something that you're not in a position to give any kind of tentative opinion until the toxicology comes back.
That's possible.
All right. And a shooting, on the other hand, if they were to call and ask you, I got one question, Doc, was he facing the shooter at the time he was shot? That's something that you might be able to answer earlier.
Yes.
All right. I would not expect you to independently remember whether or not on any particular case you got any calls from a particular law enforcement officer to ask such an inquiry. Is that a fair assumption?
On an individual case, it would probably be difficult to remember every conversation of that type, yes.
Okay. And the scalp wound that you told us about is the type of wound that you said is consistent with somebody falling and striking a hard surface.
Yes.
Like a tile floor.
Yes.
Okay. So let me see, using this anatomical dial, if I can for a moment, I want to ask you about the leg wound. May I approach Dr. Vega, Judge?
Yes.
So, well, I was impressed with how easily you were able to put your leg up on the bar. Using this anatomical dial, if the individual that was shot was falling backwards and their legs went up in the air like this as they went back, would the trajectory of that leg wound be consistent with a shot to the leg that would go on the inside of the calf and exit on the knee?
If the leg were raised above the plane of the body while the body was falling, there's probably a location at which that angle could be produced. And I want to make sure I got the right predicate here, if you will. You're sort of assuming from the same position that the initial shot to the chest would have been fired. Is that accurate to say?
Well, again, like you, I can't say what the order was, but if there was a loss of consciousness and incapacitation and the individual were to start falling backwards, at some point in time, would the leg not be up where it would be consistent with that angle?
In addition to the body falling backward, the hip would have to be flexed and the leg would have to be brought in front of the rest of the body. If that were to happen, then yes, that angle could be produced.
The last question I have for you, Dr. Vega, is I want to ask you about the study of wounds. As a medical examiner, you're constantly called upon to examine various wounds and extrapolate how they were incurred, correct?
Yes.
All right. And that is, correct me if I'm wrong, a science in and of itself, is it not?
I mean, it's a field of study, so I suppose the term science is appropriate, yeah.
So we have, for example, crime scene people who study wound ballistics and the interaction between a projectile moving at a high rate of speed and human tissue and skin. Those are some of the things that you're called upon to interpret as well.
Yes.
Okay. Give me just a moment, Your Honor.
Of course.
Of the shot to the leg. Hypothetically, if somebody were to throw a karate kick with their leg or an attempt to kick, might that also be consistent with the trajectory of the wound to the leg?
It would have to be a unique kind of kick to, from the front in a standing position, be able to expose the back of the leg. But I suppose it is possible if the leg were raised high enough that the back of it were exposed to the person who's facing that individual, that it could happen.
Thank you. Nothing further, Your Honor.
Yes, sir. Any redirect?
No, thank you.
All right. Can this witness be released?
Yes.
Yes, sir.
All right. Do you also have him under subpoena? Do you need him
under subpoena?
You okay? All right. Yes, ma'am. Go ahead.
We have another witness that is fairly quick, or we can break.
I would just keep going through, but I'm known to do that, and it's not well received. So how long do you think? I mean, I know for your direct, but I don't know how long the cross is going to be. So who is it?
It's a unit manager, the crime scene tech, Rich Talbot.
Oh, Mr.
And
Talbot.
it's just as to the stippling or lack thereof on the shirt. I have about 6 pictures.
Yeah, I think we can do that.
All right. Miss Sarah, can we do one more?
Yes, sir.
Do you need to stretch for a minute?
No.
Okay.
Good, thank you.
All right. Let's get this.
How are we finding it, people? How are we finding it? Hey, Vixie, welcome back. How are you finding this trial? I know it's a little bit boring, the hearing, but it's just giving you a little basis of what it's going to be like on the 22nd. So yeah, shit timing though. The Karen Reid motions had to come out right when we're doing this, so I know a lot of people. I was scrambling to look at all that, but yeah, I think this is going to be a good trial. I think.
I don't mean to put you on the spot. Any issues with education, training, experience?
Maybe.
Okay, so let's go ahead and put that all on. Go ahead, ma'am. Sir, as the deputy said, 12 to 15 inches from the microphone, loud, clear voice should be fine. If you need to adjust it, please feel free to do so.
Okay, thank you.
Good afternoon.
Hello.
Please state your full name and spell your last name for the record.
Rich Talbot, Talbot,
And by whom are you employed?
Manatee County Sheriff's Office.
How long have you been so employed?
For about 23 and a half years.
And what are your duties with the sheriff's office?
I'm in charge of the crime scene unit, so I run the day-to-day operations of the unit. And that can entail anything from assigning and reviewing cases to responding out to a crime scene. I'm responsible for supervisory type issues. And then sometimes I also do crime scene processing as well if they need it.
So sometimes you function as a crime scene tech?
Yes.
Okay. And how long, your whole 23 and a half years, has that been as a crime scene tech or therein the manager?
Yes, I spent 2.5 years as a regular technician and I was promoted to supervisor.
And during the whole 20 plus years after becoming supervisor, you've continued to work as a crime scene tech?
Yes.
And can you tell me a little bit about your education to become a crime scene tech?
Yes, I have a degree in criminology, a bachelor's degree in criminology. And once I got hired here at the sheriff's office, they have sent me to, I have about 300 to 400 to almost maybe 500 hours of job specific related training courses.
And has that continued throughout your time at the sheriff's office, even more recently when you've been functioning as a manager?
Yes, a lot of the time was in the first probably 10 to 15 years that I was here, and then but our training goes more towards the newer technicians now, and now it's more supervisory type classes that I attend. Yes,
sir. And has your training included using an infrared camera?
Yes, I attended a training class for that.
And what is an infrared camera?
An infrared camera allows you to actually create a contrast between the surface that you're looking at, the item, may it be clothing or skin, and it creates a contrast and it takes some of the colors out of the item you're looking at, and the substance that may be on the clothing or on the skin, it enhances that.
And that's a type of camera the sheriff's office possesses?
Yes, we do have one.
And you have used it regularly over the years for testing?
Yes.
And do you have to use an alternate light source? That's a mouthful for me, I'm sorry. To take the photos, or is it something that the camera does itself?
No, the camera actually, there's filters put on the end of the camera lens, and we hold a small infrared flashlight that actually you shine on the surface of the object that you're looking at, and then the camera takes the picture.
I see. So we'll come back to that, but I want to take you back to September 27th of 2020. Were you working that day or on call at least?
On call.
Okay. And did you respond to a scene at 11331 White Rock Terrace?
Yes, I did.
And was that as a supervisor?
Yes.
But while there, did you assist crime scene tech Amanda Conolin in some of her scene processing?
Yes, I did.
And did that include the trajectory rods?
Yes.
And so on that date, were you present the entire time Ms. Conolin was there processing the scene and learning along with her?
Yes, I was.
Thank you. Did you at some point a couple days later return to the scene to do some additional work?
Yes, we did.
And what was that for?
That was to go out and complete a scanning of the crime scene utilizing a ferro-terrestrial laser scanner.
And was that completed by yourself or another crime scene tech while you were there?
The main person completing that was CST Rudolph.
On about a week later, I guess, on the 6th of October, were you asked to actually process some items in the lab?
Yes, I was.
And what were you asked, or what did you assign yourself to process?
Essentially, there was a shirt that the victim in this case was wearing at the time of the incident, and I was asked to examine that shirt for any gunpowder residue or anything like that, stippling.
And what is stippling? And let me ask you this. Through your time as a crime scene tech and the unit manager, have you dealt with a lot of gunshot cases?
Yes, we have.
And have you received training and experience in things such as soot and stippling?
Yes, the training and experience is a lot of different cases that have involved that.
Yes, sir. Okay, so what is stippling?
Stippling is small particles that are that come out of the end of the barrel of the gun, from the ammunition, and depending on the range of the gunshot, the firearm from the surface of whatever it's striking, it's basically small particles that will show a pattern or of burn marks or little particles that are land on that surface.
Because correct me if I'm wrong, when a gun is fired, I call it a bullet, the projectile leaves the end of the barrel.
That's correct.
And with it, gunpowder, which has made it go bang, might also exit.
Yes.
And is it your understanding from your training and experience that at certain distances that gunpowder could land on a victim or clothing on the victim and leave some residue?
Yes.
It's a bit leading, so.
Okay. And so what is soot?
Soot is just a like a burn mark or something like that the powder is leaving on the skin or the clothing or stuff like that.
And would that be the same where the powder, just expand a little bit on the powder from?
The firearm.
Thank you.
Or from the ammunition.
Thank you, sir. And did you in fact process the victim's shirt in this case?
I did.
And did you document using a regular camera and or an IR camera?
Yes, both. We took photographs of the shirt with a regular camera, and then using the infrared camera, we took photographs of it.
And could you explain a little bit more about the process? You said there's different filters. Could you just explain so that we can understand exactly what that means?
Yeah, there's the camera kit that the IR camera uses comes with 3 different filters, I believe, and there's different levels of the light, the amount of light that it allows in from the infrared flashlight. So there's different levels of the filters that will allow it to see different light.
And based on the different levels of light and the different filters, what occurs to the item you're examining?
Depending on the filters, the more light that lets in, the more the the filter will allow more light in, and the shirt, you're looking at a shirt in this case, the colored background will fade away more using the different filters. You have different levels of the background that's taken out, and then the substance that's left on the shirt will absorb the light, and basically it creates more of a contrast between the substance that's on the shirt and the background color of the shirt.
And Mr. Talbot, I'm going to show you 39 through 43 was going to be marked as state's exhibits. Would you take a look at those pictures and tell me if you recognize them? I said, I don't know. It's 39 through 44. I may have misspoke. I'm not sure if I said 43 or 44.
Yes, I recognize them.
And how do you recognize them?
They're the photographs that I took on the shirt that day.
And do they appear to fairly and accurately depict the examination you performed on October 6th of 2020?
Yes.
Your Honor, at this time, the state would ask to move in states 39 through 44.
Any objection? Received.
And may I publish them?
Yes.
Thank you. Mr. Talbot, there's a laser pointer there if you need it. And
thank you.
I'm going to steal it if you don't mind. I'm showing you what's this is states 39. Can you just kind of describe for the record what we see here?
This is just an overall of the shirt on the front side of the shirt. As we put it back together a little bit as much as we could, you can see the cut marks in the shirt where EMS cut the shirt off the victim.
So it's kind of a cross in the middle, and you're understanding that's from EMS.
Yes, that's what I believe to be.
Thank you. And then what's the area of interest on this shirt?
This right here is the gunshot hole in the front of the shirt. And I placed a white card in behind that to be able to see the hole.
And I'm going to show you states 40. There was only one. How many holes did you find in this shirt?
Just one.
Okay. And so this is the same one we just saw in states 39?
That's correct.
Okay. And you said you placed a white card behind it?
Yes.
Okay. And so these two pictures that we've just seen, are those through a regular camera at regular light or not?
Yes, I believe they were.
Okay. And then after taking photos at regular light with a regular camera, what do you then do?
I then start using the infrared camera and just take some more of the same series of photographs, but not without the overall in it.
And during the course of that taking, are you changing those filters you told us about?
Yes, I changed the filters as I went through, going through each level of the filter to see what is going to show the best contrast.
And I believe states 41 through 44 is a sampling of those photos. Is that correct?
That's correct.
Okay, thank you. I'm going to show you states 41. Ultimately, when you're using this infrared camera, if there were stippling and soot, what would you expect to see?
I would expect to see the background colors of the shirt to lighten quite a bit, like where you see this dark right there and it's gray. It lightens up significantly. And if there was stippling present, you would see darker particles or powder burns around the bullet hole.
And in states 41, do you see any of those darker particles or bullet or burn marks?
No, I did not.
I'm going to show you states 42. It looks somewhat different than 41. And what accounts for that?
It's just a different different filter, and the background on the darker area is lighter color now, and the gray shirt is lighter color even more to it, where it's almost like towards a whitish color.
And did you see anything under this filter that indicated to you there was stippling or soot?
No, I did not.
And I'll show you states 43. Again, it looks a little different.
Yeah, and it is just another filter we used, and again, there was no other areas of stippling that we thought could be there.
And then finally, states 44. Again, a little different. Is this a different filter again?
It may be the different filter, but it's also a closer up shot, showing the bullet hole a little bit closer.
And now we see some faded portion there around the bullet hole. What is that? Is that attributed to anything?
In my opinion, it was attributed to just wear and tear of the color of whatever the color of the shirt is, and because you can see the wear and tear in another location of the shirt showing the same thing.
And was that location close to the bullet hole or somewhat at a distance?
Further away.
So after conducting this examination of the shirt using your infrared light, did you find anything that indicated to you there was soot or stippling on this shirt?
No, I did not.
Can I have just a moment, Judge?
Yes.
Through your time as a crime scene tech and subsequently the manager, have you been trained on or come to know through your experience generally how far soot or stippling exit, or how far away the gun would be?
I couldn't give you an expert answer on that question, but through my experience and with the medical examiners and different firearms experts, I've heard that it's outside of 3 feet. Inside of 3 feet, you can start to see some of that stippling and gunpowder maybe. So that's just the general thing that I've come up with, that I've known over the years to be at outside of 3 feet.
Thank you, sir. I don't have any further questions, Judge.
Cross. And do you want any of this, or?
Yeah, we can have the lights, and I need 2 minutes.
Yes, sir. Absolutely. I was just saying, were you going to use the display?
No.
All right. Yes, sir.
Afternoon, is it a deputy or Mr. Talbot?
Mr., if you wish, that's fine.
Civilian?
Yes.
All right. So, Mr. Talbot, you've told us that you examined the shirt, it had no signs of stippling.
That's correct.
And stippling being the gunpowder residue that comes out the barrel of a gun when it's fired.
Yes, the small particles that will come out of the gunpowder.
Right. A lot of times it leaves like tattooing when it's in close range.
That's correct.
All right. And you've told us that stippling generally travels, I believe your words were outside of 3 feet.
Yeah, the distance, if you're expecting it to show up on the skin or the shirt or something like that, they would expect it to be somewhere around 3 feet. You'd expect us to see it there.
Okay. So would it be fair to say that what you're telling us by your testimony is that making believe that you are the shooter and I am an assailant, and I have previously on this occasion assaulted you, and now I am coming at you again to assault you. You're telling us that you shot me, and when you shot me, I was 4 feet or more away from you.
Potentially.
Yeah. That you chose not to let me get closer than that to assault you a second time.
Potentially, yes.
That's all.
Any redirect?
No, sir. Thank
All right. Can this witness be released?
By the state.
Yes, sir.
All right, sir. You're releasing your subpoena. Thank you very much.
Thank you.
All right. Let's take a break. And it's just a little bit before 1. I think we can be back by 2. It's a little bit after the lunch rush, so hopefully everybody can get in and get out. Does that sound all right?
Yes, sir.
Do you solemnly swear or affirm the testimony?
Right, so skip that. a lunch break very quickly. What's anyone's initial thoughts on this game? So it's hard. It's quite hard to get into it a little bit, I think, but it will come out a little bit more now. This is obviously about the stand your ground law, and whether she's within her right to do that or no, and not. Yeah, no, this is the thing. Yeah, I don't want to spoil it either. So Sarah P, you've seen this. Sarah P, you've seen this hearing. Miss P, do you remember it? You don't. It's a year ago, 2 days ago that we watched it together. Yes, pre-trial. This is from the 6th of July, 2023. So it's pre-trial, but this is an important part of it, really, because it'll show you what happened. Do you know what I mean? So, yeah. So yeah, I like this case. I'll be honest. I like it. It's intriguing because there's no doubt that she shot him. It's whether she did so in self-defense or not. So yeah. So again, it's from last year. So I think a lot of people know about it up until now. No, it's interesting. The witnesses can be released from subpoena if they still need. So yeah, they'll be subpoenaed again. I mean, for the actual trial, which is started in a couple of weeks. So, right, let's go. A few more hours left on this one.
You shall give in this case to be the truth, the whole truth, and nothing but the truth.
I do. Thank you.
Hello, sir.
Hello, sir.
As the deputy said, 12 to 15 inches from the microphone.
Okay.
Adjust it how you need, up, down, left, right, and just loud, clear voice should hear everything.
Yes, sir.
Thank you.
And Judge, we're ultimately going to need the screen. Good afternoon.
Good afternoon.
Please state your name.
Detective Justin Warren,
How do you spell Justin and Warren?
JUSTINWARREN.
Where do you work?
I'm employed by the Manatee County Sheriff's Office.
How long have you worked there?
Started March 25th of 2003, so just over 20 years.
What is your current position?
I'm currently assigned to the Manatee Homicide Investigative Unit.
What is that?
So basically, it's a unit comprised of detectives from the Sheriff's Office as well as other local municipalities. And whenever a homicide occurs within the jurisdictional boundaries of Manatee County, several of our detectives will go out to assist.
And generally speaking, when there is a homicide, do all of the members go out?
It depends. Sometimes there are people on vacation. Other times, not everybody will come out. It depends on what the supervisor deems necessary.
But the majority of the time, do you have more than one detective there?
Oh, yes, ma'am.
Okay. And do you have what's considered a lead detective in cases that you do?
We do.
Okay. Now, what does the lead detective do?
The lead is essentially the person who will basically hand out assignments. Those other detectives that will be out at the scene, or they might be knocking on doors, talking to witnesses, they essentially report back to the lead and the sergeant.
Okay. So as the lead, even though you may be designated the lead, that doesn't mean you're doing all of the interviews.
Yeah, that's correct.
Okay. Were you the lead detective on the case that we're here about today?
Yes.
Ashley Benefield.
Sorry, yes, ma'am.
Yes. On the date of the shooting, were you notified?
I was.
And around approximately what time?
I think it was probably around 7:20 or so.
Okay. So you were called at around 7:20. Do you know, was there a 911 call?
Yes, ma'am, there was.
And what time was the 911 call?
I think that was approximately 18:56 hours, so 6:56 or so p.m.
So you're there roughly 35 minutes, or,
Yeah.
or you come to the sheriff's office roughly 35 minutes afterwards.
Yes, ma'am. I started responding there.
Okay.
Yeah.
So I was starting to say that you went to the scene, but you didn't go to the scene first, correct?
That's correct.
Where did you go?
I went to the sheriff's office so that we could begin authoring a search warrant for the residence.
Okay. At that time, did the defendant, Ashley Benefield, come to the station?
She was brought to the station. Yes, ma'am.
Okay. Was she brought to the station by other members of Manatee County Sheriff's Office?
Yes, ma'am. There was a patrol deputy brought her in a marked patrol unit.
Was she under arrest at that time?
Not by me, no, ma'am.
Okay. When you saw her, were there any other people with her?
When she arrived, it was just the deputy and her. But I was soon, actually, before I even met with her, I was actually approached by a female by the name of Faith Brown.
Okay. And did she have other people that joined her throughout the evening?
Eventually, 2 others arrived. Yes, ma'am.
Okay. Do you recall who they were?
Leland Taylor and a Miss Kimberly Kuhn.
Okay. And they're all 3 attorneys?
They are.
At the time, did you have a crime scene technician take photographs of her?
We did. We had a crime scene technician respond to the office. We actually obtained a search warrant in order to get those photographs and DNA and whatnot. But yes, we did.
And why?
We asked, and initially it was told by her attorneys that they would rather us get a search warrant, so we did.
Okay. And why did you want pictures?
So initially, when I saw her, I didn't notice any kind of injuries at all. I didn't notice anything about her clothing that stood out, whether it was ripped or torn or stained or stretched out, things that you would typically see during a physical altercation.
At the time that you saw Ashley Benefield, were you aware that there was a self-defense claim?
I had been aware of what had been said on the 911 call. Yes.
Okay. And what was said on the 911 call, and we have a stipulation to this effect, but basically she, Ashley went to a neighbor and said her husband attacked her.
Correct. And yes, ma'am.
So you were aware of the self-defense claim at the time?
Yes.
When you observed her physically, what was she wearing? Oh, I'm sorry.
Can I request that the stipulation be read?
Which one is it?
It's number one, I think.
Number 1? Okay, it doesn't mention 911, but that's ran to neighbor's house, called 911.
Well, Your Honor, I believe it says immediately
Mhm.
ran to neighbor's house.
Yes.
And hysterical,
Mhm.
just quite different from what was repeated.
Oh, okay.
Okay.
I've read it.
So anyway, I'm sorry, this is repeated, but you did understand that there may be a self-defense claim at the time.
Yes, ma'am. That's accurate.
So what was the defendant wearing?
Like if I remember correctly, it's like a I don't know what you call it. I guess like a crop top, tube top, something like that, almost sports bra kind of thing, and a pair of shorts, if I remember correctly.
Okay. So tube top, sports bra kind of thing.
There was some midriff that was visible. Exposed.
Okay. And you said you looked at her clothes
I did.
and you didn't see anything torn or disheveled?
No, ma'am, I didn't.
Okay. And when you looked at her, did you see any injuries?
I did not.
Did you look specifically for injuries?
I was paying attention as we were standing there in the lighting out in front of the office and then on the way up to the interview room. And as we walked her into the interview room, I was paying attention to that. Yes.
Did you see her face clearly?
Yes.
Did you notice any injury to her face?
No, ma'am.
Okay. Did you speak with her attorneys about the need for documenting these injuries or,
Yes.
or lack of injuries?
Yes, ma'am, we did.
Okay. And that's when you got the search warrant, correct?
It is.
And did you have an opinion about what you should photograph?
So my initial opinion was to photograph everything to make sure that we did a thorough and accurate job in documenting any injuries or marks that may be present. And we actually even put it to her attorneys. And I asked them, I said, if you wouldn't mind, go talk to your client and try to help us determine if there are any areas of injury or any areas, because we're going to do DNA swabs of the skin as well, to try to pick up any foreign DNA, foreign to her. And
Any response, Your Honor? I think we're heading into a dangerous area.
Yeah, I don't know if you're going to start talking about attorney-client privilege information or.
No, no, I just wanted to get across that this witness asked the attorneys, where should I photograph, and then what the response was. And that's
Okay.
why.
All right, I'll overrule.
Okay. So you asked, should I pay attention
right.
to any areas?
Yes.
And go talk to your client and let me know.
Yes.
And they came back and said what?
Arms, legs, neck, and hands, I do believe that's the final.
Arms, legs, neck, hand. Did they ever mention, or did anybody ever mention to you eye or face?
No, ma'am.
Did anyone ever mention to you midsection?
No, ma'am.
Did you ultimately arrest her that day?
No, ma'am.
Why not?
Because she had made that claim of self-defense. We wanted to make sure we conducted an accurate and thorough investigation. There was obviously a lot going on here with her past history, and we wanted to make sure that we did a thorough job.
Okay. So you said with her past history, so at least you were somewhat aware of some previous reports.
Yes, ma'am. There were some reports that were in the Manatee County Sheriff's Office computer records database that we were able to view.
Okay. And did you ultimately get another search warrant to take pictures of the defendant 3 days later?
We did.
And why'd you do that?
Well, sometimes with injuries, they don't readily show up right away. Bruising sometimes doesn't come up initially. So we wanted to make sure that we did our due diligence again and check 3 days later, giving those injuries time to appear.
Okay. And have you seen those photos?
I have.
Do you recall how many photos were taken?
Of her in total?
Yes. Let me be more specific. So the first day and then 3 days later, there was more taken. So together, about how much?
100 or so.
Okay.
Something like that.
So a lot of pictures.
There were a lot, yes.
And did you at any time, either at this first meeting in the sheriff's office or after the fact, see anything on the defendant that appeared to be an injury?
There was a small scratch. I believe it was on her side. But that actually came up during an interview that we did later on, and it was very minor.
Okay. As part of the investigation, was Doug Benefield's phone taken into evidence?
It was.
And was that phone searched or downloaded to gather the information?
It was. It was taken to our technical services unit, and they did an analysis on the phone.
So you don't do that?
No, ma'am.
Okay. So once the information is downloaded from a phone, is it in some sort of a format that you can read it and search it?
They do use certain programs that allow you to search through and help organize what you're downloading. I don't know the exact ins and outs of it, but I mean, I'm capable of using the program and reading through it, but
okay.
I don't know the technical aspects of it.
Did you review certain information, some information from his phone?
Yes, ma'am.
Okay. And did you find anything about a U-Haul on his phone?
Yes, ma'am. There was a confirmation email that a U-Haul was supposed to be picked up locally. Then I believe it was supposed to be dropped off in the Bowie, is it Maryland area?
Okay. And were you able to examine his searches on his phone?
Yes.
And did you find anything interesting about his searches?
Yeah. So during one of the searches was actually, it looks like he was looking for a roommate. Like he was looking for a place to move into. It was like roommate finder or something along those lines. But in the Bowie, Maryland area.
And why did that seem of importance to you?
Well, some of the information that we'd received was that everybody believed he was moving in with them. And obviously this kind of contradicted that.
Okay. Moving in with them, meaning Ashley and
her mother and their child.
Okay. In Maryland.
Correct.
I am going to talk to you about Statement Exhibit 45, and I know there may be objections to this. These are the text messages. There is a stipulation, which I think is number three, that this does not need any further authentication, but I don't know if the defense has a further objection.
That's correct, Your Honor. We stipulate that it's authenticated. However, we still preserve any appropriate objections, one of which includes hearsay and two references.
And Judge, generally my response is that these are text message exchanges between the defendant and the victim for the 7 days right up to an hour before he's murdered. While there may not be anything, explosive on these text messages, that is the reason I'm putting it in, is that there wasn't any fighting going on. There wasn't any
question, Your Honor.
No,
I think she's just responding to the objection.
Yes. It is to show the nature of their relationship leading up to the incident. It's expected, and because of what is written in the stand your ground motion, the state feels it's necessary to show the tenor of their relationship and how the relationship was at the time in question.
All right. So I guess my first question is, I haven't seen the text. I don't know what's in the text. I wasn't provided a transcript or a printout of the text. So I don't even know what the subject matter is. I don't know how many there are.
A few. Yeah, we were going to go through it, and the detective was going to help me read these.
Right. I don't know how to make a ruling when I haven't even seen them yet. Maybe they're hearsay, maybe they're not. Well, you've got defendant statements, at least for one side of it. So is the other side of the conversation being offered for the truth of those statements, which would then be hearsay, or is it just to show the natural flow of the conversation, the effect on the, I don't know.
Yeah, I do think, Your Honor, it has to be relevant to some fact in issue.
And then you got relevance, so.
Yeah, and it is not.
And
I don't know how to make this decision without seeing them.
Okay. And I do have some further argument depending on what the actual objection is and what the response is.
So what I'm thinking is going to happen is that we're going to keep going pursuant to, or I'm sorry, subject to your objections, but I got to see them to even have an idea how to rule.
I understand. So, Judge, we can continue.
I left my quarter upstairs.
We can continue on as the court suggested earlier. I'm confident the court will rule.
All right. Thank you, sir. So this is subject to any objections.
Okay. And if we could just dim the lights a little bit right in front, just the ones in front of the screen would be okay. And the state would enter into evidence States Exhibit 45. I don't know that I actually did it after the objection. Or would you like me to wait?
Well, yeah, we're going to have to wait on all of it.
Okay. Okay.
Now, ultimately, even if I don't allow them, I imagine you're going to want to put them in the record for your proffer and appellate purposes. But for right now, I'm delaying ruling on all that.
Okay. Now, you have a pointer right in front of you.
Yes, ma'am.
Yeah, if you wouldn't mind. It's really hard to see on this screen, so I'm going to zoom in a little bit. Let me go all the way to the top. What are we looking at here? If you could just tell us what information is in this.
So this appears to be a timeline of text messages. Down here, it's telling what type, because there are different types of messages, instant messages, and depending if you have an iPhone, it might be an iMessage or an SMS. Over here shows the direction of the call or in or text message, whether it's an outgoing or it's an incoming. This would be the date that it was sent, and sent, and this would be the sent or received, I should say. Then this would also be the date and time. Then obviously direction from and to, and then the owner's information of each phone.
So are you aware of the reports that came into the sheriff's office? We heard testimony earlier about it from Stephanie Murphy, that there were at least 5 abuse complaints against Doug Benefield, saying that he was abusing the dog.
There were several, yes, ma'am.
Okay. And were all of those complaints before this date of 9/20 of 20?
Yes, ma'am, I do believe so.
So I would like for you to just, I'm going to make it a little bit bigger. If I'm just going to have you go through some of these so we can get sort of the tenor of what's going on here. So the ones in light blue are from who?
Okay, so the ones in light blue are from Doug Benefield.
And two?
And they would be to Miss Ashley Benefield.
And the orange?
And the orange are from Ashley to Doug.
Yeah, it might be better, you know, if you look up here, you might be able to, the video is horrible. Okay, so the first instant message is 9/20 of 20 at what time in the morning?
9/20 of 20 at 8:20 a.m.
Okay, and now it looks like there may be not a message necessarily, but an attachment.
Correct.
Okay, so now you've seen this before. So do some of these attachments work and some do not?
Some, yes, ma'am. Some of them do, some of them don't.
Okay, do you know why that is?
I think because some of them are actually based on the internet, not something that's downloaded. So sometimes if you're not connected, the link won't work, and
okay,
various other reasons.
So this is the first one. And what is this?
Looks like a Bible verse.
Okay. And that was from Doug to Ashley, correct?
Yes, ma'am.
Okay, and then if you could just go through the next few lines.
Okay. On 9/20, so the same date, 10:36 a.m. Loved an image. So typically with some images and posts, especially with iPhones now, they really have this thing going where you can actually laugh at an image or love an image, or you can do different reactions essentially. So as far as I'm aware, that's what we're actually when it says loved an image. I think it's a reaction to that.
Okay.
Most recent text message. 10:36 and 36 seconds. So 5 seconds later, she sends a message, good morning.
Okay. And then he says?
He replies with good morning.
And then within an hour after that, there is what looks to be an attachment. Is that one that you're able to open?
I'm not sure if that is or not. I don't think it doesn't have a line under it. So I'm not sure if we're able to open that one or not.
Okay. So then the next text message is from?
This one's going to be from Doug to Ashley. It says, run, baby, run.
And if you could just continue down the line.
Sure. Then Ashley sends a message, laughed at a movie. Ashley sends some smiley face emojis. That's what they look like. Doug replies, ready to rock and roll, laugh out loud, question mark. That was at 12:20. At 12:31, she replies, give me a few, LOL, trying to round up the cats. It's like trying to teach ballet to squirrels.
Okay, so I'm just going to scroll up. What's the next entry?
So within, looks like within seconds, he responds, ha, that's funny. Give me a few, LOL. He's basically saying he liked this comment. So essentially, like I said, it's a reaction to the comment that was given.
Okay. And then he says, or the next entry is her. What is it?
So at 1:06 p.m. it says, OMG, or oh my God, I'm exhausted, LOL. You can come over now. Sorry.
And at this time, it's your understanding they were living in separate houses, correct?
Yes, ma'am. He had an apartment down the road. I believe it was called the Green.
Okay.
And then she was in a subdivision.
So this here is Ashley telling him you can come over.
Yes.
And he says,
sorry. He replies, ha, need to video the rodeo. Okay, headed that way.
Okay.
That's at 1:08 p.m.
And then she likes a comment, but then at 1:20, what does he say?
So at 1:20, I'm walking around to back.
And she says,
I can let you in the front or whichever. He said, okay, front's good. Then she gave him a little thumbs up.
Okay, so that entry was at 1:22 p.m. The next entry is several hours later at 5:37 p.m., which appears to be from Doug. What does it say?
Me and XS boxes arrived.
All right. And Ashley's response?
Is LOL.
Mhm.
Then it looks like it's 6:40. Doug sends some other type of an attachment to her.
Okay, and we'll view that attachment.
How do you know what he's doing? I think it's giving you clues that I gotta guess. Get real. Real.
Working mother, not a working mother.
Working mother, not a working mother.
Not a working mother. I live in a
Some. Oh no, it's running out of time. House. Real house. White. Oh, no. Oh.
So the person on the left, that's Ashley, correct?
That's correct.
And then on the right, do you know who that person is?
That's her mother.
Okay. Then at the next entry is about 40 minutes after that one is what?
Let's see. We have was there a response to that? I'm sorry.
I'm sorry. It looks to be a call log phone call.
Yeah.
Yeah.
So that looks okay. So yeah. A call log. Sorry. Incoming. It looks like there's about a 13-second call
From Ashley.
From Ashley.
Okay.
To Doug.
And then the next entry.
Next entry is from Doug to Ashley. It's 9/20 of 2020 at 8:58 p.m. And it says, "Good night, sweet Theta waves. I'll be done by 1 tomorrow and plan on joining the party."
And she does what?
She loved the message at 9:22 p.m.
And then said,
Then good night. I'm sorry. Good night, huh? You sure want to come hang out at the slum? Or you sure you want to come hang out at the slum? So basically indicating what they were joking about in the video.
on the video. Okay. And his response.
Yep, be smashing at the slum.
Okay. Then skip down. The next one is that she liked that message. And then the next entry is from Doug at what time?
That's at 7:36 a.m. on 9/21. So the next morning.
The next morning. Okay. And there's an attachment.
There is.
Okay. And we'll look at the attachment. And for the record, what is this?
It's another Bible verse.
Okay. And what's the next entry?
The next thing I see is at 9:55 a.m. Ashley loved an image. Then she says, "Good morning."
Okay. And what does he say?
Doug replies at 9:56, "Good morning." And there's some little emojis behind it here. Then later at 12:46 p.m. Headed that way in about 30 minutes.
Okay. And her response?
Her response, it's at 1:09. Oh, hey, wow, you done for the day? Don't rush because of us. We're out for a walk now. Not in a rush to get started today. LOL. We'll have to round up the cats when we get home anyway.
And his response?
So his response at 1:13. Oh, nice. A little breezy, which helps. Getting an early start can finish up early to come over and be with y'all and play with Emerson, free y'all up some. Just ping when good to head over.
And she likes that.
And she likes that at, yes, 1:51.
And says?
Then at 1:51, a few seconds later, will do.
And then she also asks him?
2:47. Want to grab a can opener at Publix on your way over, LOL. I, of course, packed the one that we had.
Okay. So I'm going to run a little ahead. So this is the next day. If you could read that, what's at the top, that date.
All right. So we have an outgoing from Doug to Ashley on 9/22 of 2020 at 4:11 a.m. And it looks like it was an attachment that was sent.
Okay. And we'll look at that. And for the record, if you could say what that is.
It's another Bible verse.
From Doug.
From Doug to Ashley, yes.
All right. And then he says.
Then he says, "Good morning. Hope you slept okay."
And her response.
Looks like she loved the image and then replied with "Good morning."
Okay. I'm going to scroll up. How about later on that day at like 1:36, which is the top entry, and he says to her,
So Doug sends Ashley a message. Can you think of anything we need at Lowe's or anywhere?
and the next,
After that, at 1:42 p.m., it looks like Ashley reaches out to Doug via phone because there's a 48-second call.
okay, so it's a phone call.
Correct.
And then the next entry,
The next entry is at 3:23 p.m. and it's from Doug to Ashley. Headed that way in a few. I'd nothing need.
okay. I'm going to scroll up. And then I want to go to the next attachments here at 9:22 at 9:27 p.m. What is that entry?
So it's like an image, or I'm sorry, some kind of an attachment sent from Doug to Ashley at 9:27.
Okay, I'm gonna look at that. And for the record, what is that?
It's a picture of Ashley and her daughter on the beach.
And the next entry is right after that?
Yes, ma'am. It's at 9:28 p.m.
And it also has an attachment?
It does.
Okay, I'll open the attachment. What are we looking at, just for the record?
Again, it appears to be Ashley and her daughter at the beach.
Okay, so Doug sent these to her.
Correct.
I want to go to the next yellow square there. What, is that the same evening?
Yes, so 9:22 at 9:30 p.m. Another attachment is sent.
And this is what?
This appears to be their daughter at the beach, and I believe that actually can't see who that is there in the background very well.
Okay.
But it appears to be the same location.
Okay. So then I'm going to scroll down
I am the
until we get to the next day, 9:23 of 20 at 6:47 a.m. What is that entry?
So that is a message from Doug to Ashley, and it appears to be another attachment sent at 6:47 a.m.
Okay. And the attachment again?
Is another Bible verse.
And then after that, he says,
So at 9:23, he says, good morning. And at 9:28, he replies again and says, got email from Stephanie after she talked to Faith. Since order to mediate, we meet for 1 hour tomorrow to stop court next week. You dismiss injunction. We sign joint stipulation to dismiss dissolutions and hold until Morlan signs order for a report. As soon as she signs order, we file dismissal and we're done.
and what else did he say?
At 9:30, and we have joint session with Dr. Q Friday to wrap up our adventure in Florida and leave with understanding of double knots and red-blue inversion.
And the next couple of entries.
Okay. 9:49 a.m. She loved an image. Then at 9:49, looks like 10 seconds later, good morning. Doug then actually, it says emphasized on good morning. So her response, then Ashley sends another at 9:50. Okay, I'll reach out to Faith to follow up on all of the above with a thumbs up.
Okay. And then he likes that.
Yes, ma'am. So at 9:50, he likes that. At 9:51, and we're all done. Or I'm sorry, and we're done.
Okay.
At 9:52, Doug sends another message, and all in first 10 days of Jewish New Year, LOL.
Okay. So
And
we're
then she
gonna,
likes that comment.
we're going to scroll down to the 9:23 or 9:23 at 10:13 a.m. from Doug. What does that say?
9:23, 10:13 a.m. Doug to Ashley. So perfect outside.
And she loves a previous comment, but what is the next comment underneath of that?
So her comment at 10:14 a.m. says, "Oh yay, we should do Selby today."
Okay. And his response?
His response is at 10:14, "Oh yes." Then he responds, "Yum."
Okay. Then I'll scroll through some of this. The message at the top from 11:39 a.m. Who's that from?
So that's from Doug to Ashley. And the text is, Stephanie just sent Faith joint dismissal of everything except injunction, which Faith has to do. Just a one pager.
And next?
Then he sends another text, what time thinking Selby?
And then she likes the first comment. And then what was her response to Selby?
So her response at 11:44 was maybe 1:30ish. I'll text you when we are heading that way.
And then he says, let me scroll up here. There.
So at 11:44, he replies, okay, I can come pick you up too. 12:12, he again sends a message, more time with my baby, a happy face. Then at 12:14, mediation tomorrow by Zoom at 10:30, and be quick.
Okay. I'm just going to scroll up here. So the next entry I want you to read is from 5:53:38 on the same day.
Okay.
And what does he say?
So it's an outgoing message from Doug to Ashley, 5:53. Do you want to get together tonight or in morning before mediation and unify the instructions for Faith and Stephanie? Think we are going to need to keep involved until this is done or will drag out.
Her response.
Her response at 7:02 is, ha, okay, thumbs up.
And his response.
And his response at 7:05, thumbs up, prefer tonight, maybe run over Pandera or in morning or AM, sorry.
And she says.
At 7:24, she says, sure, can do Pandera tonight.
And the next entry.
Next entry is outgoing from Ashley to Doug at 7:24. It says 8 ?
Okay. He sends a thumbs up.
Yeah, 7:27, he sends a thumbs up.
Okay. And then they're telling each other good night. Good night, sweet dreams.
Yes.
And the next day in the morning,
So
7 o'clock, who is that from Doug?
yes, it is. It's from Doug to Ashley on 9/24/2020 at 7 a.m. And it's another attachment.
Okay. And for the record, what is that?
Another Bible verse.
Okay. I'm going to scroll through. This entry here is 9:24 at 10:09 a.m.
Okay.
Can you read what that says?
9:24 at 10:09 a.m. It's from Ashley to Doug. It says quick and easy, LOL.
And his response.
His response, he emphasized quick and easy, LOL. Then at 10:26, so nice to experience quick and easy, finally, LOL.
Okay, so I'm going to scroll again. On the same date, 12:50 p.m., can you read this?
Okay, so yeah, 9:24, 12:50. This is from Doug to Ashley. It says, just to ponder while I finish up, thinking about getting all the cars up there. And I thought was to ship the Cherokee up there by transport, which is 900, and either tow my truck or tow your Jetta. The U-Haul plus the car trailer is about $1,000. That's for the biggest truck, which gives us plenty of room. The option is another pod and tow one of the cars behind my truck. Overall price about the same. U-Haul more flexibility, like taking things straight to storage.
And she says.
Her reply at 1:27 is, okay, things to think about. Maybe best to have you drive the U-Haul and tow your truck behind. Mom and Cats will go in the Jeep, and I'll drive with Emerson in my car.
Okay. I'm scrolling up again for the record. And the next day, 9:25. This is 2 days before the murder.
So 9:25 at 5:45 a.m., there's a message from Doug to Ashley, and it's another attachment.
And what is this?
It's another Bible verse.
What is the next entry?
So the next entry is 9/25/2020 at 6:03 a.m. It's from Doug to Ashley, and it appears to be another attachment.
And if you could read what this says? It's
Sure.
an attachment, but what does it say?
Live a life filled with love.
Okay. And he says, good morning.
Yeah, so at 9:26 a.m., he sends her a message saying good morning.
Right. And then what is the next thing he says?
The next thing he says is at 9:27 a.m., and it says, Dr. Q is at 10:30. Do you want a chai?
Okay. And they go on talking about the tea. I'm scrolling. This is one day before. This is 9/26/20 at 6:43 a.m. What is this?
So this is a message again from Doug to Ashley, and it appears to be an attachment.
And what is that?
Another Bible verse.
And he says.
And he then sends her a message, good morning, at 9:40 a.m.
And she responds.
9:54, she loved the image. Then at 9:54 and 17 seconds, good morning.
Okay. And then I'll scroll a little bit. So this is 9/26/20 at 12:27 in the afternoon from Ashley. What does she say?
So Ashley sends a message to Doug, want to come pick me up and we can go get the truck.
And he says?
He replies, sure, heading that way. Then later, let's see, if, at 12:41, I be here. Then at 9:04, good night, sweet dreams.
Okay. And she likes the image or loves the image. And
Yes.
says good night.
Love the image, and then replies good night at 9:23.
Okay. So the next day, 9/27, this entry's at 6:42 a.m. What is this?
So this is another message from Doug to Ashley at 6:42, and it's another attachment.
And this must be one that we can't open. So he says after the attachment.
So at 10:02, he sends a good morning with some little emojis.
And she loves the image, and then.
Love the image at 10:06. So then 10:06 and 10 seconds replies with good morning.
Okay. So there are several short messages. And then at 1:03 p.m., this message appears to be from Doug. What's he say?
So Doug sends a message to Ashley, what y'all working on?
And she responds.
She replies, last cram, LOL. using the big boxes and getting the last loose stuff packed up and ready. That was at 1:15.
And then she also says,
how's it going over there? Making progress.
and his response?
His response at 1:18, loose stuff, should be a chapter in our book, LOL. Got everything out and in garage, ready to throw on truck, except couch, AKA bed, pretty much emptied. Taking Sully to get his shots, then to doggy spa to get groomed and stay until ready to go.
And he says after
Then
that.
at 1:19, I'll come there and drop him off at 3.
And then she laughed at the message
Correct.
from him. She also liked the message, I'll come there after 3.
Yep.
And then what'd she say?
Then at 1:20 p.m., great, could you run by Lowe's before you come over? Grab a few more large and mediums.
And he says,
Sure, I need a few too.
she likes that. And then she says,
She likes that. And then at 2:36, just to be safe, let's do 10 of each just for the last bits here.
and he likes that.
He likes that. And at 2:36, he also replies, okay, let me know. Okay, let me know anything else if think of.
And then she says,
Tape. At 2:50, she replied tape, but then also LOL.
and he responds,
At 2:50, he says, ha, okay. Then at 2:51, just finished the vet, headed to the spa, LOL.
and she laughs. And
Correct.
then the next entry.
At 3:45, he advises that he's headed there.
And she says,
She replies at 3:51, okay.
then he says,
At 3:54, I'm out here out front. Or I'm sorry, I'm here out front.
and her response.
Her response is at 3:55, okay, 1 minute.
Okay. So he must have left at some point. This jumps 2 hours or an hour and a half. And the next entry is from Doug to Ashley and says what?
At 5:10 p.m., it says I'm about to head back.
Okay.
Then at 5:11, there's some kind of an attachment that's sent from
That we
Doug to
can't open.
Ashley.
And then at 5:11 p.m.
At 5:11, Doug sends another message to Ashley. Everything and except couch and 10 medium boxes and 2 cab, LOL.
And she laughs at that.
And she laughs at that at 5:14. At 5:14, she then sends a message to Doug, ha, OMG.
And he says,
And at 5:32, he sends a message back, trucker on the way.
and what time was the 911 call again?
Was it 6:56?
Okay.
Approximately.
When was Ashley arrested?
A little over a month after this occurred.
Okay. And why'd you wait so long?
We were trying to do an in-depth and thorough investigation, look at every aspect of what was going on. She had made a claim of self-defense, and we wanted to make sure that we did everything possible to either prove or disprove that.
Okay. Was a booking photo taken of her at the time?
Yes, ma'am.
Okay. And what was the date? Do you recall?
Not off the top of my head, Alex. It was a little over a month.
Okay. Beginning of November?
Yes.
Yes. Here. Judge, this is the certificate of business records that the state did a notice of for the booking photo of Ms. Benefield.
Okay.
Object relevance.
Relevance is she looks exactly the same as she did in the other 2 sets of pictures that were taken.
Okay. Go ahead, sir.
Same objection.
I'll overrule.
I'm just going to put this up.
I don't know. What number is it?
Oh, I'm sorry. Statement entered into evidence states 46.
Subject to the objections that I've overruled, received.
Okay. Thank you. I have no further questions. Thank you. Oh, Judge, I don't know that we ever got a ruling on 45, but we're doing some objection.
No, go ahead and do your cross, and then I'll hear all of the
Don't
arguments.
let me forget. So
What was the number on that one?
45,
There we
the
go.
one that there's an objection?
Yes, 45. Okay.
May I?
Yes, sir, absolutely.
Detective Warren, afternoon.
Good afternoon, sir.
So you testified that you were the lead on this case, and a couple of questions I think would be appropriate. The lead is kind of like the quarterback, no?
You could say that, I guess.
All right. And the lead is also the one with the most comprehensive knowledge of the investigation and how it's shaping up and where it's going.
The lead is typically the person that has the overview in mind.
So that's a yes?
I'd say we work as a team, but sure, yes.
All right. And correct me if I'm wrong, but as the lead detective, you developed the theory of the case.
We all actually sit down and look at the evidence. I don't, like I said, I don't go out to every scene. I go out to a lot of them, sure, but we have other individuals that do certain things. So it's really a group effort.
Well, let me ask you this. Do you remember sitting down for a deposition with me?
Yes.
And do you remember that that was testimony under oath?
Yes.
You took the same oath for the deposition as you took this afternoon when you came in before Judge White, no?
Yes.
All right. Do you remember being asked the following question on page 9, paragraph 3? Okay, so as part of your responsibility as the lead detective, you would develop a theory of the case, would you not? Answer, sure.
My answer is still sure.
Okay. Now, you've told us on a couple of occasions that you wanted to make sure you did a thorough and comprehensive investigation.
Is that a question?
Yes, sir.
Yes.
All right. And that is because you certainly wouldn't want to jump to a conclusion on any case, much less a homicide accusation.
That's correct.
All right. And as a result of that, you spent quite some time after this incident running down leads and doing the investigation so you could make a fair and objective determination of what, if anything, was to be charged.
Correct.
And that included you investigating self-defense and things of that nature.
Absolutely.
All right. So I'd like to ask Jack if he would assist me on this. I'd like to put up on the screen, if I can now, the warrant that you authored.
And Judge, no, Jack, is there impeachment here?
Yeah, I mean, is this impeachment?
Yes, it's coming.
We need to ask him the question.
Hold on, as to which question so far, the thorough investigation, which,
The thoroughness of the investigation, its objectivity and fairness.
okay. I think there should be some specific questions to impeach with a document. I mean, is there going to be an inconsistent statement or?
Yes, sir. Yes, sir. If you give me a little leeway, Your Honor, I think I will satisfy the court that the questions that I'm about to direct are appropriate, and I will tie it up.
All right. I'm not quite sure because he hasn't answered any questions about the search warrant.
What is that?
No, this is the arrest warrant.
The arrest warrant.
Yes, sir.
Okay.
I think the question needs to be a little more pointed. What exactly is this different than? What are you saying this is different?
Hold on, no crosstalk. Just go ahead, put your arguments on the record.
I would like to know what exact statement is being impeached and what he's using to do.
All right, thank you. Yeah, that's my question too. I'm not exactly sure what specifically you're impeaching from the testimony he's stated so far.
Okay. If the court will allow me to approach the witness,
okay,
I think I can set the predicate.
All right.
Detectives, let me show you this document and ask you if you recognize it.
Appears to be an arrest warrant. Yes, sir.
And whose arrest warrant is it?
Ashley Benefield.
And did you fill out and execute that arrest warrant?
I did.
All right. And that arrest warrant, correct me if I'm wrong, is a statement by you under oath that you took to a circuit court judge.
It is.
All right. And when we say a statement under oath, same oath again you took before you came into court this afternoon.
Yes.
And you represented to the judge that the facts stated in the attached affidavit to that arrest warrant were true and correct.
To the best of my knowledge.
Okay. Now, if I may, Your Honor, I'd like to put a select portion of that warrant up and ask him some questions. And I will demonstrate.
What's being impeached?
Well, I have to ask the question first.
Right. So generally, the police court itself would not be admissible. So I need to know what the questions are, and then I'll need to see if that's materially different so that it could be used as a impeachment, as a prior inconsistent. I assume you're doing prior inconsistent statement.
Yes.
Okay.
And what I want to ask him about is first, I want to establish what he said in the warrant. And then I'm going to show that a select portion of the warrant is in fact not accurate.
All right, well, I think that's kind of putting the cart before the horse. I think we got to have the testimony here and whatever that testimony is, and then we'll figure out if there is a prior inconsistent statement.
Okay, I understand. So that is the warrant and attached affidavit that you actually served.
It appears to be.
All right. Now, everything that you had to say in there is true and correct based upon your oath.
Based upon everything I know to the best of my knowledge.
Would you tell Judge White whether or not prior to you submitting this affidavit, you authored two prior affidavits, two versions?
What do you mean, two versions?
Did you author two separate and independent versions of that affidavit before you finally settled on the one that is before you?
I worked on the arrest warrant, so I don't think I ever sent anything out. This was the first time.
No? Okay, so you know about Florida's public records law, do you?
Sure.
All right, and you know it applies to the Manatee County Sheriff's Office as well.
Absolutely.
All right, so let's see if you can identify this.
If I could just see it. These are some of, Judge, first off, I would object. This is a conversation between me and the witness about drafting the warrant. It has nothing to do with what he submitted to the court. This is conversation between he and I about how it should be phrased. So I don't really understand what's being done right now.
Your Honor, these are two proposed prior warrants of the same version that was actually filed that are statements of this witness. And I'm going to show the court the difference between them and what was intentionally misrepresented and intentionally omitted.
To the court?
To the court that signed the actual warrant. In other words, I'm going to show that this witness has materially made prior statements inconsistent with that warrant, and that there were things intentionally omitted from that warrant that were previously included in the other warrants.
All right, so this is where I'm getting confused. If we're going to impeach with a prior inconsistent statement, I don't think you can start that process with an out-of-court statement and then impeach with prior inconsistent statements. It's my understanding we've got the testimony here today, whatever that might be, and then there might be prior inconsistent statements, inconsistent omissions, commissions, who knows. But I'm not familiar with this. Do you have some cases about impeaching a witness who hasn't yet made any statements using three potentially disparate out-of-court statements?
Well, I think, Judge, if I can break it down for the court, I think we've had a statement by this witness on direct to the effect that this case took time because this detective wanted to be objective and fair and make certain that a proper investigation was done. And I am going to impeach that statement by showing that he knew otherwise and had already concluded otherwise, and that the statements delivered today in front of this court are false. And I can do that through his prior inconsistent statements.
Can I have them?
Absolutely. Your Honor.
Possibly, if they were prior inconsistent statements, but
I don't know.
I would just also ask for a copy for the state. These were never provided in discovery. I just took pictures of one of them on my phone so I can at least read it, but the other one we've never seen except for briefly this morning.
Are you asking for a Richardson hearing?
I'm just asking if it's possible for defense counsel to provide us copies or something so we know exactly what's going on. We may have just done.
Can I suggest maybe, Your Honor, the court excuse the witness?
Sure.
And we take
Detective Warren?
Yes, sir.
The rule's been invoked, so
Yes,
I'm going to have you step outside.
Sure.
Please don't discuss your testimony with anybody, your answers, the questions asked, anything like that.
Yes, sir. Thank you.
I don't remember this at all. I don't remember this bit. It's interesting.
Can I assist the court by leading the court through what I intend to establish?
Well, let me read these first.
Sure. It's the highlighted portions, Your Honor, in particular, that I plan to.
Hello. Hello, Christ-loving mom. We're doing this. We're doing Baldwin tomorrow. This and Baldwin tomorrow.
Highlighted portions.
Oops. Went a bit too quick there.
Proponent?
Yeah,
You
so
want to
here's what I would,
impeach the detective with the highlighted portions of what I'm holding in my hands.
yeah, let me walk the court through it if I may. If the court looks at the proposed warrant of November 2nd at 2:06 in the afternoon,
yes,
the court will see in the highlighted portion on the second page that the detective says the day before the shooting, Barbara Russell, Doug Benefield scraped Ashley Benefield with a box. Then if the court looks at the second proposed warrant, which is approximately an hour and a half later on 11/2/20 at 3:37 p.m., instead of Barbara Russell, her name is now removed and she's no longer an identifiable witness. Now it says the day before a witness, and it says Doug Benefield scraped Ashley Benefield with a box. Then if the court looks at the actual warrant that is submitted on 11/4/20, it says, Judge White, the day before the shooting, a witness, no longer Barbara Russell, explained that Ashley Benefield was inadvertently scratched when someone, no longer Douglas Benefield, but someone walked by her carrying a box. This witness before the court, Your Honor, sought a waiver so that he could speak with Dr. Russell. He got the waiver and he spoke with Dr. Russell. And Dr. Russell told him, and he admitted in his deposition to me, that she told him that Douglas Benefield was increasingly rough and would body check Ashley Benefield with a box, that he would slam it against her, and that it happened on the day of the shooting. And what is in those affidavits, both the actual and the proposed, is not that at all. When a detective comes to the court with a proposed warrant, it's not unusual that the court might ask some questions. And in this instance, if the court saw in the affidavit that it was Douglas Benefield who slammed Ashley Benefield with a cardboard box, the court might ask, being a student street smart, a question such as, what was the relationship between these two? Are they siblings or are they husband and wife? And when told they are husband and wife, Your Honor might say, well, is there a history of domestic violence here? And if the answer to that was yes, then the court might say, could this be a self-defense situation? The point being that the detective might have left without that warrant being signed. I think this is clearly in contradiction to what he's testified to about a fair and objective investigation that went on for several weeks before he submits this actual warrant. So I propose to ask him about his actual warrant and then go back and go over the two proposed warrants to show what he left out and ask him why he left it out. And if he did not think that relevant to a judge that he was submitting the statement under oath to.
I know, same here. It's not new.
Disprove what material fact? How is this material?
That this was anything but a fair investigation and a diligent investigation in direct contradiction to what he has told us here today. And just so the court knows, this is not my only point. I have coming behind it even stronger.
All right, final thoughts?
Judge, to be perfectly honest, I have no idea what we're talking about. The witness was not asked anything that was inconsistent with anything he said before. If the defense wants to try to disprove that it was a thorough and accurate investigation, then the defense can put on evidence in their own case. I don't think bringing in extrinsic evidence, I don't think the evidence is appropriate evidence to use for that purpose anyway. But even if it were allowed in, I don't know that you could do this extrinsic evidence at this point to impeach him for, I said I did a thorough job, but no, you didn't. I'm just a little confused by that. So I would object to any of this coming in at this moment. I'm sorry, I just don't know what rule of evidence we're proceeding under.
goes directly to bias of this witness who testified on direct. I didn't ask the question. The prosecutor asked the question, why did it take so long for you to get this warrant? Because we wanted to do a fair and objective investigation. That was what he testified to. And I am going to show with his own statements that that was not the case. It surely goes directly to this witness's bias and motive. And I have additional very strong evidence, Your Honor, to support that as well.
All right. Well, whenever I start doing an analysis of these kind of arguments, what I want to hear is, well, what are you trying to do? Because that informs me to which folder to go to open up to see what's the predicate that needs to be laid and then what's the procedure for doing something. I don't see this as impeachment by prior inconsistent statement. Because I don't think, yes, he said I did a thorough job, but I don't think that is
fair
necessarily then opens the door to, well, why did you put a comma here and not here? And I'm being a bit melodramatic on that point, but because as I look at some of the highlights on the papers you've handed up, I mean, it's really a simple matter of just reordering some of the words. Now on the issue of the Dr. Russell, I see we're in the 2:06 p.m. email, Dr. Russell is mentioned.
Correct.
In the 3:37 email, Dr. Russell's name is now a witness.
Correct.
And I'm trying to look amongst all the talking at the actual arrest warrant that was submitted. Looks like it was attested to November 4th of 2020.
Yes.
I'm not seeing the incident with the...
I can show the court. I have it marked. Yeah.
Yes.
I think, Judge, what distinguishes it from something that's inadvertent clearly is not only is Douglas Benefield now removed from the actual warrant as being the one who scraped Ashley Benefield with the box, but now there is the statement that that whoever this person was inadvertently scratched her with the box. And that is in direct contradiction to what this witness was told prior to him filing that arrest warrant. He asked for a waiver, which was given to him so he could interview several psychologists. He went and interviewed Dr. Russell. He acknowledged in deposition to me that Dr. Russell told him it was Doug Benefield and that he was becoming increasingly objective on that date by slamming a cardboard box into Ashley Benefield as he passed her in the hallway. And it was on the day of the incident, not the day before.
Right. But that testimony itself, you're just introducing that's what he was told, not for the truth if that's what happened.
Correct.
Okay, because that would be how many layers of hearsay? 3 or 4?
No. Look, I'm trying to show what he knew. Because he's the one who filed the affidavit, Your Honor.
Yeah, so I'll allow it for the very limited purposes of the fact that if you think that this shows that, and you're going to link this up, that he didn't do a thorough investigation, okay, we'll see.
I will link it up.
But, I mean,
I'll link it up.
yeah, I mean, I don't know about you guys, but when I write an order, there might be 4 versions of it as I go through.
Well, Judge, at the risk of embarrassing the court, as far as Your Honor's authorship of orders, I have never seen an order like the order that the court wrote for the motion to compel.
Well, that could be taken 2 ways. couldn't it?
I've never seen a better order, Your Honor, or more thorough.
And that's the platitudes. All right.
I would just like to object to him using emails between he and I discussing probable cause as some form of I don't understand.
Ms. O'Donnell, I'm not quite sure yet either.
Okay.
But we spent a lot of time on this.
Yes.
I want to keep plowing through. I think I'll be able to figure it out when we get to the end of this. I'm pretty sure I'll be able to figure it out and where this fits in. And I will put it in its proper place and give it its proper weight. All right.
Thank you, Judge. And just for the record, I have no intention of involving Ms. O'Donnell in this. It's
Yeah, 'cause if you call her as a witness, we got a problem.
It's going to be limited strictly to the.
All right. You can, but. All right, so go ahead and take your seat. You're still under oath?
Yes, sir.
As you're approaching your seat, Did anybody talk with you about your testimony or discuss anything with you?
No, sir.
All right, sir, have a seat. For your purposes, from where you left off, I have overruled the state's objection. Mr. Taylor has some questions for you.
Sure.
All right, Detective Warren, I'm going to put your actual warrant up on the screen, the affidavit. Do you recognize it? No?
Yes, sir.
Okay. Are you able to see it?
It's a little blurry.
Okay.
Oh, Carol. Yes. Thank you.
Let me give you his actual copy.
Okay.
So that'll assist you. Now, this was the affidavit that you took to the judge, correct?
Yes, sir.
All right. So I've highlighted on that affidavit in that particular paragraph that you see, and I have a couple of things boxed in red, correct?
Yes.
All right. I want to ask you about them. Does it say that upon further investigation, hold on a second. All right, does it say, Detective, in the third sentence of the top paragraph, upon further investigation, a witness explained that Ashley had obtained the scratch on her right side the day before the shooting when she was inadvertently scratched when someone walked by her carrying a box?
So in the fourth sentence, I do see that it says that, yes.
All right, now, I'm going to pass to you a document and ask you if you recognize it.
Appears to be an email from myself.
Don't tell me what it is. I'm just going to ask you some questions.
Okay.
Does that document contain a proposed affidavit that was written by you?
There is an attachment to it. I mean, I can't say indefinitely that's the same one that was sent with it, but there is an attachment to it.
All right. Now, that document was sent on November 2nd, 2020 at 2:06 p.m. in the afternoon, correct?
According to the email you've provided me with, yes, sir.
All right. And if you would turn to the proposed affidavit that's attached to that document that I just handed you.
Okay.
Not the actual warrant.
Yeah, correct.
The email of
the alleged attachment, yes, sir.
Yeah. All right. So if you would tell me, instead of it saying now, a witness explained, is in that proposed affidavit, does it say Barbara Russell?
I'm sorry. Yes. So on the second page, we conduct an interview with Barbara Russell.
Okay. Now, Barbara Russell, her name has been removed from the actual affidavit, has it not?
Yes.
All right. Does it also then say that Douglas Benefield scraped Ashley Benefield with a box?
It does.
Okay. And going back to your actual warrant, does it say Douglas Benefield in your actual warrant?
No, it says someone.
Someone. Okay.
Which could mean Douglas Benefield.
All right. And does it also say in your actual warrant that that someone who scratched Ashley Benefield with a box did so inadvertently?
While walking by, yes.
Now, do you remember, as part of your investigation, you obtained a waiver for you to be able to go speak with Dr. Russell?
That's correct.
And that included also a waiver for Dr. Quintal?
Yes.
All right. Is it not a fact that you admitted to me that in your conversation with Dr. Russell, before you filed this actual affidavit to your warrant, that she told you that Douglas Benefield had become increasingly rough and would body check Ashley Benefield with a box?
I think those were your words.
And did you not agree to them?
I'd have to go back and listen to the interview. I apologize, sir.
Did you prepare to come here today to testify?
I did, sir.
You chose not to listen to it?
Objection.
Sustained.
Do you recall being asked the following question on page 23, line 14? This is your deposition of May 16th, correct?
I don't know. I don't have a copy of it in front of me, sir.
May I approach the witness, Your Honor?
Yes.
May 16th of 23. Okay.
All right. You recall being asked the following questions. All right. And does it say on there, starting on line 11, so she said, this is Dr. Russell. So she said he had become increasingly rough, like he'd pick up a box to move it, pass her in the hallway, body check her. Your answer, that's what it says. Do you want to see it?
No.
All right. Then the next question, all right, do you recall her making that statement to you? Your answer, vaguely. You recall that?
Yeah, I still vaguely remember that.
Can I just ask for verification of what you were referring to, the first question? The first question was, you said this excerpt says, what was the excerpt that he was looking at?
That Dr. Russell had, may I respond?
Yeah, you're going to have to, because I don't know what we're talking about either.
The excerpt was that Dr. Russell had told the witness that Douglas Benefield had intentionally slammed the cardboard box.
Excerpt from what? Excerpted
from Dr. Russell's statement that this witness took. I was questioning him about the statement that he took from Dr. Russell. And I asked him, is it not a fact that this is what Dr. Russell told you? And that was the answer that he gave.
And this is where I was concerned. We're now impeaching with a prior inconsistent statement, conceivably. Statements that they were made in one version, but not the other version, and left out of another version, or changed in another version. And you're impeaching with a statement from, an out-of-court statement from this witness received from a doctor who I haven't heard from, that was made to her, presumably by the defendant.
No.
So we're just getting so far afield. And this is where I was saying, make your point and get out, because I tried to give you that wide berth, but
I'm on my way out, Judge.
okay.
All right.
All right. I get the point you're trying to make.
Yep. Okay.
The point is, this witness has made multiple prior different statements, spoke with the state, changed it again, left out some what you believe to be material details. I get it.
Okay.
The message is clearly received, if that's the point you're trying to make.
Thank you.
I just believe there's going to be numerous things like we're dealing with right now with this cross-examination.
Let's see how I do, Your Honor.
Okay.
All right. When you bring an arrest warrant to a judge, are you ever asked questions before it's signed?
Excuse me, what kind of questions are you referring to and by whom?
Have you ever been asked questions by a judge about a warrant that you have brought for signature?
Sir, I've submitted numerous warrants. Most of the time we don't talk to the judge.
You've never been questioned by a judge?
Most of the time we don't. Most of the time it's submitted via e-warrants, which is an electronic system.
And it's never happened to you, is your testimony?
Oh, I'm not going to say I've never talked to a judge. I just don't recall an incident off the top of my head.
All right. Let's talk about the wounds to Douglas Benefield and your perception of how they occurred. You stated, did you not, in your affidavit, that based upon the entrance wounds to Douglas Benefield, it does not appear that he was facing Ashley Benefield when she began shooting?
Objection is impeachment.
Sustained.
Did you draw any conclusion as to whether or not Douglas Benefield was facing Ashley Benefield when he was shot?
Do you want me to read the warrant?
No.
No, so this is just testimony.
Just answer the question.
So yes, based on my observations and the work of the team that was assigned to work this case, it appeared that he was not facing her at that time.
Okay. And you know that the medical examiner said that he was?
I don't know what the medical examiner said, sir. I wasn't in here.
Oh, you've never seen the medical examiner's report?
Sustained.
I have seen the medical
Hold on,
examiner's
no,
report.
I sustained it.
Sorry.
It's improper impeachment to impeach this witness with the statement of an out-of-court statement of another witness.
Did you contact the medical examiner's office before you secured and drafted the final version of this warrant?
No, I did not. A detective would have been present at the autopsy, though.
Do you dispute now, as you sit here today, that Mr. Benefield was facing Ashley Benefield when he was shot?
Oh,
Election relevance of his opinion.
Well, I think he's made the one conclusion. I think he could be asked, do you have the same conclusion today? So overruled.
Thank you.
I don't dispute anything the doctor said. He's the ultimate person that would give you that answer.
All right. Now, you also concluded that the wound to the right leg was from the outside of the leg to the inside. Is that correct?
Objection relevance of his opinion.
Again, I don't recall ever hearing him testify to that fact. So I don't know where that's coming from. I have not heard this from his mouth.
Did you reach a conclusion as to the direction of the gunshot to the deceased's right leg?
Objection relevance of his interpretation of the direction of that wound. The state is the one that filed the charge, not the detective, so.
All right, I appreciate it. Overruled. If you can answer.
Sure.
I'm sorry, can you repeat the question?
Did you reach a conclusion, Detective Warren, as to the gunshot wound to the deceased's right leg?
Okay.
Okay, yes, you
As to the direction?
Yes.
Well, like I said, I would defer to the doctor, to be honest with you. I think he has the best opinion on that.
I understand and I appreciate that, but I'm interested in what your conclusion was.
So based on my observations, I wasn't there when he was there and I never saw him in person, would be that the right side of his body was facing Mrs. Benefield.
That's not the question I asked you, Detective. Did you not understand it?
Apparently not. Can you repeat it, sir?
So my question to you is, did you reach a conclusion as to the gunshot wound to Mr. Benefield's right leg?
Based on what I saw and everything at the scene, I believe that his right side was facing her. So that would have been what was struck first.
Did you state that the entry to the leg wound was on the outside of the knee and the exit was on the inside?
I could refer back to the warrant if you'd like, sir.
Please. If that helps refresh your recollection.
Sustained. Well, if he's refreshing recollection, that's a different issue.
Yes.
But
refer to your warrant, Detective, see if that refreshes your recollection.
So in my affidavit for the warrant, one of the rounds entered the outside of the right leg and exited the inside of the right leg. That was based on what I was observing.
And as you sit here today, is that still your position that the entry wound was on the outside of the right knee and the exit wound was on the inside as opposed to it being reversed?
Based on my training experience, what I observed, sure. But like I said, I would always defer to the doctor. I would never argue with a medical expert.
So I would assume then you would defer to the doctor as well as it relates to the proposed wound to the arm.
Absolutely.
All right. So you got wrong. One, whether or not Mr. Benefield was facing Ashley Benefield when he was shot. Correct?
sustained and
All right. Your conclusion was inaccurate.
sustained.
All right, moving on. You told us that you observed Miss Benefield that night, and you did not see any signs of domestic violence, struggle, or things of that nature, such as torn clothing.
That's accurate.
Okay. And is that, in your experience, always the case with domestic disputes?
No, not always.
All right. And you're aware that the shirt that you observed on Miss Benefield that night, where it came from?
I'm sorry, which shirt are you referring to?
You said that you did not observe any torn clothing on Miss Benefield that night.
I did not.
Like her shirt was not torn, her shirt wasn't torn.
I didn't see anything, no.
Okay. Where did the shirt that you remarked that you didn't see torn come from? Do you know?
I have no idea where she purchased the shirt or where she got it, sir.
Okay. Isn't it a fact, Detective? Now, you're the lead detective, correct?
Sure.
That shirt was brought to her by another deputy while she was sitting in the squad car, was it not? That would be Deputy
I wasn't at the
Paul.
scene, sir.
But wouldn't that be something you'd be expected?
I don't know if it is or not. Let him finish the question.
Wouldn't that be something as the lead detective you would be expected to know before you make the statement that you didn't observe any torn clothing, which is inconsistent with domestic violence?
No, and I think if you actually play it back, I already testified to the fact that she was wearing a sports bra.
All right. I want to ask you a couple of questions about the home. You drafted a search warrant for the house, correct?
That's accurate.
All right. And you drafted that search warrant pretty much immediately based on your experience of knowing that you wanted to get into the house to conduct the investigation.
I drafted that search warrant based on the other detectives on scene advising there was probable cause to assume that a potential homicide occurred inside. Yes, sir.
Okay. Now, I'm glad you referred it that way, because isn't it a fact that that warrant that you were drafting less than 75 minutes after the shooting isn't it a fact that you didn't describe it as a homicide, you described it as a murder? Did you not?
I'd have to look at the warrant again, but that's
I'll be
possible,
happy to
sure.
show it to you.
Relevant to the-
Yeah,
Understand the difference.
so what's the relevance?
I think the relevance is to show that this detective had already reached a conclusion that this was a crime rather than a homicide, despite his testimony that he wanted to do a fair and objective investigation over the course of an extended period of time, and that he was referring to it and calling it a murder within approximately 75 minutes following the incident.
All right.
He'd already made his mind up.
Detective Warren, can you step out in the hallway? It's easier if you step, we can send you out.
That's
It's
not a
easier
problem,
than
sir.
having them approach.
That's not a problem, sir.
The rules may invoke, don't discuss your testimony, don't let anybody talk to you about your testimony.
Yes, sir. Thank you.
All right. So I don't think I have the search warrant, unless it was one of the attachments. I don't recall seeing it.
I'll give the court a copy.
Well, let me ask you this. So the point you're making is that instead of using the word homicide as the crime that's being investigated, the detective used murder.
Yes, and
So what statute would you have proposed that he should have used? Because as we know, a search warrant, what's the point of a search warrant? That a crime's occurred or is occurring or has occurred, and that there's probable cause or a reasonable probability that the fruits of that crime or the evidence of that crime is going to be found within the place to be searched.
Yes.
So a search warrant will list a crime or crimes that have alleged to have been committed. So what I'm saying is, what is your argument that he should have put as opposed to murder with 78204?
Yes, sir.
Yeah.
As opposed to 78204?
My argument is that every single member of the Manatee County Sheriff's Office but him described this as a homicide, including the medical examiner, rather than a murder. But that's not enough. This detective, in his deposition to me, believe it or not, under oath, said and represented that every homicide is a murder, and anybody who shoots and kills somebody is a murderer. That is his perception of murder. As opposed to an objective evaluation, what I am tying in is that within 75 minutes after this incident occurred, this detective had already decided that my client had committed murder. That's what I want to bring out.
All right. I appreciate all that. I'm happy to receive that. I'm going to respectfully, as you said today several times, suggest that there is a much more direct route to get where you want to go. There's no jury here, so, impeach, but.
Okay.
Okay, so I think you can get there. I think we can be a little bit more direct about it.
Yes, I understand.
Yeah.
I'll go right to it.
I think, you want to say, hey, you said murder in your search warrant. Yes, I did.
Yep.
That was within 75 minutes of being called out. Yes, it was. And then you can make all those arguments you want to make about how that was biased and his mind was made up and it was predisposed, how this was going to go. And I'll receive all of that.
Understood.
Okay. There was one other issue you were asking about.
Judge, before we move on from that, just so I can understand from defense counsel, is because I'm looking at the actual search warrant and the only time it refers to murder is where it says the statute number. Is that the only instance in which he's referring, or is there some other? I couldn't find another one. I just want to make sure before we continue that we understand.
I assume that's the issue.
Okay, thank you. I just want to make sure.
All right.
I think we can bring him in.
Yes, he's on his way. All right, Detective Warren, take your seat back.
Yes, sir.
Did anybody discuss your testimony with you, approach you, try and talk with you?
No, sir.
All right. So I have sustained the state's last objection. Mr. Taylor.
So, Detective, you described the incident that you were investigating within 75 5 minutes of it happening as a murder?
In the search warrant?
Yes.
Sure.
All right.
I think all of our search warrants actually are for the same thing when we're investigating murders.
You did the same thing for 2 other search warrants.
Yes, sir. That's what our unit investigates are murders.
Now, did you tell me under oath that every homicide is a murder?
I believe I might have misspoke when I said that, but so basically the intentional killing, unlawful and intentional killing of a human being is a murder, yes.
Did you tell me, just to make sure that it wasn't a mistake, did you not tell me that anyone who kills is a murderer?
Well, there's differences in whether it being justified
the answer
or not.
to my question, yes?
Objection, is this impeachment? And is
I'm going to sustain.
Thank you.
Again, I think when we're impeaching with a prior inconsistent statement, we don't lead with the out of court statement that might be inconsistent. I would need to hear the testimony here today, what the answer is, and then I can determine if the prior statement is inconsistent. So I'll sustain.
Do you remember me asking you at the deposition the following question? On page 11, line 20, you could have a homicide that's...
Objection and proper impeachment.
I'm going to sustain. I need the answer. I need an answer here in open court, and then we can discuss whether that's a prior inconsistent statement.
Are all homicides murders?
The unlawful killing of a human being is a murder. Yes, sir. There are some cases where it may be justified.
It may also be excusable.
Sure.
Is everybody then who kills a murderer?
And that's a matter of opinion, I guess. But I mean, by the definition, a murder is the unlawful killing of a human being.
Is it your statement that anyone who kills is a murderer?
Objection, asked and answered.
Sustain.
Would you be surprised to learn that you were the only one
Objection.
Let the question finish, please. Go ahead,
in
sir.
the Manatee County Sheriff's Office throughout this case who designated it as a murder as opposed to a homicide?
Don't answer. Sustained.
Another interview that you did was of Dr. Quintal, was it not?
I did an interview with Dr. Quintal, yes.
And you conducted that interview pursuant to a waiver that was given to you by Ashley Benefield so that Dr. Quintal could share with you the health information that he derived from interviewing Ashley Benefield, correct?
Yes, sir. We were trying to gain an idea of what their relationship was like.
Did you learn during your interview with Dr. Quintal that Ashley Benefield was afraid of Douglas Benefield?
He may have made some statements indicating that he had some feeling about that.
Did you learn that she was scared of violence from him?
I don't, like I said, he said a lot of things. He also said he didn't understand why Douglas was with her.
Did you learn that Dr. Quintal told you that Douglas Benefield was a controller?
Objection, this is.
Sustained.
Not offered for the truth, Your Honor, offered for what this witness learned and knew during the course of his investigation.
And that's.
Well, what does that have to do with, I'm not understanding what the relevance of that is. That a doctor told this witness that the defendant said the victim was
Not the
controlling.
defendant, Your Honor, that Douglas Benefield, the victim,
Right.
was a controller.
Right. But the doctor would have heard that from the defendant?
Yes,
All
but
right.
it's also the doctor's opinion. He was giving this detective his opinion of Douglas Benefield, and he was describing Douglas Benefield to this detective. And there's a reason why I'm asking. I'm going to follow up with the question.
It sounds like you're offering that for the truth.
No, sir. I think you'll see why I want to show that this witness was aware of this.
Okay. I don't know, but we're going to see.
I will tie it up for the court very quickly. Do you recall Dr. Quintal telling you that he believed that Douglas Benefield was a fake who used God as a pretense?
I remember the topic of God did come up. I don't remember, like I said, every word that he said verbatim, which is why it would have been tape recorded.
Mm-hmm. And you have that recording, do you know?
You should have it as well. Yes, sir.
Yeah. And do you recall Dr. Quintal telling you that Douglas Benefield?
Yeah, listen, I'm really, sir, not understanding. I mean, what is the point of all of this?
Next question. If Douglas Benefield had a violent background, is that something that you would want to know?
Sure.
Is that something that would be significant for purposes of your investigation?
One of the things that we looked at was he violent with her? That's why we went through all of the reports. We wanted to know the background because, as I stated earlier, we wanted to do a thorough and accurate investigation before anybody was charged with a crime.
Would you tell His Honor, Judge White, whether you ever did a background investigation to determine whether or not Douglas Benefield God is a pretense?
I remember the topic of God did come up. I don't remember, like I said, every word that he said verbatim, which is why it would have been tape recorded.
And you have that recording, do you know?
You should have it as well. Yes, sir.
Yeah. And do you recall Dr. Cantel telling you that Douglas Benefield?
Yeah, listen, I'm really, sir, not understanding. I mean, what is the point of all of this?
Next question. If Douglas Benefield had a violent background, is that something that you would want to know?
Sure.
Is that something that would be significant for purposes of your investigation?
One of the things that we looked at was he violent with her? That's why we went through all of the reports. We wanted to know the background because, as I stated earlier, we wanted to do a thorough and accurate investigation before anybody was charged with a crime.
Would you tell His Honor, Judge White, whether you ever did a background investigation to determine whether or not Douglas Benefield was violent?
We did searches based on what was available through the Manatee County Records database. And I believe we also got some information from Charleston or somewhere up, one of those places up there where there were some allegations, but that was it.
Do you remember me asking you this question at your deposition?
Well, I don't know if it is yet, but it might be inconsistent with the statement that was just made about the investigation that was done, but I don't know.
I asked the question. Do you remember being asked the following question on page 84, line 16? When you investigate a case like this, you told me that you don't recall whether or not you did a background on Douglas Benefield himself. Your answer was, I don't recall doing it myself. No.
You're talking about a background meaning the criminal history. I don't recall doing a criminal history on Douglas Benefield to see if he was a convicted felon, but a background check, it's actually listed, I believe, in some of these other reports where we looked up Manatee County computer records databases and pulled those reports.
So is it your position, Detective Warren, that only convicted felons can have violent backgrounds?
I've overruled.
Thank you.
If you repeat the question.
Is that what you're telling us?
Can you repeat the question?
Yes.
Thank
The
you.
question was, are you telling us that only convicted felons can have violent backgrounds?
No, but there is a difference between doing a computer record check through our personal database and doing a criminal history check through NCIC, FCIC.
So let me ask you the question again, but perhaps you didn't understand it.
Perhaps.
Did you ever do a background investigation to determine what you've told us you would want to know, whether or not Douglas Benefield was prone to violence?
Like I told you, sir, we did searches to find out what information was available. You can change the definition of background check all you want to. Yes, we did our due diligence.
Have you read, by the way, have you had an opportunity to read or discuss the stand your ground motion we filed with the prosecution?
I did, but it was months back, I'm sure.
There was a representation that Douglas Benefield grabbed Mrs. Benefield by the left hand to prevent her from leaving. Do you recall that?
No, not off the top of my head, sir.
All right. You, as part of your duties and responsibilities as the lead detective on the case, you requested swabs, did you not, of various parts of Miss Benefield?
We did.
All right. And that would include her left hand, would it not?
It would have included the areas that we were explained by her attorneys to pay the most attention to.
Did it include her left hand, detective?
You would have to probably direct that towards the crime scene tech that collected the swabs.
Well, how about if I use your report?
Okay.
Objection, Judge.
Yeah, if he's just relating what someone else said or did.
No, I'm
going to sustain.
I'm asking if he requested that swabs be taken of her left hand.
Okay. That question can be asked.
Yeah. That was the question. Did you request swabs be taken of Miss Benefield's left hand?
I requested the swabs be taken of her arms, legs, hands, and neck.
Okay. As part of your duties and responsibilities as a lead detective, did you ever get the laboratory results of those swabs from FDLE, Florida Department of Law Enforcement?
Was it FDLE or DNA Labs International?
Actually, I believe it was DNA Labs International. I stand corrected.
Okay.
Did you get the results back?
Yes.
Did you learn that out of all the people in the world,
Objection to asking this witness about the results of the DNA.
Again, you can ask your question and then we'll have the objection. Again, I make this ruling because there's no jury here.
I know.
So if I sustain it, I sustain it.
But he's testifying by asking the question.
well, did you learn that of all the people in the world, only 2 people could not be ruled out for having left DNA on Miss Benefield's left hand? John Sant, the neighbor, and Douglas Benefield.
I'm sorry.
No, do you have an objection?
Yes, that calls for hearsay and
Sustained.
misrepresentation of the report.
I haven't seen the report, but it's hearsay. Absolutely.
All right, Detective, I have a few questions now I'd like to ask you about some areas that we discussed previously under oath. I had asked you at the deposition various things about Douglas Benefield. For example,
Objection, is this impeachment?
I don't know.
I gotta say the question.
Yeah, so a deposition is an out-of-court statement, which is the first phase of hearsay. I don't know why it's going to be offered, but I don't know if you're refreshing our recollection, which is done a different way. I don't know if you're impeaching. If you're impeaching with a prior inconsistent statement, all I can say is, again, I need a statement here in open court, and then we can figure out if that prior statement was inconsistent.
Here comes the statement. Detective, do you have an opinion? How would you describe Mr. Benefield admitting that he shot a gun in the house, in the kitchen, to intimidate Miss Benefield to stop speaking?
Objection.
Sustained.
How would you characterize such?
Hold on, I didn't hear the rest of it.
Yeah, I'm just asking him how he would characterize such an act of shooting a gun in the kitchen to intimidate someone from speaking any further.
You want this witness's opinion about how he would characterize without any frame of reference. I mean, what do you mean?
Okay. Detective, were you aware that there was an allegation that Douglas Benefield had shot a gun in the kitchen ceiling of their home to stop Mrs. Benefield from speaking any further?
I was aware, or I had heard that there was an incident allegedly that a firearm was discharged in the residence into the ceiling.
And would you describe that as a violent act?
I guess it all depends on the purpose and how it occurred.
Such as?
Objection as to his opinion.
Yeah, I'm going to sustain on and we're getting into a collateral matter, how this witness would characterize an act that he did investigate, he wasn't there for, he's heard about through some unknown source. So, no, what his opinion of that, I'm going to find is irrelevant.
All right. Were you aware during the course of your investigation, Detective, that there was an allegation that Mr. Benefield would punch holes in the drywall of their home?
I believe that I had heard something like that, but I don't recall where that was from.
Were you aware that there was an allegation that Mr. Benefield had beaten his first wife up on their honeymoon?
Objection, Judge, what is it? It is irrelevant what this detective may or may not have known about his past.
Well, actually, Judge, this detective has testified that whether Mr. Benefield had a violent background is something he would want to know, that it would be significant to his investigation.
Right. You know, I'm not taking any of this for the truth of the matter asserted.
I understand.
All you're asking is, did you hear this? It doesn't prove that those things happened.
I understand that.
So I'm not sure why we're asking them this problem.
And that would be the second question is, so what's the relevance of whether he heard that the decedent may have been violent towards, I don't know, would you say a first wife? I don't even know who that is. I don't know when they were married, how long they were married. I don't know the nature of their relationship. So I'm going to sustain as irrelevant.
Okay. You are aware, are you not, of an incident where Mr. Benefield was seen by a neighbor at night standing in her yard?
Sorry. Yeah, actually, we discussed that during the deposition. I remember because I had some questions about it myself.
There's a police report that accompanied it. Have you reviewed it?
I did it one time, and I believe that the witness said that there was a person standing there. And I asked you how we got him identified, because I guess they identified him by his voice is what you told me, which I found odd, because why would you sneak around and then talk? Kind of, you know.
Did you review that witness's deposition?
I did not.
It's Exhibit 5 to our standing ground.
I don't have access to those, so.
Have you ever placed a tracker on anybody's car?
Relevant.
I'll overrule.
Have you ever placed a tracker on anybody's car without the appropriate legal authority?
No, but I've done it with the proper legal authority several times.
I want to lastly ask you about some photographs of Miss Benefield. There were 2 sets of photographs taken you testified to, correct?
Yes, sir.
Some were on the evening of the incident, and then there was a set that were taken a few days later.
Yes, sir. That's accurate.
So to cut to the quick, if we can, and not test what has up to this point been the judge's considerable patience, the scratches that were preserved in those photographs on Miss Benefield on the night of the incident, you saw them, did you not?
In the photographs later, yes.
Yeah, and they show as red and fresh, do they not?
They appear to be red, yes. I can't tell you how fresh they are. I'm not a wound expert.
Okay, well, they weren't scabbed.
Like I said, I didn't. I saw a photograph later on.
Let me show you the photos.
Sure.
Let me just show them to you. So I don't think that picks it up.
Thank you, sir.
I've asked you 4 photographs that have been previously considered. Do they depict scratches on Miss Benefield on the evening of this incident?
They appear to.
Okay, and do the scratches appear fresh?
I don't think necessarily the one up under the sports bra appears.
Are they? What color are they? Are they pink?
Like I said, I'm not a color palette expert, but I would go with sure. They could be pink or red.
Okay, are any of them scabbed?
It's kind of hard to tell because they're so minute.
Do you see any scab?
No, and I don't actually even see an open wound on this one that would scab over. So
okay, let me show you the photographs that were taken a few days later.
Okay. Thank you, sir.
Why are these not marked? Yeah, if you're going to use photos, you either need to mark the ones you're using or use the ones that have already been admitted. Because we need to have a record of what you're showing the witness.
All right, let me have them marked.
And Madam Clerk, I'm fine if it's just defense 1, 2, 3, 4, 5, 6. You don't have to use letters or anything. Okay. All right, we're going to call these defense 1 through 6.
Very good, Your Honor. All right, for the record, Detective, I previously showed you defense exhibits 1 through 4, correct?
Yes, sir. That's correct. There you go.
Now I'm
Could
going,
I just see them? I'm sorry.
now I'm going to show you defendant's exhibits 5 and 6.
Thank you.
I'm going to ask you if those are the photographs that were taken several days later.
You would have to talk to the crime scene tech about that for proper identification, but I believe so. Yes, sir.
And is the color of those scratches different than the color of the scratches in the photographs that were 1 through 4?
Well, the scratch that was on her hip, the red scratch that I said didn't have a scab, that's not even photographed in any of these, just so you know. It's actually gone.
Mm-hmm.
Other than that small little minute thing you can barely see, there does appear to be some scabbing, but it's very, like I said, very tiny.
Okay. Are you familiar with the concept of blading?
I am.
And educate us a little bit about what blading is in the sense of it being a defensive posture.
Are we talking about it in regards to law enforcement?
No.
Okay, well, I'm just, I'm not a jujitsu expert or anything, so.
I understand. I'm talking about with respect to minimizing the area of your body that is exposed to potential gunfire.
Okay, I guess if you were trying to minimize the area exposed, you would possibly turn your smallest side to it. Which would be your side? Sure.
Okay, otherwise known as blading.
If that's what you want to call it. Blading typically isn't a complete turn. It's more of a 45-degree angle or so.
Okay, again, to minimize the exposure.
Well, blading, interview stands, those types of things, blading is typically done like for our purposes. If I'm out interviewing a suspect, I'm going to blade my body and turn my gun sight away from them because honestly, that's more of a threat if they're looking at my gun while they're thinking about fighting me. I want to keep that away from. It also provides for balance.
Right. You want to make sure that they can't get the drop on you.
It's more of a safety thing than an offensive thing, at least in my opinion.
Yeah, to protect.
Like I said,
you.
I'm not an expert, so.
To protect you. As part of your investigation, you determined that the firearm that was used to shoot Mr. Benefield was owned by Ashley Benefield.
One of our detectives, I'm sure, did would have done that part of it. I don't recall doing that part myself.
All right, but you do recall it was lawfully owned by her.
As far as I'm aware, yes.
Yeah, and that she had a concealed weapons permit.
She may have. I don't remember what she did at that point, but it's possible.
I don't believe I have anything further, Your Honor. Thank you for your patience.
State, redirect.
Yeah.
All right, can this witness be excused?
Yeah.
Defense, can the witness be excused? Mr. Taylor, can the witness be excused?
Yes.
All right,
Okay.
Detective Warren, you're excused.
Thank you, sir.
Oh, can you reach me those papers?
Yes, sir. There's a couple paper clips here. You want those too? Oh, yeah. Yes, sir. Yes, sir.
Mr. Taylor, I think these are yours papers. And your paper clips. Yes, sir. All right. State?
The next witness is going to be a little lengthy. Do you think we could take a 5-minute break before we start?
Sure, absolutely.
Thank you.
Oh, I can't see that. It is 4:06. How about, 4:15, maybe a few minutes after 4:15?
Right, let's skip this bad boy then. Till we find it. Is the Commonwealth fighting her or the family of the dead? They're fighting her, as in, so she shot him. She did. It's just a question of was it self-defense or not, boo boo. Basically, was it self-defense or not?
Because of relevance, and we believe them to be relevant, but as Your Honor has noted, no jury. So, however, the court wants the truth.
Relevance.
Judge, the relevance is the tenor of their relationship. This is all after she's made all of these allegations against the defendant, or I'm sorry, against the victim, and all of them have been shot down. And then she's telling people that she's afraid of the defendant or of the victim, I'm sorry, and she's afraid for her child, but yet she's having these text conversations with him that clearly there doesn't appear to be any fear, and it helps set the tone for their relationship.
All right. There was also, I know relevance was now, but there was also the objection to hearsay, not as to obviously the text attributable to the defendant, right, or come in.
Right.
But what about the argument that any text by was alleged to be Mr. Benefield hearsay?
I would have to know which text specifically, but like for instance, he says trucker on the way as the last text. So my argument for that would be statement of intent, that hearsay is allowed to come in if it's a statement of intent by a witness and the state is trying to show that the witness complied or acted in compliance with that statement. So that would be my response to that. The other ones of good morning, good night, those aren't offered for the truth of the matter today.
All right. Yes, sir, Mr. Taylor. So there's your answers to your two objections. So anything else you want to put on the record, sir?
I don't believe so, Your Honor. I'm a lot more concerned with the next witness that I'd like to take on the court.
All right. Well, there's some foreshadowing for you. Okay, I'm going to allow it. I'm going to overrule the objections. Defense states 45 is admitted, that being the text messages. I find them relevant solely for the purpose of the state's argument, and that's the only way that I'm going to take them, because that's why the state has said they're offering them, is just to show the nature and tenor of the communications and the relationship between the parties in the days leading up to the event. And as to hearsay, certainly any statements made by the defendant or attributable to the defendant as part of this text messaging would be admissible under the rules. And as to the other ones, again, I don't find that they're offered for the truth of the matter asserted. With the good night, the good morning, what do you need at Lowe's? You want to go to Panera? I'm taking it solely for the purposes that the state has said they're submitting it. So I will overrule on that. All right, sorry about that. I got my papers out of order and started numbering incorrectly. So now I'm good to go. All right, who is the next witness?
The next witness is Detective Bryan Morlan. So is that?
So if there's concerns, let's hear them now, I guess. If they're general concerns as opposed to discrete portions of his testimony.
I think this witness marks the beginning of the down the rabbit hole that we were hoping to avoid, only because this is the detective, Judge White, that was assigned to the DCF cases and the allegations of abuse by Mrs. Benefield against Mr. Douglas Benefield. And I don't think it has any relevance whatsoever to the proceedings. I think that we're going to end up in a dispute as to what the conclusions were, that is to say, unfounded, unsubstantiated, as opposed to ridiculous or nonsense, that kind of thing. It's one thing when something is not proven by insufficient evidence. It's quite another thing when it is determined to be unfounded. I don't know that any of the DCF people who actually made the decisions are going to be present to be able to be cross-examined. And I think even if they were, I don't think that that's a road that we want to go down because, again, I don't think it has any relevance to the proceedings at all. Even if we give the state the benefit of their theory in creating motive and showing what they want to show, such as the text messages between parties that they were getting along, I don't know what the substance of the abuse allegations links to that.
All right, let me just say this. That's where my mind is going, but I don't know anything about these allegations. I don't think it's in any of the paperwork.
I can tell you, Judge, my intention, and it's for the same reason that I entered Judge Morlan's oral order for the previous things. I do not intend to get into anything other than there was a complaint, who investigated, was it sexual abuse or physical abuse, and against who? And then was it investigated, and did this detective close the case? Or, file the case, or how did it work?
Okay. Let me get a little bit more. Oh, hold on. As you may have noticed, I'm pretty big on procedure. And so I go with proponent, and then I come back to the non-movement or non-proponent, and then I come back for rebuttal. So when I come to you, tell me everything you want to know, because I don't ping pong back and forth. But I have questions.
Yes.
Because I don't know anything about this. Who are the complaints against?
The complaints are the defendant making complaints of sexual and physical abuse against the victim.
Regarding what child?
The same child, Emerson.
Emerson.
Yes.
Because I've heard about an older child.
Yes.
And Emerson. All right, so these are complaints made by the defendant
Yes.
against the decedent
Yes.
regarding their natural
Their
child.
natural child who was a toddler at the time.
When were they made?
I have the dates. December 10th, 2019. March 21st, 2020. March 23rd, 2020. April 5th, 2020. And April 27th, 2020.
Oops, sorry. All right. So tell me, what is your theory as to why these tend to prove or disprove any material facts that I need to consider?
Well, to me, there are two issues. There's credibility, ultimately the credibility of the defendant, because we have to take the facts as known by her, or as at least as she's saying. So the credibility of the defendant is an issue. So some of these things that I'm getting into go towards the credibility or lack of credibility. These things also go to the motive for this, because the defendant attempted in court over and over and over to stop this communication with the child, and Judge Morlan stopped that. So she changed tack and then went to abuse against the child as opposed to supposed abuse against her. And she attempted for the abuse against the child. And she even makes comments to a witness that we're going to have later on that nobody will help me. You know, what am I going to do? Nobody will listen to me, because these reports were not being filed by law enforcement. And then at the time, all of this is going on at the time they're uniting it in the text messages. So
all of what's going on?
These complaints are going on before the text messages where they're.
Yeah, I was going to say, because those are from the week before. These are months before.
Yes. So these had already been made. I apologize. These had already been made at the time that they're talking like they are here. And her argument is, I just want to save my child. That's the only reason I'm around him. This is all going to come out later on. And otherwise I would never be around him. Nobody will listen to me. I have to move to Maryland to get a new family jurisdiction. So this goes into everyone. She had exhausted, in the state's opinion, every avenue that she could to keep this man away from the child. And when she felt like no one else was going to do anything, this was the result.
All right. Anything else?
No.
All right. Now, sir.
So, Your Honor, you wear the robe. But all I can say is, as I tried to explain in my opening statement, the parameters of the stand your ground statute require the state to prove by clear and convincing evidence why the force used was not justified. I don't see how motive has anything to do with that. I also don't respectfully see how complaints about abuse have anything to do with that. And what I'm particularly concerned about, and the reason why I think it's going to be, to a great extent, a depletion of the court's time unnecessarily, is that this detective was not the one who received the complaints. That would have been DCF. So this detective, whatever he has to say, is going to the extent it's substantive, is going to be based on rank hearsay. That's number one. Number two, I'm concerned about this detective offering an opinion as to how the case was closed. Assuming the court were to allow it, I could understand if the state asks, and was the case closed? Yes, okay, next. On the other hand, I could not understand if the question is, how was the case closed? Well, it was closed as unfounded. In other words, there was not a scintilla of truth to it. How am I going to cross-examine this detective based upon that conclusion, which was rendered by somebody else?
All right, so what I'm hearing is this detective, he's a CAC?
Yes.
All right, crimes against children. A complaint was made?
Yes. To the sheriff's office.
By the defendant?
5 times, yes.
Hold on. For each individual complaint?
Yes.
Complaint was made by the defendant on such and such a date against the decedent. Just a very broad category alleging some sort of abuse against their natural daughter. It was investigated and it was closed. Right? That's all you want.
Judge, I believe its effect on listener the same as Judge Morlan's order, the fact that it was closed unfounded. That is the part that has an effect on the defendant. I'm not offering it to prove that there was no evidence of it, just with the defendant.
And this is the weird thing, because I've heard that now. But I think the point is, what your point is, it was closed and no action was taken. Whether it was unfounded, unsubstantiated, fanciful, improbable, I don't even know what they're, I do know unsubstantiated, unfounded. No, I think those are the big ones. I'll allow that. I'll allow the fact it was closed with no action taken.
if I could just let him know. I mean,
Yeah, let him know,
we're
and,
not a jury.
and I'll prepare the curative instruction for the jury.
Okay.
But at the end of the day, I understand, and this is what I was saying earlier to the defense is, I understand the point you're trying to make. I get it. I know where you're going. No problem. I'm with you. I'm following you. The same as with Mr. Taylor. I just think there's a much more direct way to get there. All right. In fact, quite frankly, if that's all it's going to be, there could probably be a stipulation here, but that's all I'm going to allow. And then you can argue at the end, and you can argue at the end the opposite side.
Okay.
Okay. That she was absolutely privileged to make these complaints, and you know, she must have had a good faith basis to do so, and so be it. There was no action taken.
I wouldn't have a problem stipulating to that.
Judge, I would rather call the witness.
That's fine. And I'm not, listen, I honestly, I just threw that out there. You know how I sometimes do things gratuitously, which I shouldn't. So go ahead.
State Falls Detective Bryan Morlan.
I'm prone to gratuitous musings.
I just want to let you know I tried to say it all the time.
No problem.
This judge was like, just get fucking on with it, guys. Just get on with it.
Thank you, sir.
Please state your name.
Detective Bryan Morlan,
Where do you work?
Manatee County Sheriff's Office.
Okay. Are you in relation to Judge Morlan?
No, ma'am.
Okay. How long have you worked for Manatee County Sheriff's Office?
Since 2004.
What is your current position?
I'm a crimes against children detective
How long have you done that?
since 2011.
And what does a crimes against children detective investigate, just generally? What kinds of crimes?
We take general assignment, so any kind of abuse, neglect, death investigation, sexual abuse, things like that. Anything that happens to anybody under the age of 18 years.
Okay, so of children.
Yes.
Okay. When you investigate either of those allegations, either physical abuse or sexual abuse, do other agencies all work together with you?
Other entities do, yes, ma'am.
Entities. Okay, and who are those entities?
Generally, child protection, the child protection team, which is here in Manatee County, and then what I would refer to as DCF or Child Protection Services.
Okay, so I just want to make clear, you're law enforcement, so you do investigations for criminal charges.
That's correct.
Okay, and if DCF is involved, they are not investigating for criminal charges, correct?
Correct.
Okay. So they have different goals, I guess is my point.
Their goal is the safety of the children involved.
Okay. And CPT is not a part of DCF. I just want to put that on the record.
No, ma'am.
Okay. When there's an allegation of abuse, what is the protocol? Who goes out to investigate first?
Generally, what happens in at least my criminal investigations is once the allegations are made, they'll go through the Florida Abuse Hotline. CPS would get involved, call for law enforcement. Generally, what happens is a uniformed law enforcement deputy goes out and takes the initial investigation. If further investigation is warranted, it'll make its way to our office and get assigned to a detective.
Okay, so, and during this process where there's an initial law enforcement officer, is there typically someone from DCF there? I think you said CPI.
CPI.
Okay, which is a part of DCF.
Yes, child protection investigator.
Okay. So only when further investigation is needed do you get assigned?
Correct.
Were you in that position, the same position you're in now back in 2019?
Yes, ma'am.
Did you become familiar with someone named Ashley Benefield?
Yes, ma'am.
And her child with Doug Benefield, Emerson?
Yes, ma'am.
Okay. Were you involved in investigating a series of allegations starting back, I guess, in 2017, but really in 19, I guess, is what I want to concentrate on?
Yes.
Okay. Let's start with the first allegation that came in 2019, the date of December 2019.
Yes, ma'am.
Do you recall that allegation?
Mhm.
Okay. And without getting too much into the facts of it, what type of an allegation was it?
That was a sexual abuse allegation.
Sexual abuse allegation, and the allegation was made by
The reporting party was Ashley Benefield.
Ashley Benefield, and saying who was doing the abusing.
Doug Benefield.
Okay. And clearly you opened up a MSO case number on that.
It was opened by the uniform deputy.
Already open. Okay. So at this time, the uniform deputy had already gone out as well as the child protection investigator.
Yes, ma'am.
Okay. Do you know if she went to CPT that time?
In 2019, she was seen by Dr. Riley at CPT. Yes.
Okay. And CPT, that is a medical exam?
They perform two functions for us. In my criminal investigations, they do forensic interviews for us and also medical evaluations. Yes.
With respect to what we're talking about with Emerson, she was how old?
She was too young for
Too
a
young.
forensic interview. Yes.
How old was she? Like 2 or toddler?
Yes.
Okay. After this first complaint came in or allegation came in, did you investigate?
Yes, ma'am.
Did you speak with the parties or speak with Doug Benefield?
I did.
Okay. And did your conversation with him give you any concern?
No.
Okay.
Sustained.
And you eventually just closed that case with no charges, correct?
That's correct.
All right. So I want to talk about the second, what I call the second report. Do you know what date that came in?
Are we referring to a 2020 report?
Yes. Yeah.
May I look at mine?
Yes. Go right ahead.
The report date on that was March 21st, 2020.
Okay. And that was also obviously given an MSO case number. What was that allegation?
That was a physical abuse report.
Okay. And that was, again, by Ashley Benefield saying Doug Benefield was abusing the child Emerson.
Yes, ma'am.
Okay. To your knowledge, did a deputy and a child protection investigator respond initially before you got it?
Yes, ma'am.
Okay. Before you could fully investigate that case, did another complaint come in?
A few days after that, on the 23rd, another deputy responded to Ms. Benefield's residence and conducted another interview.
Okay, so another allegation, same parties.
Yes.
All right. And what type of an allegation was that?
Also physical abuse.
Physical abuse. And did you investigate both of these reports kind of together?
Yes.
Did you ultimately close that case?
Yes, ma'am.
With no charges?
No charges.
And then the fourth report, can you tell me what date that was?
Report date on that was April 5th, 2020.
Okay. And what was the allegation?
Also physical abuse.
Same parties?
Yes, ma'am.
Same allegations. Okay. And again, a deputy and a child protection investigator responded. And at some point you were assigned the case?
Yes, ma'am.
Okay. And again, before you could fully investigate this, did another complaint come in?
That I don't recall.
Okay.
Hi, Unicorn.
I have something dated April 27th of 20. Do you have any notation of that in your file? With Deputy Shrink?
I think this hearing has sent everyone to sleep. As El Shafty has been quiet. I know also the timing of this current read motion. Crap. Everyone's just disappeared. It's so quiet. So I hope people give this trial a chance. I think it's going to be a really good trial. It's just obviously timing today has been crap. And it's actually more boring than I thought it was. But the trial should be good. I hope everyone gives it a chance, at least. I hope people come back. Everyone just disappeared. Unicorn, this is, don't worry, you don't need to watch. It's basically this thing, right? So ballerina, I'll play it forward. We only got about now that hour to go, but it's a ballerina, and she basically shoots her husband. So there's no denial she shot her husband. It's just whether it's self-defense or not, basically. So this was a trial. This was a hearing for standing ground to see if that was going to, be given or not. Spoiler alert, obviously wasn't given because she's going to trial. So I wouldn't go back and watch it. That's the fundamentals of it. I think you could do a quick Google on it. So that's probably the best part, I'd say, because there's not much. There's a lot of arguing back and forth, pettiness and stuff happening. So I wouldn't go back. But we're doing Alec Baldwin tomorrow, and I'll do some kind of read stuff in the morning. But yeah, this one's not started the 22nd, so plenty of time. I just want to put this on just to give people a taster. But I forgot how boring it was. Fuck. It's on, Dylan. It's on. What's on? People who want to watch trials will be, yeah, absolutely. I think so. It's okay. I thought you, hey, it's on site. Josie, it's on site. Thinking, it's on what? It's okay. It's all good. I'm not surprised. It's more of a, I forgot how boring this was. And when it goes boring, people go quiet. And obviously, we've dropped shit tons of people today. So I was hoping that people wouldn't be bored of this trial. That's all, because I think it's going to be a good trial. Hopefully that scribes it for you. What I just said, Unicorn. Sarah, you go nowhere, girl. Hey, Rhode Island. There you go. Hippie chick still here. It's hard to get into. I just want to give people a broad overview of it. The trial will be the main thing, I think. There you go. Hey, Misconduct. How are you, my darling? Hope you're well. Joe's listening. Okay, cool. Cool. There you go. The timing today was what a bombshell today with the Karen Reid stuff. But yeah, it's all good though. It's all good. On TV, so not on chat like usual. It's fine. Yeah, it's fine, Joe. I try to save you. I try to save you without saying anything. I think today's bad luck with it. It is, TJ. It is. It's all good though. It's all good. But yeah, as a reminder, we'll be doing Alec Baldwin tomorrow, people. Hey Emma. Oh, here he is. Big trouble. Me, this lawyer's funny as hell, man. People just don't get watching a shit till he don't understand. I mean, I know. Hope you're well, fella. Hope you're well, my brother. Watch your wine work, so don't try me. It's all good. It's just it went all quiet for like the last couple of hours. Like that's all. It's all good though. We've not got long left, people. We got about now 10 minutes, but it's on 1.25, so it's about 50 minutes, 55 minutes, and then yeah, I'll do the Karen Reid stuff tomorrow during Breakfast Club or Morning Club, whatever we call it. So thank you, Misconduct. Appreciate you, my darling. Thank you so much. I appreciate all of you anyway. So I was just hoping the trial's not too boring for everyone, because I was a bit worried people would be like, this trial's fucking shit. But I think it's genuinely could be quite good. So we'll see. Anyway, back to it. Less speaking, more trialing.
This is when he responded to Ashley's residence, yeah.
Okay. And that was on April 27th.
Yeah.
And that was another allegation, correct? New bruises and sexual abuse?
Allegation of bruising and marks, yes.
Okay. Same parties?
Yes, ma'am.
Did you investigate this case or these two cases?
I did.
And ultimately, you closed those with no charges?
That's correct.
Okay. Thank you. I have no further questions.
Mr. Taylor? Cross?
No question.
Okay, breaking news, people. So, lead investigator in the Karen Reid case, Massachusetts State Trooper Proctor, is suspended without pay after duty status hearing. So he's suspended without pay. Wow. So he had a hearing today and he's been suspended without pay. You fucking mofo. That's good news. So it's two things, Unicorn. There was a motion to dismiss put in today because, what do you call it? The jury come forward to the defense to say that all 12 voted not guilty for murder and not guilty for leaving the scene of a crime. And the manslaughter charge, the vote was 8 guilty, 4 not guilty. So they're trying to dismiss all the charges, basically, is what they're trying to do. And now this one, now obviously breaking news about Trooper Proctor or Proctor Trooper suspended without pay. Ooh. Also good. No, we had a pile earlier on, pile of them. Then Karen Reid's news broke and everyone went over to Melanie Little. So, but it's fine though. Purple Bunker. I know. Eat that, Lizzie Proctor. I know. I agree. But what a fucker Proctor is. Firing will come next, just to get the lawyers around to do it right. It's because of the union. I think it takes delay because of the unions, and the unions have to they have to work with people like Erin Hack. Erin Hack's on the other side, all 4'1" of her, just So that's what the unions are going to encounter for the next few months. But yeah, that's good news. Good news all around today, I think. Right, let's watch the mother MO for last bit of this as well.
For Detective Morlan.
All right, can a witness be released?
Yes.
Yes.
All right, sir, you're releasing your subpoena. Thank you.
Sir.
State would call Dr. Breder.
Mark, this one we need to have a little powwow.
Okay, don't bring in Dr. Breder yet. Thank you, Deputy.
Thank you, sir.
All right, go ahead and put your objections on the record, and then I'll hear from the state.
Your Honor, for this, I rely exclusively on the Florida Evidence Code, which is really, really clear about character evidence. And I've read these reports. What Dr. Breder is going to testify to about Ms. Benefield and his conclusions clearly go to her character. And the evidence code says in no uncertain terms, it's inadmissible until such time as the defense puts her character, if at all, in issue. What is admissible is Douglas Benefield's character. According to that same statute, I gave the court a memorandum on it. I know while I haven't spent that much time before the court, I have spent enough time to know that the court reads everything. So I know Your Honor has reviewed it. I don't think, honestly, Judge, there is an exception to it. And what I'm particularly concerned about is the state is about to call a professional who's going to opine as to characteristics of Ms. Benefield that really have no place in this hearing. And while I firmly believe at the end of the day, Your Honor will parse this appropriately, I have some real concerns about this kind of testimony and whether or not the court would be capable of that. So I think it's improper.
All right. State, what do you expect Dr. Breder is going to testify about?
Okay, there are several things. Most of what I try to keep Dr. Broder's testimony to is his observations of the defendant and the victim and the child. Also things that the defendant told him. So I try to section this out to sections that I did not believe would be objectionable. But then there is a section where he does talk about some testing that he did, and some of his opinions and diagnoses of her would suggest that she has, it would probably be improper for me to get too far into it, but suggests that she does exaggerate facts, that she does exhibit paranoia about things. And I think that is highly relevant to the self-defense argument. First of all, I believe the defendant has put her character into question by asserting self-defense in the motion, even though we're not technically in trial. But I do agree that character evidence only has certain ways that it can be proven, and that's not what the state's trying to do. What the state is trying to do is the court has to determine if this use of self-defense was valid based on the facts as they were known to the defendant at the time. And as I've argued before, the only person that knows the facts as were known to the defendant at the time is the defendant. And if a professional has investigated her and evaluated her extensively and says she has a tendency to exploit the facts and exaggerate the facts and be a victim when she's not necessarily a victim, I think it goes to the facts as seen by the defendant at the time and the reasonableness of her belief that she needed to use deadly force.
All right, so let's talk about that one first. And you can sit, you don't have to.
Okay, it's just hard.
I understand.
Remember to do that.
And if you want to, that's fine. If you want to stand up and move around, that's fine too.
Okay.
So we certainly have to look at the use of force as informed by the facts and understanding that the defendant had on that day, which sometimes misleads folks into thinking it's a subjective test. It is not. It is knowing the facts that would have been within the defendant's ambit of knowledge at that time. What would a reasonable person have done? So I don't look at what would a reasonable person who tends to exaggerate situations. I'm not concerned with a reasonable person who's paranoid or mentally ill or schizophrenic or any of those. I'm just, what are the facts that were available to and known to the defendant? And were the actions of the defendant reasonable in looking at it from the perspective of a reasonable person? So I guess I'll say that I'm not seeing, and I'll come to you. Don't think I'm not coming over there. I am. But before I go over there, I want to make sure I understand what the testing of the defendant and the diagnosis that she exaggerates and may suffer from paranoia, to the extent that those are diagnoses, DSM-4 or 5, whatever we're on now. So I want to hear a little bit more about that, but also what the observations of the defendant, the victim, and the child, what those are, when were they, and what's the relevance of any observations that that witness may have made. Defendant's statement's another issue. I'm not going to spend a lot of time there, because if she made statements to him, as long as they're relevant, they're coming in. But those two things, I'm not quite understanding the testing of the defendant and any diagnoses by Dr. Breder and how that's relevant to the objective person standard, and then the observations of the interactions between the three of them.
Okay, which one do you want me to take?
Whichever one you want first.
Okay, Judge, as far as the testing, I agree that it's an objective standard. But if your only recitation of the facts is told by someone who suffers from histrionic personality disorder and makes herself a victim all the time, then her view of the facts, it goes to her credibility, her view of the facts as is being put forth in the motion and possibly in this courtroom is not necessarily as reliable.
Let me ask you this. Is the defendant's motion substantive evidence that I can consider?
I think the defense would say it is.
But I'm asking you.
No.
I'm just going to ask that limited question. Is the defendant's motion substantive evidence that I can consider?
Absolutely.
And you have a case that says that. I don't think it's not sworn to, is it?
No.
Now, hold on. Let me say this. I completely understand that in order to make a prima facie case, and I believe this as well, not just I know this is the case law, that a motion to dismiss under the stand your ground statutes does not need to be sworn to. All it has to do is set forth a prima facie case. So with that said, though, how do I consider that as substantive evidence when it's a motion written by the attorney on behalf of the client, and I don't see any manifestation of an adoption of that?
Well, I can answer that. Number one, the state has stipulated and acknowledged that it meets the prima facie.
That's it. That is a pleading threshold.
Yeah.
That's not a substantive evidence threshold. All it is a pleading threshold.
Right, and the appellate court has said that Your Honor is obligated to take the averments as true.
In determining prima facie, and I agree, there's a prima facie case. My question is, under what authority, so I'm looking for a statute, a rule, or a case, says that an unsworn motion to dismiss under stand your ground can be considered as substantive evidence?
Well, I think at this juncture, the only inquiry for the court is whether or not the state produces evidence clearly and convincingly that the force used was not justified.
100%, I agree with that.
And that therein exposes, I think, her argument in this sense. Whether or not Ms. Benefield exaggerated things has nothing to do with what the state, at least up until now, has yet to produce. I was going to use scintilla of evidence, but I'm kind of burned on that one. Has yet to produce any evidence whatsoever, which is the violent nature of Douglas Benefield. And was my client, the objective standard, on that day, knowing what she knew about him, firing the gun in the kitchen, placing a tracker on her car, was she justified in resorting to deadly force? I've yet to hear anything about that refutes that. I only have heard a case that is intending to show motive.
I appreciate that for your closing argument. My question is much, much more narrowly tailored. Can the court consider the defendant's motion to dismiss for stand your ground reasons that was written by the attorney, is not verified, has not been adopted as a defendant's statement, as substantive evidence? And so we'll leave that right now on the table because I'm not aware of any case law that says it's substantive evidence. But let me come back to you. And I think I kind of got off on that tangent. Based upon the observations, is that where we left off? Or is this still on the testing?
I believe it was on the testing.
Okay.
Brothers testing.
Okay, so yes, I think that's where we were. We were talking about how the court does have to determine the facts as known to the defendant. And when you're evaluating what's known to the defendant, I think the credibility of how she views things is highly relevant to the recitation of the facts. And so I don't know how the substantive evidence or non-substantive evidence in the motion to dismiss plays into that. The burden has shifted to me. She has said self-defense, so I do feel like we have to prove otherwise. So the fact that she has these traits and has been seen to do it, I think plays into the facts as known to her.
I think if there's going to be substantive evidence in front of me, all I know right now is that a prima facie case has been pled. That's it. Now the burden shifts to the state to prove by competent and substantial evidence that proves clearly and convincingly that the defendant is not entitled to. But I don't think the facts as alleged in the defendant's motion are substantive evidence. I'll look back through my notes, but I know there's been a lot of cross-examination on allegations of prior violence and so forth. And my take on that all has been, well, yeah, I heard about that, but not, yes, that happened, or yes, it's true. I just don't consider that as let's just call it proof. So I think if at some point the defendant's statements are in front of me, whether it's here in court or was it a recorded statement?
Yeah. Okay.
So for right now, I just don't think that beyond the fact that there's a prima facie case of self-defense and now the state has to rebut that. So I'm not at this point. I mean, there might be rebuttal where Dr. Breder can bring that all in, but at this point, I don't think it's relevant to preemptively show that she exaggerates or is paranoid. All right, now on the observations.
On the observations, it again goes to the state's allegation of motive that she is trying everything to get rid of this victim, and she's tried violence against her and it hasn't worked. She's tried violence against the child and it hasn't worked, and so it goes to her credibility and motive that she's telling the the victim one thing, she is acting another way in private. It shows that she is being manipulative and she is not at all wanting to have this nice family relationship, which goes to her motive to get rid of him. She doesn't want him around.
All right, let me take even a further step back. And this is an example of where you guys know the case so much better than me. What observations do you expect Dr. Breder to testify to? I saw it on this day. I saw this.
The seeing is mostly with the child, because the allegations were of abuse, and the seeing is the child interacting with mom and dad. The rest of it is the defendant's statements.
All right, so the observations, I'm only talking about that right now. The observations portion, which was number one of the testimony you intend to elicit from Dr. Breder, is that he observed the decedent interacting with the child, Emerson, presumably in a positive way.
Yes.
And the child didn't exhibit any external manifestations of fear or...
Correct.
Okay. When were these observations made?
And I have to look at my questions, but the report was set to come out. It came out, I think, a week before he was killed. So he met with them 10, 15 times. So I'm not sure exactly what date, but I can tell you when he was asked to do the report, when he was assigned to do the evaluations of the two of them. It was. They don't have a date. Hang on, Judge, I'll find it. Trying to find this report, Judge. Here.
I agree. I think he's excellent so far, anyway.
No, I don't know how long it's going to be, but there's several statements.
Okay. I don't know what they are. All right, sir, Mr. Taylor. So I've already said I'm not going to allow the testing and the diagnosis until I think there is substantive evidence in the record of defendant statements or character that would allow that to be used. Maybe in rebuttal, we'll see. But now to observations. Did you want to be heard on the observations of Dr. Breder?
Well, let's assume, I think the court got to it right quick. Let's assume that he's going to come in, he's going to testify. I observed Douglas Benefield with Emerson, and Emerson appears to be quite happy. Okay, so that's, I guess, another way of establishing that the complaints were closed with no finding. So it's, I guess, reinforcing the state's establishment of motive. So the question becomes, for something that's not an essential ingredient of this hearing, that does not go to one of the facts and issue, just how much reinforcement to a non-essential element is the court going to allow? I don't think that there's a thing that Dr. Breder is going to say about observing the interaction between the father and his daughter that's adverse. I think the court figured that out pretty quickly. So then the question is, so what's the relevance of it? What's the benefit of it? What's material to it? Because it does not run to supporting any fact and issue. What I do think, Your Honor, is that if she is allowed to call Dr. Breder and Dr. Breder is allowed to testify, I believe I can question Dr. Breder about his conclusions as they related to Douglas Benefield. I think that the evidence code clearly provides for that. I have alleged that Douglas Benefield was violent. I've attached to our motion, which I think the court can consider substance evidence, admissions by Mr. Benefield under oath, and that I am entitled to bring out from this psychologist who the state is going to call that he concluded Douglas Benefield suffered from obsessive compulsive personality, and that somebody with that diagnosis likes to control their circumstances, their situation, which would include, according to Dr. Breder, quote, their marriage, parenthetical, Ashley, end parenthetical, quote. Dr. Breder also hears Ashley's chief complaint, which is that he's violent, he's jealous, he's manipulative. These are things that she feels. If the state wants to go down that road, I think then I'm entitled to cross on it.
All right. I don't know because I haven't heard his testimony yet. It may be within the scope of direct and it may be outside of the scope of direct. I don't know how far they would get into that. I think that's more of a game time decision. All right, State, any final thoughts?
No, I just want to put on the record that I disagree that if I do get into certain things about the defendant, that it opens the door naturally to talk about his impressions and diagnosis of
I think I would like to see that a little bit.
And that's why I said, I don't know. Because I don't know what his testimony is going to be. Certainly it's something that could happen. I don't know. Maybe it's relevant to some issue you raise. I don't know. But more specific to the observations that Dr. Breder made regarding the interactions between the decedent and the child, the ruling is much like I just made with Detective Morlan. If you want to get a little bit at, and let me be clear, if I'm understanding how this is going to come full circle, that a couple of days before this, it's what I'm understanding from you and from what I'm piecing together as we go forward. A couple of days before the incident alleged in the information, Dr. Breder issued a report, and that the defendant would have seen that report, seen that Dr. Breder made positive observations regarding the interactions between the victim and the child, and that supports the state's theory of why she did what she did.
Your Honor, I'm sorry to interrupt, but Ms. Benefield never saw the.
And that's what I'm trying to understand.
Right, that they did a joint motion to discuss but they had not seen it. I would agree with that.
All right. So what again would so then here's where I'm left. Dr. Breder comes in and he says, around the same time that in the spring of 2020, that.
And I'm sorry, Judge, I did find the date. It's June 1st, 2020.
June 1st of 2020 is the order appointing him.
No, that's when he started his evaluation.
All right. That's what I thought it was for. So then I need to understand again, what is the purpose? What's the relevancy of Dr. Breder's observations of seeing the child have positive interactions with the father? And again, my assumption, I'm sorry, I assumed, was that somewhere along the lines, the parties saw the report or knew about the report. And then your theory was then the defendant said, oh, now even Dr. Breder's not supporting me. Now I have to do something else.
And I ultimately do believe, and that's what I would be arguing in a trial, that is actually what was happening. I think it's the state's argument that the defendant knew that this positive information was going to probably come out in this report.
How? How do you know she knew that?
I know from some of the interactions that were going on between her and Dr. Breder, and some of the interactions that were going on in it were, the three people with Dr. Breder. I can impute it to her that she could see what was going on, and she could see, how Dr. Breder was leaning. And that she knew that that report was going to come out and be given to Judge Morlan.
So now if I'm understanding, it's going to be Dr. Breder's observations of the interactions of the decedent with the child in the presence of the defendant and how those were positive.
I don't know. There were some that were not in her presence and some that were.
All right. Then to the extent, I don't see any way to make it relevant to any issue that I need to determine, but for what effect it might have on the defendant. So to the extent there were some observations of positive interactions between the decedent and his daughter when the defendant was present in the presence of Dr. Breder, I'll allow that. But then that's about it.
Sorry, if you could repeat that.
positive interactions between the decedent and his daughter in the presence of the defendant and in the presence of Dr. Breder. And then I can see how that fits in, and that is relevant to your position. Otherwise, I just don't see the relevance of it.
And my only other argument, Judge, and you may still have the same opinion, but it also goes to the defendant's credibility, saying this child is abused, this child abused, this child abused, this child abused, and the child is acting like this, and her credibility is exactly what's at issue in this case. So.
And that's why I asked about the date. That's why I wanted to know when was he making these observations, to see if it coincided with the reports that were being made, and it doesn't. It's several months after.
Say it was 6 weeks to 2 months afterwards.
It was. So, no, that'll be what I'll allow.
Okay, so let me make sure I have it straight because it's late. So we're not going to talk about the interactions not in the defendant's presence.
Correct.
And we're not going to talk about diagnosis.
Correct.
Okay.
Unless those later on become relevant.
Okay. In like a rebuttal or something.
Sure.
Does the court have any thoughts on cross-examination about my continuing to attack the nature of Douglas Benefield?
I'm just going to leave that open to whether it's within the scope of direct or not. It may not, and it may be. I don't know. But if it's not, then yeah, I would sustain because it's beyond the scope of direct, and then you could call him, and then it may be relevant and may be admissible. I didn't mean relevant. Admissible is the word I want. All right.
And Judge, if I could just have a moment to let him know.
Absolutely.
Okay.
Yeah, we did go through with Laura. Hi, Sarah. Hi, Laura. Hi, Ian. So tomorrow morning club, I'm going to I'll read through the whole thing again. As the whole, it's about 8 pages or 10 pages. I'll go through all the motions again tomorrow morning after everyone's chilled out, and yeah, we'll see what happens. But yeah, if you want to see, so this is tomorrow, 8 o'clock, obviously 1 o'clock UK time. Changed it a little bit, so we're going to look at Karen Reid motions to dismiss. Then we're going to start the Alec Baldwin trial. If I can get the banner up, down, whatever time that is. It's Wednesday morning club. So basically, we're starting Alec Baldwin tomorrow. We missed it today because it's a hearing. So we'll see. Right, let's get back to this one.
Thank you.
Hello, sir.
Good afternoon.
As the deputy said, just 12 to 15 inches from the microphone to adjust up, down, left, right, wherever you need it. Just a good, clear voice will pick up everything. Thank you, sir. Yes, ma'am.
Good afternoon. Please state your name.
Good afternoon. Dr. Brad S. Breder,
How do you spell it?
Broeder.
And it's Brad S., you said?
Yeah, S for Stephen.
Okay. What is your profession?
I'm a psychologist. Clinical psychologist is my degree.
How long have you been doing that?
I received my degree from New York back in February of 1987, and then relocated here to Florida. Started my practice in January of 98 after I was licensed here in Florida. So this is year number 36.
Okay. And what do you currently do? Do you have your own business? Do you have a practice together with someone?
I'm a solo practitioner. I have run my own business, but I do serve as a consultant to Sarasota County and Manatee County Child Protection Team.
Okay. So what is your education to be a psychologist?
Well, I first earned my master's degree in counseling psychology and then went on to pursue my doctorate in clinical psychology.
And you have a sole practice, you said?
That
Sole
is correct,
practitioner?
yes.
And you do consulting work for the county? And who is that?
Yeah.
I think in light of the court's ruling, I don't have any problem acknowledging him as an expert, and we can get on with the limited nature.
Okay.
That's fine, Judge. I just want to establish that he consults for CPT.
All right. I think that was the last thing I wrote down.
Yes.
Yep.
And what does that mean, consult for CPT? What do they ask you to do?
Well, each county in the state of Florida is supposed to have a consulting psychologist because that person helps with the in-service trainings as well as attending the multidisciplinary staffings, consulting work to advise, and then if need be, called in to conduct evaluations either of a parent, a child, or both parents.
And you said that you consult with them. How are you notified when they need you?
Usually the team leader or director will contact me and let me know that what's my availability to attend to staffing. And once or twice a year, I'm kind of on call, let's say, to conduct seminars or workshops.
Okay. And what is a staffing?
The staffing is referred to as multidisciplinary staffing when you'd have different people that are concerned about a case. Usually if the CPI, Child Protective Investigator, has responded to an abuse call, that they will, if based on their concerns, their impressions, their observations, they may then request from CPT, the Child Protection Team, to do an overall evaluation. And based upon that, if there's some concerns or people are undecided or unsure, then we kind of meet as a group. And those people would usually be the DCF representative, supervisor, the CPI, the caseworker from the CPT team, the director or coordinator from the CPT team. If there was a medical examination conducted, there would be the nurse or practitioner there. Pardon me, myself, and usually the invitation goes out to anyone else who might know the family, the parent, or the child.
How did you become, or let me ask you, did you become involved in a case involving Ashley, Doug, and Emerson Benefield?
Yes, I did.
Okay. How did you become involved in that?
I was contacted by Ms. Kimberly Griffin from the Manatee County Child Protection Team. She was at that point the team coordinator. And they had concerns based upon
Also staying as to the substance of issues
okay.
that may have been communicated.
Based on, let me back up. So Kim Griffin is with, which agency did you say, CPT?
Manatee County.
Manatee County. And had she, to your knowledge, been involved in several prior complaints against Doug Benefield, lodged by Ashley Benefield?
There had been 3 complaints in total starting in December of 2019.
Okay. And you were asked to evaluate her, Ashley Benefield, correct?
That's correct.
And were you also asked to evaluate Doug Benefield?
Yes.
Okay. And what was your purpose of, what is your goal here? You're not law enforcement, so what is your goal when you do an evaluation?
Well, sometimes the evaluation might be just parent effectiveness. Sometimes you're assessing for substance abuse. But more often than not, it's an evaluation, psychological evaluation for mental health issues.
Okay. And did you in fact complete evaluations of both parties?
I did, yes.
Okay. Were these extensive evaluations?
As a solo practitioner, I pride myself on being thorough, so I would say yes, they were absolutely extensive.
Okay, so I want to talk about Ashley Benefield for a moment, specifically. In preparation for your evaluation, did you review documents?
Part of any thorough evaluation would be looking at not just collateral contacts, interviewing other people, but collateral data, which would be whatever records are presented pertaining to the case and the family situation.
Okay.
In addition,
go ahead.
I'm sorry. In addition to the fact that I typically will ask the parties, the parents in this case, if they had anything else they wanted to share with me by way of, diaries, journals, photos, videos, whatever they might have. So the more data I have, the more inclusive it can be.
And you said collateral contacts. Do you make those contacts?
Yes.
Okay.
Seems like we're going awfully far afield from what the court ruled.
I'm going to overrule. I mean, I don't think we've gone into things I've ruled not to go into, but.
Okay. As part of your work specifically with Ashley Benefield, did you meet with her?
Yes, I did.
And did you meet with her alone or together?
In conducting these kind of evaluations, is a series of individual interviews. Oh,
is there an objection?
Yeah, she interrupted the witness who was attempting to answer the question.
Okay, overruled. Go ahead and ask your question.
Okay. Did you meet with Ashley by herself?
yes, I did.
Okay. Did you also meet with her with other people?
I did a home site visit. So yes, I saw her and her daughter and her mother, as well as I'd seen her and her mother in my office, and I've seen her with just Emerson. And on a separate occasion, I'd seen her and Doug together, both in terms of conducting the exchange of their daughter at my office, as well as a joint meeting.
Okay. And when you say joint meeting, is that one where they sat with you and did therapy together?
Not therapy, it's an interview for the evaluation.
An interview for the evaluation. Okay. So how many times did you meet with them together? Do you recall?
I believe at least twice where we had a formal meeting, different than when they would exchange Emerson. And the point of the exchange in my office, just to share, is that it's important in the evaluation to oversee and evaluate it, to observe how the child responds, leaving one parent, going to the other parent, how the parent handles the child in the separation, particularly because at that time, Emerson was just under 2.5 years old.
Okay. So she was pretty young, a toddler.
2 years, 4 months.
Okay. During your contacts with Ashley, how did she present when you first met her?
Objection. Beyond the scope of the court's ruling. The court's ruling was that Dr. Breder would be entitled to testify to his observations upon all parties being present. Ashley Benefield, Douglas Benefield, and Emerson.
And I'm sorry, go ahead. You look like you were going to speak. Judge, I don't know that this has anything to do with the court's ruling. This is his evaluations of Ashley, specifically her mannerisms, her speech, what she says is all relevant.
How?
Because it goes to the allegations that were made about the child abuse, then the fact that now someone is evaluating her, now the fact that she is attempting to manipulate the evaluator goes towards the motive of the entire case.
Sustained.
What did Ashley tell you about her relationship with Doug?
Objection. Once again, beyond the scope of the court's ruling.
No, I said defendant statements we didn't get into. We didn't talk about the limits. Defendant statements weren't limited in any way. But with that said, so it's not a violation of the ruling I just made a few minutes ago, but maybe there's other objections that may be relevant or appropriate as we go through. But no, I mean, defendant statements they're allowed to come in under the rules. It's just a matter of whether they're relevant to any particular issues.
Did you speak with Ashley about her plans for the future with or without Doug Benefield?
Yes, that certainly came up in the scope of the overall evaluation.
And what did she say about that?
She made it very clear on more than one occasion that she had no intention of reconciling with Doug, and that she had every intention of relocating to Maryland with her mother and Emerson, particularly because her grandmother had passed away and her mother had inherited that home so she could return to her native home state of Maryland.
And did she indicate to you that she was going to go without Doug? Go to Maryland without Doug?
Again, in several different occasions, she had indicated that was her intention. She did not want him to come along with her. There was some email exchanges indicating that she was trying to make that happen. He had made it clear that he was going to be going there and thought that he'd be moving in with them, which she clearly made clear to me that that was not going to happen.
Okay. So she made clear to you that he is not moving in. We are not getting back together.
Yeah, absolutely.
Did she say those things and act that way during the joint session with Doug?
No.
Okay. How was it different?
It was different in that her presentation of herself was more deferential to Doug because her goal, as she had shared with me, was to, in essence, kind of appease him, go along with him, because she was concerned he might get angry and blow up. So she wanted to just kind of go with the flow, as the expression is, and therefore she was willing to go out to lunch or go to a movie or hang out with him and Emerson. So she was not going to present that ultimate goal, certainly not with me. In those sessions, it didn't come up.
Okay. Did you talk to her about the suspected poisoning in the past? Or did she mention it to you?
That was an issue that came up, yes.
Okay. And did she believe she had been poisoned?
She was suspicious. She admitted that she didn't know for.
Jeff, he's dying. She's calling for an opinion as to the substance of the comments. Did she believe?
Yeah, I mean, to the extent it asked for an opinion, I mean, we're talking about statements. What did she say?
Okay.
What were your observations?
What did she say to you about the poisoning and whether she believed or not that she was poisoned?
She had a very definite concern, a fear that he might have attempted to poison her. She was concerned first with during her pregnancy and felt ill. And then when she delivered the baby, she even stopped, didn't even want to attempt breastfeeding for fear that she had been poisoned. So she had refrained from that and went so far as to ascertain a toxicology report to that effect.
Okay. And did she ultimately admit and say, well, okay, maybe he didn't poison me?
I don't know if she certainly didn't say it that way. No.
How would she have said it?
She said, she explained to me a bunch of physical symptoms she had, and she was worried for Emerson, and she did admit that she did not know if he had poisoned his former wife, Renee, but she had that suspicion, but she could not say conclusively that he had attempted to poison her. No.
Okay. And did she indicate to you that something about, I know you're the professional here, but do you know what I'm talking about?
Yeah, I believe you're referencing towards the end of the evaluative period. She wanted a resolution, and she was very frustrated with the system, CPT, the courts, Judge Morlan, et cetera, because she felt no one was helping Emerson, no one was doing anything. I put in my report that she declared, I'm the expert, and I'm not doing anything, and what's going to happen, she'll have to take matters into her own hands.
Okay. So she indicated to you that she specifically had a problem with the authorities, MSO, CPT, CPI.
That is correct.
Okay. And at some point, did she say to you she needed all this to be done? We're running out of time.
Yes, she did.
Tell me about that. What did she say?
It was during that same interview session where she really wanted to just kind of be able to move on with her life. She was looking forward. She explained to me that her mother had retained the hope of a realtor to sell her home in the Lakewood Ranch area that they were preparing to move. That was her intention. So she just was hoping to relocate, reestablish herself. She shared with me that if she had been able to establish a permanent residence of at least 6 months, that she could then appeal to the authorities, the Child Protective Service authorities in the state of Maryland, in hopes that they would help her.
Okay. And was she frustrated at you because you weren't helping her?
Objection.
To the extent it calls for speculation, if she made words, then that's one thing, but.
Did she ever express frustration or anything that would have led you to believe she was frustrated with you?
Objection. That's what she said. Did she say that?
Yeah, that's how I take it. I mean, hopefully I'm being very clear. We're talking about not speculation or what you think or what you guess or what might have been. We're talking about words that were uttered by that person over there.
Ashley expressed her frustration at the overall situation. To the extent that I was part of that situation, then yes, but she never specifically singled me out.
Okay. And did she indicate to you that Doug was still abusing Emerson? Or that she thought Doug was still abusing Emerson?
Not at that point, because they, at her initiative, had agreed to basically spend time with Emerson together as a family. And so there were no, during the course of my evaluative process, there were no complaints or fears about that, which she attributed to her presence.
Did she discuss with you the past allegations of abuse against Doug?
She explained each one of them, yes.
Okay. And, but she said after that they were living as a family.
Not living, they did not live or stay together. They didn't even have any intimate relations. They would do things like take Emerson to the beach or go to his condominium unit to the pool, or they would go out as a couple for dinner and grandma would watch the baby and things like that.
But Ashley told you she had no intention of being with him.
Unequivocally.
Okay. During the time that you spoke with Ashley, did she ever say that Doug physically harmed her?
Not physically, no.
Okay. Did she ever say that she was afraid of Doug being violent with her?
She explained the gun incident in their kitchen in their South Carolina home, and that was certainly a frightening experience for her.
But did she say that would have been 4 maybe years before, correct? Before you were meeting with her?
I'll sustain.
Was that incident, did it just happen or was it a long time before?
It was well before my involvement.
Okay. Did she complain of any other things, acts of violence or aggression from Doug since then?
What she explained to me about Doug was that she felt that he had a violent temper. They would get into these yelling, screaming matches, and he would punch holes in the wall. Again, that was again in their home in South Carolina.
Okay.
None of that was recent during the time I was involved with them.
Okay. So during the time that you talked with her, she never brought up anything more recent than South Carolina for violence?
If she didn't say it, it's not included in what she did say to him.
Overruled. Go ahead.
Did she give you any examples of Doug's violence, any more recent than South Carolina?
No.
Okay. Did she indicate to you that she was afraid of him while she was talking to you?
You mean in the individual sessions? Or
Yes,
just she and I? She did not present as fearful or worried about that, no.
Okay. When was the last time that you saw them? Do you recall?
Approximately late August. This is 2020.
And when did you do your report?
I believe it was submitted on or about mid-September, I think the 14th of 2020.
Okay. So when a report is submitted, it gets submitted to CPT?
The work product is the property of the child protection team. So that who handles it and anyone else who wants to see it would have to get a court order from the judge.
Okay, so even the people that you're interviewing have to get a court order to get that evaluation?
That is correct.
Okay. Did your sessions with Ashley and Doug together, did you have any concerns for the safety of Ashley or the baby after your sessions?
I did not.
No further questions?
Cross?
Yes, sir. Good evening, Dr. Breder. I'm Neil Taylor. I have a few questions I'd like to ask you.
Certainly. Good evening to you, too.
Only because it's the most recent, so we'll all remember it. And I recognize we're asking you questions that you're trying to answer from memory, which is not the easiest thing given the time that has transpired. But do you recall testifying at a dependency hearing?
Objection is this?
Sustained.
Okay. Are you certain about your statement that Ms. Benefield did not express fear of Douglas Benefield to you in the past and continuing in the summer of 2020?
My notes in my report reflect that she had certainly expressed fear that Doug could not parent Emerson, and she was not comfortable with him having Emerson, like for an overnight, for example. So she wanted to do whatever she could to block that.
All right, may I approach the witness, Your Honor?
Okay.
Let me pass this to you and see if this helps refresh your recollection. Does that help refresh your recollection as to whether or not Ms. Benefield during the summer of 2020 expressed to you that she was afraid of Douglas Benefield?
Yes, based upon the previous experiences in South Carolina.
All right, now the judge has restricted us, as Ms. O'Donnell told you, to things that Ms. Benefield told you. And you've been very candid and helpful, but I want to just ask you a few additional questions. She told you, among other things, did she not, that Doug had he was very angry with a real temper?
She expressed that he would get very angry, yes.
She expressed to you, told you that he was very controlling.
She certainly felt he was controlling, yes.
Yeah. In fact, I believe she said to you that he was highly manipulative.
I don't know if she used those exact words, but she felt that he was controlling, yes.
Right. Let me see if I can refresh your recollection. May I approach him, Your Honor?
Yes.
See, Kelly, don't worry. I think there's another like 5-6 minutes left, and we're signing off as well. So, see you, Kelly.
Brother, see if that refreshes your recollection as to whether or not Ms. Benefield told you that Doug Benefield was highly manipulative in those exact words.
That's my statement, yes.
She told you that he was very intense,
Yes,
that he punched holes in the wall,
that's true.
fired a gun in the ceiling of the kitchen. And she discussed with you her fear that he'd poisoned his first wife and perhaps her as well.
She admitted that she didn't have any proof of that, but she was suspicious that he had poisoned Renee and that she therefore had similar suspicions that he might attempt to get rid of her.
All right. And lastly, I want to ask you, you mentioned, and I think the word that you used was appeasement. This was the strategy that Miss Benefield told you she employed for going along with Douglas Benefield in an effort to protect her child, Emerson, correct?
She felt the best way to protect Emerson was to appease him, yes.
Yes. I believe the way you characterized it was to keep him, Douglas, at bay.
Yes.
Nothing further.
All right.
Thank you, Doctor.
Redirect.
So defense just asked you about Ashley saying she would go along with Doug to protect Emerson, to keep Doug at bay, correct? Did you have any concerns about Doug being with Emerson?
Objection.
The door has been opened, Judge.
You know what? I'm going to allow it. I think the question was asked. Go ahead.
Did you have any concerns about Doug being with Emerson alone?
Well, let's put that in context. When you're doing these kind of evaluations, you have all sorts of hypotheses to start out with. But as part of the evaluation, I have to see parent and child together, both in terms of the separation from one parent to the other, as well as their interaction. After observing him with Emerson, and the first time just happened to be due to scheduling issues at his own apartment, I did not have any concerns at all.
Okay. And did you observe the two of them together?
Yes.
The child and the father?
Yes.
Okay. And was there anything about their interaction that stood out to you?
Emerson had been with her dad in the pool that afternoon prior to my arrival. And when I got there, she had just woken up from a nap. I was a complete stranger to her, and she therefore clung to her father and stayed on his lap and cradled herself. And he was comforting her and soothing her. And I kept my distance as he and I talked. And it was pretty clear that even as she's waking up, she was looking to him for comfort.
Okay. And so Ashley says she's staying with Doug just to protect her daughter. But this is a situation where CPT and law enforcement had all been involved, and it culminates in you. And did you have any concern about Doug being with his daughter?
Again,
I'll sustain. That's been asked and answered.
So Ashley said to you that Doug could be violent or angry, punch a hole in a wall, things that happen in South Carolina, correct?
Yes.
Did she ever say anything to you like, I am so scared he comes after me all the time?
No, she never used that expression or that phrase.
Did she ever say, I was afraid anytime that he was going to hit me?
No, she never expressed that at all.
But yet she's scared because he's so violent. Correct. She said she's scared of him because he has a violent tendency.
Yes, but the context was typically about how can she best protect Emerson and how come I and the rest of the quote unquote system were not doing enough to protect Emerson.
Okay. Thank you. No further questions.
Nothing further.
All right. Can the witness be released?
Yes.
Yes, sir.
All right. Sir, you're released from your subpoena. Thank you very much.
Thank you, Your Honor.
You take your water with you if you want.
Good.
Dare I ask? Oh, well then, you solve that issue. I was going to be the bad guy and say, call the next one. But that was not a possibility.
Right, that's the end of it. There were no more witnesses. The defense did not put any witnesses on in their rebuttal either. So I think you can imagine what happened. It was declined as standing your ground was declined. And it's going to trial. No, that's it, yeah. Let me just see. See you, Rhode Island. See you tomorrow. See you tomorrow, medallion. Right. Let me just check one thing here to see if there's anything. Oh, hang on, no, that one, this one. Oh, that was longer than I thought, people. Right, I don't think there's this actual video in stand ground. Okay, there is. Hang on. Here we go. Let's watch this then. This is what came out of it. And then we're done then. This is only 6 minutes, so you don't have to, or 7 minutes. So this was the verdict of all that.
Now, we brought you the 2-day hearing.
My dad met Ashley 9 months after my mom passed. He told me that they were actually married, not just dating.
So her claim was that while she was pregnant with their daughter, he had poisoned her through heavy metals.
They disproved all of the allegations like every other time, but that started the real problems between Ashley and Doug.
He's saying the neighbor came over, female neighbor. It was a domestic. She shot her husband.
In Florida, the judge has denied defendant Ashley Benefield's stand your ground defense. Now, we brought you the 2-day hearing back in July. Ashley Benefield is accused of murdering her husband, Doug, in 2020. Now, they had separated and were embroiled in a bitter child custody battle. In his ruling, Judge Stephen White says the state has proven by clear and convincing evidence that the victim's homicide was not a singular act of necessary self-defense, but was instead the culmination of a lengthy, concerted effort by the defendant to eliminate the victim from her life and the life of their child. When the defendant's efforts to enlist the assistance of law enforcement, child protective services, and the judicial system failed, she took matters into her own hands. That's the judge, folks. Now, after denying her stand your ground defense, the judge set a tentative trial date for November 29, 2023.
The farthest?
Farthest?
All right. Case management I have right now is November 29th at 9 a.m.
That should be fine. November 29th.
Anyway, there we go. We don't need to go into all that because it's different hearings again. He's not been added yet, I don't believe. So, Florence, I think he's only there for the appeal process, though, as in that specific. I don't think he's joining the team, though, is he? Just for that specific role. I could be wrong. I need to look at the documents. Liz, I know it's been so long coming. 22nd of April it comes in. I forgot how big this was. I forgot this. I forgot a lot about this pre-trial stuff. 9 hours. Freaking no, I should have looked that up, shouldn't I? So tomorrow we plan on doing Morning Club, followed very swiftly then by Alec Baldwin, and that's the plan for the rest of the week then, as we go through it. I think the Black Swan murder trial is going to be very good. I generally do think it's going to be very good. There you go. Yeah, I thought so. So, yeah. I think this could be very, very good. I think it's actually going to be very, very good. I think she's a bit fucked, if I'm being honest. Anyway, I don't remember if the testimony was in there or not. But yeah, she's basically, she admits she did shoot him, but in self-defense. The problem is she shot him in his back. So the allegation is that he was moving away from her quite far away. I don't know. We'll see with the trial. But yeah, so I think it'd be a good trial. So I think we've got a buffer with Alec Baldwin. Then we got the Karen Reid hearing on the 22nd. This starts on the 22nd. We got Karen Reid on the 22nd. My priority always will be Karen Reid. So we're definitely showing that. And whatever we miss with Ashley Benefield on that 22nd, we'll go back and we'll finish it off the rest of the day. So along with the judge as a witness, yeah, I mean, judge is 100% going to be with, well, she should be. And they could call Bev as a witness, which could possibly keep her off a pre-trial if there is one. I hope it keeps her off the whole fucking trial. This could be what they're trying to do, is to keep her away from the whole trial. This could get messy. It could get messy ahead. Anyway, people, right, it's been a long day. 7 hours, 20 minutes. So thank you for your patience. I do promise you this is going to be a really good trial. So thank you for your patience. I hope that, you know, you'll come back and join us, especially tomorrow. Come back and join us tomorrow. We'll have Morning Club again, and we'll go in and watch Alec Baldwin. And I know nothing about Alec Baldwin's trial, so I just know they allegedly shot somebody. So I don't actually know. I presume someone died. I don't know too much about it. See you, Beautifully Inappropriate. Oops. See you, my darling. See you, Tim. See you, Vicky. Right, I'm going to go sign off. Today was marred by the Karen Reid motions. I think everyone disappeared to Melanie Little, and now Peter Tragos is live as well, so go and follow them, have a listen to it, and we'll reconvene tomorrow morning. And with that, everyone, love you all, as always. Well, most of you anyway. Yeah, let me put this. Now, let me get my background. And I'll play my outro, my new outro, 23 seconds. No, wrong one. Here we go. Here it is. Right, everyone. I will love you and leave you. See you, Liz. See you, Sarah. See you, everybody. Bye-bye.